No, I had withdrawn, my lord.
Fresh matters kodi,
Fresh matters.
which can wait till Monday. If there's any urgency, I'll take it. Fresh matter kodi first.
Submission. That's one submission with regarding the fresh.
Wait. Any submission, please wait.
In three connected matter, one matter I have withdrawn.
Any submission, please wait.
Old ಮಾಡಿ.
Memo ಕೊಟ್ಬಿಟ್ಟು ಅವ್ರು ಹೋಗ್ಬಿಡ್ಲಿ. Today we are not in a hurry. I'll hear everybody. Wait. ನೀವು ಇಲ್ಲೇ ಬರ್ತೀರಾ ಅಲ್ಲೇ ಇರ್ತೀರಾ? ಇಲ್ಲೇ ಬಂದ್ಬಿಡ್ಬೋದು. ಎಸ್ ಸರ್ ಹೇಳಿ. ಹಾ ಕೊಡಿ, ಯಾವಾಗ ಬೇಕು? ಹಾ ಎಸ್ ಸರ್. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಹಾ ಫ್ರೈಡೆ ಎಸ್. ವೇಟ್ ಸತೀಶ್ ಏನು 7A ಅದು 11th 12th ಇದೆ ಕೊಡಿ ಎಲ್ಲ 12th ಎಲ್ಲ 12th ಕೊಡಿ. ಅದು ನಿಮ್ಮ ಮುಂಚೆ ಅವರಿದ್ದಾರೆ ಒಂದು. ಎಸ್ ಸರ್. ಸರ್ ಅದು ಬಿಟ್ಟು ಬೇರೆ ಏನಾದ್ರು ಜಲ್ದಿ ಹೇಳಿ ಸರ್. ಅದು ಬಿಟ್ಟು ಹೇಳಿ ಸರ್. ಏನ್ ಫ್ರೆಶ್ ಪೆಂಡಿಂಗಾ? ಅದು ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಮೆರಿಟ್ ಇದೆ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಸರಿ, ತೊಂದರೆ ಇಲ್ಲ, ಬರ್ಲಿ, ಬರುತ್ತದೆ. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಒಂದ್ ನಿಮಿಷ ಏನ್ ಎಂಪರ್ ಆಗ್ತದೆ ಸರ್? ಸ್ಟೇ ಇದೆಯಲ್ಲ, ಎಷ್ಟು ಸೋ ಮೆನಿ ಪೀಪಲ್ ಡೋಂಟ್ ಹ್ಯಾವ್ ಸ್ಟೇ. 2 ವಾರ ಅವ್ರದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆಮೇಲೆ ಟೇಕ್ ಇಟ್, ಯು ಮೂವ್ ಇಟ್. ಎಸ್ 138 230 ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಅದಕ್ಕೆ ಏನಿದೆ? NBW ಇಶ್ಯೂ ಆಗಿದೆಯಾ? ಆಯ್ತು 230 ಕೊಡಿ. ಎಸ್ ಎಸ್ ವಿನೋದ್ ಕುಮಾರ್. Promise of marriage, marry. Mother and brother, they can't obviously marry. Good. Yes, tomorrow. ಯಾವಾಗ ಕೊಡಿ? ಟುಮಾರೋ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? 24 ಕೊಡಿ. ಮಂಡೇ ಅವ್ರಿಗೆ ಆಗಲ್ಲ ವೇಟ್ ಮಾಡಕ್ಕೆ? ಮಂಡೇ ಆದ್ರೆ ಕೊಡಿ. ಮಂಡೇ ಆದ್ರೆ ಎಲ್ಲ ಮಂಡೇ ಮಾಡ್ತೀನಿ. ಮಂಡೇಗೆ ತಗೊಳ್ಳಿ ಇದು. ಏನಾಯ್ತು? ಹೌದು 281 291 2991. ಡೀಲಿಂಗ್ ಮಾಡಿದ್ಯಲ್ಲ? ಡೀಲಿಂಗ್ ಮಾಡಿಲ್ವಾ? ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. ಆ ಥರ ತೊಂದರೆ ಆಗಿದ್ರೆ ಡೋಂಟ್ ವರಿ. ಖಂಡಿತ ಡೀಲಿಂಗ್ ಮಾಡಿ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಬರುತ್ತೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ ಸರ್? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ. 2 ವಾರ ಮೂವ್ ಮಾಡಬೇಡಿ, ಆಮೇಲೆ ಡಿಸ್ಪೋಸಲ್ ಖಂಡಿತ ಮಾಡ್ತೀನಿ. 2 ವಾರ. ಲೆಟ್ ಮಿ ಕನ್ಸಿಡರ್ ಆಲ್ ದಿ ಕೇಸಸ್ ವೇರ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಸ್ ನಾಟ್ ದೇರ್. ಎಸ್ ಇಲ್ವಾ? ಯಾವ ವರ್ಷದ್ದು? ಅದು ನಾಳೆ ಹಾಕಿ ಮಾಡಿ. ನಾಳೆ ಎಲ್ಲ ಮಂಡೇ ಹಾಕಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. You have an interim order, then don't move it. Yes, next. 2 weeks wait, sir. Why are you moving it when there is an interim order? Tell me. Wait for 2 weeks. Yes. Tender and data theft. ಕೊಡಿ. ಕವರ್ಡ್ ಬೈ ಅಂದ್ರೆ ಇಲ್ಲ, ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಅವ ಏನದು? interim order ಇಲ್ವಾ? You have for the respondent. Okay, give it. Yes. ಮೇಡಮ್ ಇವತ್ತು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಸ್ವಲ್ಪ ಹಾಕಕ್ಕೆ ಹೇಳಿ, ನಾನು ಬಂದಿದ್ಯಾ? ಎಸ್ ಸರ್. ಈ ಕಡೆ ಬನ್ನಿ. 22 ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? ಬರುತ್ತೆ ಕೊಡಿ. ಮಂಡೇ ಹಾಕಿ. ವೇಟ್, ಈ ಕಡೆ ಬನ್ನಿ ಎಲ್ಲರೂ.
FIR is registered on 27. These people are a partnership deal. In violation of those clauses, they have approached the arbitration commercial court and arbitration.
Can it wait till Monday?
Okay.
Notice
has been issued and they are the partners. They have been.
When was the FIR registered?
27/6.
Take bail. Take bail, sir. Take bail, sir. ಅದೇ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಬೇಲ್ ತಗೊಳ್ಳಿ. Take bail, sir. I will not, wherever you are converting this court to a bail court, I am not entertaining.
No, not converting into.
Then what is it, sir? ಕ್ವಾಶಿಂಗ್ ಆಮೇಲೆ 4 weeks ಬಿಟ್ಟು ತಗೊಂತೀನಿ ಕ್ವಾಶ್ ಮಾಡಕ್ಕೆ.
41 ಏನು?
So what, sir? Take bail, sir. So what, sir? Take bail. Bail court is right here. Yes.
498 proceedings
Huh?
last ಮೇಲೆ ಸ್ವಾಮಿ ನಾನು 4 ಸರಿ ಮೆಮೋ ಮಾಡಿದ್ದೀನಿ ಡೇಟ್ ಫಿಕ್ಸ್
ಸೋಮವಾರದವರೆಗೂ ವೇಟ್ ಮಾಡ್ಬೋದಾ?
ಯಾಕೆಂದ್ರೆ
ಸೋಮವಾರದವರೆಗೂ ವೇಟ್ ಮಾಡ್ಬೋದಾ? ಸೋಮವಾರ ಬರುತ್ತೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ತರ ಕೊಟ್ಟಿದ್ದೀವಿ
ಓ,
ಸ್ವಾಮಿ.
ಬರುತ್ತೆ ಕೊಡಿ ಸರ್. ಯಾಕೆ?
That's,
ಖಂಡಿತ
ಈ
ಬರುತ್ತೆ
ಕೇಸಲ್ಲಿ
ಮೇಡಮ್. ಅದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
Fresh ಮಾಡು ಸ್ವಾಮಿ.
ಬಂದೇ ಬರುತ್ತೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕೆ specific
ನೆನ್ನೆ
date
ಒಂದ್ ನಿಮಿಷ
ಕೇಳಿದ್ರೆ
ಒಂದ್
ಆ
ನಿಮಿಷ.
court ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಅಂತ ಸ್ವಾಮಿ.
ನೆನ್ನೆ 300 ಕೇಸ್ ಹಾಕ್ಸಿದೀನಿ. ಇನ್ ಎಷ್ಟು ಹಾಕಿಸ್ಲಿ ಹೇಳಿ ನೀವು?
ಅದು ಹೌದು ಸ್ವಾಮಿ.
ಇನ್ನು ಎಷ್ಟು ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ.
ನಿಜ, ಆಯ್ತು.
ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು.
ನೋ ಪ್ರಾಬ್ಲಮ್, ಅದೇ ಮಾಡೋಣ. 300ಗಿಂತ ಎಷ್ಟು ಹಾಕ್ಬೇಕು ಹೇಳಿ? ಯಾವ ಕೋರ್ಟಲ್ಲಾರು ಹೋಗಿ ಬಂದ್ಬಿಡಿ, 300 ಕೇಸ್ ಯಾರು ತಗೊಂಡಿದ್ರೆ ಹೇಳ್ಬಿಡಿ.
Petition ಗೆ ಹೋಗ್ಬೇಕು ಸರ್ ನಾವು.
ಏನಾರು ಇರ್ಲಿ ಸರ್, ಯು ಶುಡ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಿ ಪ್ರೆಷರ್ ಆನ್ ದಿ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಅಲ್ವಾ? ನಿಮ್ದೇ ನೀವು ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಗತ್ತಾ?
Because
ಮತ್ತೆ?
ನನಗೆ 4 ಸರಿ
ಅದಕ್ಕೆ
ಮಾಡಿದೆ ಸ್ವಾಮಿ.
ಸೋಮವಾರ ಬರುತ್ತೆ, ಖಂಡಿತ ಬರುತ್ತೆ.
Your Lordship,
ಸೋಮವಾರ ಯಾವ್ದು ಉಳಿದಿರೋದೆಲ್ಲ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
my lords,
ಅಲ್ಲ, ಇನ್ನೂ ಇದೆಯಂತಲ್ಲ. ಇನ್ನು 30-40 ಪೆಂಡಿಂಗ್ ಇದೆ, ಎಲ್ಲ ಬರುತ್ತೆ ಸೋಮವಾರ.
my lords, this is the.
ವೇಟ್,
Your Lordship,
ಡಿಸೈಡ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ. ಡೋಂಟ್ ಜಾಯಿನ್ ದೇರ್ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ಖಾಲಿ.
Your Lordship, one matter it is of the year 2022, but I am very sorry, there is a stay. But the difficulty is, Your Lordship, now it is affecting my promotion, my lord. What is
ಪ್ರಮೋಷನ್
Yes,
ಏನಾಗಲ್ಲ,
really.
2 weeks ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ.
Lords,
happening?
ಏನೇನು ಆಗಲ್ಲ. ಸರ್ವಿಸ್
No, I cannot take
With-
executive
ನೋ
post, that's
ಪ್ರಾಬ್ಲಮ್.
difficult.
ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ ಎಫೆಕ್ಟ್ ವಿಲ್ ಗೆಟ್ ಎವ್ರಿಥಿಂಗ್.
Yeah, but,
ಎಸ್, ನೋ ಪ್ರಾಬ್ಲಮ್.
lords,
but
ಅದು
there
2
is
weeks
no
wait
debate.
ಮಾಡಿ. From you move all these matters where interim order is there from the week commencing from the 8th. I will take everything.
Please, Your Lordship.
Till then, please don't move where interim order is there.
my lords,
Not there, ಕೊಡಿ ಎಲ್ಲ.
this is
Monday.
a fresh matter, my lords.
Yes, sir, you wanted to make a mention. What is it?
This is a fresh.
ಅವ್ರು
matter
ಹೇಳ್ತಾ ಇದಾರೆ
where,
ತಾನೆ.
uh, Lokayukta has booked charges against the contract driver who is there. So he is being booked for criminal charges. So
Oh.
the matter may be listed for tomorrow since there is urgency. my lords.
What urgency?
He is left with, he's become.
When was he booked, sir?
In the Lokayukta itself. my lords.
When was he booked, sir?
He was booked in 2023, my lords.
Your urgency today, sir?
My lords,
List
they
them
do
on
it
Monday.
in the last-
Monday. All of them on Monday.
Other matters. is there.
Interim order ಇಲ್ವಾ? ಕೊಡಿ. ಕೊಡಿ.
Accused number 1 main case ನಲ್ಲಿ acquit ಆಗಿದ್ದಾರೆ.
ಎಲ್ಲ ಮಂಡೇ ಬರುತ್ತೆ ರಾಘವೇಂದ್ರ.
230 matter, Your Honor.
230 ಯಾಕೆ ಸರ್?
Accused number 1 main case ನಲ್ಲಿ acquit ಆಗಿದ್ದಾರೆ.
ಸೊ 230ಗೆ ಹಾಕ್ಬೇಕು ಅದಕ್ಕೆ?
230.
Monday. Yes.
Your Honor. Monday.
Why? Why? You should know why you are moving the memo for end of the list and then come to the court.
230 matter, Your Honor.
Move and come. Yes.
Your Honor, 230 matter.
Why, sir?
Petitioner is an advocate. Through forgery case ಹಾಕಿ, they are troubling the advocate.
ಕೊಡಿ.
Your Lordship,
230.
maybe at tomorrow, Your Lordship, ಅದು
Much problem.
DV Act file ಮಾಡಿದ್ದಾರೆ. It's against the brother-in-law is in US.
Hmm.
No allegations against him, so
Monday.
the matter is.
TV
day
Act ಅಲ್ಲಿ
after.
ಏನಾಗಲ್ಲ ಸರ್ ಮಂಡೇ.
I'm sorry, madam, date, last week 28ಕ್ಕೆ ಅಂತ ಆಗಿತ್ತು.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ?
ಅಲ್ಲಲ್ಲ, pending 22 disproportionate assets. ತಾವು
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಮಂಡೇ ಬರುತ್ತೆ.
ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಮಂಡೇ ಬರುತ್ತೆ.
ಅಲ್ಲ, ಶುಕ್ರವಾರ ಇದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಮಂಡೇ ಬರುತ್ತೆ. ಡಿಸ್ಪ್ರಪೋರ್ಷನೇಟ್ ಅಸೆಟ್ಸ್
Disproportionate assets.
ಹಾಗಾದ್ರೆ ಫ್ರೈಡೆ ಹಾಕಿದ್ದು ಎಲ್ಲ 28th ಹಾಕಿದೆ. ಯಾವ್ದು ಮೇಡಮ್? 5th ಹಾಕಿದೀವಲ್ಲ ಎಲ್ಲ?
ಅವ್ರದ್ದು ಇದೆ.
5th ಹಾಕಿ. Yes.
Friday.
What is that memo, mister? What same? What same?
The one with.
Disproportionate assets.
ಹೌದು.
All right, yes. Monday ಬರುತ್ತೆ ಕೊಡಿ.
Fresh matter, my lord.
Monday ಎಲ್ಲ ಬರುತ್ತೆ. Fresh matters, please don't worry. Monday, every matter will be listed. Every matter will be listed.
23 matter, my lord.
Interim order ಇಲ್ವಾ?
ಅಲ್ಲ, admission ಆಗಿಲ್ಲ, my lord.
Interim order ಇಲ್ವಾ?
ಇಲ್ಲ, interim order.
Monday ಬರುತ್ತೆ ಕೊಡಿ.
Submission.
This is a,
Monday ಕೊಡಿ ಎಲ್ಲ.
this is a CMP which has been disposed of by this honorable.
Why are you moving it? ಏನಾಗಿದೆ?
We have filed recalling application and a fresh appointment of arbitrator. The
Why?
previous council has not filed claim petition in the arbitration case. So.
ಆಯ್ತು, ಫ್ರೈಡೆ ಕೊಡಿ.
23 matter, man.
But pursuant to orders of this or of the circular, the petitioner has deposited 20% of amount. Not I'm seeking the withdrawal of the amount.
Where has it deposited?
Not before the trial court.
File it there only.
So the order of this or of the circular.
I will see then Friday.
498 AM. In this case, 3 cases.
Matter has been settled, lordships.
ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಬರ್ದು ಯಾವತ್ ಬೇಕು ಕೊಡಿ.
The matter.
My lord, 498 AM.
5-7 in the trial court, my lords. Yesterday, I
Tomorrow.
got the memo, my lord.
Tomorrow.
Three cases has been listed. For one case we had withdrawn. Another two case which is not heard.
Oh, 3 memos from one office.
My lord, 498 AM.
Two case, one case has withdrawn.
Withdrawn.
Another two cases not listed.
Fresh matter ಅದು.
Fresh matter.
Monday.
23rd.
ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಬರಲ್ಲ.
ಅಲ್ಲ 23rd.
ಇಂಟರ್ ಮಾಡ್ರಿ ಇದೆಯಾ?
Intermediate ಇಲ್ಲ.
ಸರಿ.
Not heard.
Yes.
My lord, matter for 230, my lord.
Incorrect address, petitioners filed, the trial court ಅಲ್ಲಿ proceedings stall ಆಗಿದೆ. The final court directed the petitioner to furnish correct address.
ನೀವು ಪೆಟಿಷನರ್ಗ ರೆಸ್ಪಾಂಡೆಂಟ್ಗ?
I am for the respondent ಮೇಲೆ.
ಅದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿ.
This is a
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
Last time intermediate.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
Intermediate extend ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
ಟೇಕ್ ಅಡ್ವಾಂಟೇಜ್.
My lord, matter for
2024.
ಟೇಕ್ ಅಡ್ವಾಂಟೇಜ್.
This is a matter filed on 5/2/2024.
ಈಗ ಯಾವ್ದೋ ಒಂದು ಕೊಟ್ಟನಲ್ಲ ಈಗ. ಇದೇನಿದು?
ಇದು ಬೇರೆ 5/2/2024 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೇ ಕೊಡಿ.
My lord, matter for 230, my lord, 138 proceedings.
ಮೂರ್ ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ.
Don't push 3 by mentioning 1. Unfair practice.
My lords, this also, my lords, Fine.
Mention ಮಾಡಿ when I take it is fine. Don't push 3 along with 1.
Apologize.
Buy one take one free ಅಲ್ಲ.
apologize.
Yes.
My lord, matter 230, my lord, 138 proceedings, warrant is issued, my lord, you,
ತಗೊಳ್ಳಿ.
further, my lord, 498 AM, my lord.
230 ತಗೊಳ್ಳಿ. Yes.
Matter pending matter, my lord. There is no interim matter.
ಎಲ್ಲ ಮಂಡೇಗ್ ಬೇಡ, ಡಿವೈಡ್ ಮಾಡಿ ಮೇಡಮ್.
Fresh matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಏನಾರು ಇದ್ರೆ ಮಂಡೇ ಕೊಟ್ಬಿಡಿ, ವಿಚ್ ಕ್ಯಾನ್ ವೇಟ್ ಟಿಲ್ ಮಂಡೇ. ಪ್ಲೀಸ್ ಡೋಂಟ್ ವೇಟ್ ಹಿಯರ್. Give up all fresh matters which can wait till Monday.
My lords, can I?
Wait. The lady is sitting there. Please take care. What is this? Yes.
22 matter, my lord.
Huh?
2020.
Vacating ಯಾವ ವರ್ಷದ್ದು? What 22 ದಾ? ಮೇಡಮ್ ನಾಳೆ ಹಾಕಿ. Vacating stay. Interlocutory ಹಾಕಿ.
22 matter. A complaint was died.
4th. 4th.
Complaint was died, my lord. Infection.
Complaint dies, complaint it does not become infructuous. Accused dies, yes.
Fire, my lord. I am for respondent in this.
Complainant. ನಿಮಗೆ ಬೇಡವಾ? ಸರಿ.
My lords,
ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ನಾಳೆ ಹಾಕಿ.
memo for withdrawals, my lords.
Thank you, sir.
Five
When do you want
matters.
it?
All the petitioners have been discharged.
ಹಾಕಿ ನೋಡೋಣ.
All the petitioners have been
Withdrawal
discharged, my lord.
ತಗೊಳ್ಳಿ ಮೇಡಮ್.
5 matters, my lord.
ಆಯ್ತು.
Can I make a submission, my lords?
Wait.
My lord, 2023 matters. My lord, interim order is not there.
Give it. Wherever interim orders are not there, push the memos. I'll get them posted on particular dates.
My lords, 2023 matter.
Where interim orders not there, give it.
Sir.
Give it, sir. Give it. ಈ interim order ಇದ್ರೆ ಮಾತ್ರ ಮೂವ್ ಮಾಡಬೇಡಿ, ಬರಲ್ಲ ಅದು.
Settlement, my lord.
ಸೆಟಲ್ಮೆಂಟ್ ಬರ್ಕೊಡಿ ಯಾವತ್ ಬೇಕು ಅಂತ ಸರ್. ಹಾ ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಮಂಡೇ ಆಗುತ್ತಾ? ಹಾ ಕೊಡಿ.
Lordship 1780 of APAC, lordship permission was not.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Fresh.
ಮಂಡೇ ಅಲ್ಲ ಮಂಡೇ. Yes, sir. What do you want to make?
My lords, it's a matter filed on 2/4/2024, my lords.
Beyond that, what do you want to say? Say that. It is
My lord.
filed on that date, it has not come, 10 memos, leave that, fresh
My
or
lords,
pending. What is it?
respondent number 1.
Fresh or pending?
Fresh, my lords.
Give it. Yes.
My lords, this is for pardon, my lords. Application is pending, my lords, filed on 29/9/2023, my lords.
Give it.
Fresh
give it.
matters, my lords, no stay.
Monday, all Monday.
Lordships.
My lordship is criminal petition.
ಒಂದ್ ನಿಮಿಷ ಮದೆ.
Criminal petition for vacating the stay order as proceedings have been stayed.
Give it, madam.
Criminal, and
Wednesday ಹಾಕಿ. ಅದು sorry, Thursday ಹಾಕಿ.
today is serial number 66 in these two is the connected case.
We'll see. Then you make a mention when it is called. Yes, now call the case.
Your lordships,
Any other memo, give it.
one humble submission.
My lords, one
For
submission.
being
Any other memo, please give it.
One
It's
submission.
for being spoken to, my lords.
Why, sir?
Yesterday, this honorable court has quashed the FIR in 78/820 under bar, my lords. But when I informed the charge sheet is already been filed. What is required, I'll.
ಸರಿ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಅದನ್ನು ಆಡ್ ಮಾಡ್ಬೋದು. All further proceedings ಅಂತ ಹಾಕ್ತೀನಿ ಬಿಡಿ, don't worry. Yes.
In this matter, FIR filed in the year 2019, my lord. Till today not filed charge sheet. We are the.
Interim order ಇಲ್ವಾ?
Interim order ಇದೆ.
ಇದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹೆಂಗ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ? What's the submission?
ಅಲ್ಲ, my lord, wait.
2019 ದ
ಹೌದು.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಯಾವ ವರ್ಷದ್ದು?
2020.
24 ಮಂಡೇ ಕೊಡಿ.
Your Honor,
ಇಂಟರ್ ಮಾಡಿದ್ರೆ ಬರಲ್ಲ.
Monday mal.
Interim order ಇದ್ರೆ ಬರಲ್ಲ. ಬರಲ್ಲ.
ಅಲ್ಲ vehicle release.
ವೆಹಿಕಲ್ ರಿಲೀಸ್ ಆದ್ರೆ ಕೊಡಿ. ಎಸ್.
Yes ma'am.
ಅದು ಪೋಸ್ಟ್ ದಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಮೇಡಮ್. ವೆಹಿಕಲ್ ರಿಲೀಸ್ ಅಂತ ಬರೀರಿ, ಅದರಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟು ತಗೊಳ್ಳಿ. ಎಸ್.
The prosecution is based on an order of the commissioner levying penalty and duty, but certified by the sestat and attained finality. So
What
the
is it?
prosecution does not survive, my lords.
Petition does not survive.
It was prosecution, my lords. 482.
Prosecution does not survive or petition does not survive?
Prosecution.
Yes. ಅದು ನಾಳೆ ಫ್ರೈಡೆಗೆ ಹಾಕಿ.
Your Honor.
No adjournments. Don't make a mention. Mention when it is called. ಆಯ್ತು ತೊಗೊಳ್ಳಿ. ಏನು ಜಡ್ಮೆಂಟ್? ಯಾವ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ? ಎದರ್ದು? ಎಸ್ ಎಸ್ ಆಯ್ತು.
Your Honor, the matter is listed today for non-compliance. It's a matter for reporting.
You want me to take it now?
No.
Then what is it?
I request permission for the petitioner to appear by VC, by video conferencing, because he is hospitalized. The complainant will be
You are
present
not
at 2:30.
settlement, is it?
Yes, sir, but it's.
We'll see. Let it be called. Yes, next. You are for the wife? Who are you representing? ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಸುಮ್ಮನೆ ಮೆಮೊ. ಎಸ್, ನೋಡ್ಕೊಂಬನ್ನಿ. ಎಸ್, ಕಾಲ್ ದಿ ಕೇಸಸ್. ಅಲ್ಲಿಷ್ಟು ತಗೊಂಡು 1 minute, list 2 will finish. ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಅಂದ್ರೆ. Council submission,
I appear for the petition, my lord.
second list.
Second is first,
Yes,
serial
sir.
number 1.
Yes, sir.
The officer raised an objection to produce the entire proceedings in trial court.
Overruled Monday. Yes. SPP. What is office objection? Will not overrule, will impose costs on the state. Objections overruled Monday. Yes.
For petitioner in this case, the office objections in this case is the address of the petitioner in the Aadhaar card as compared to the FIR and the charge sheet are differing. However, she is the permanent resident of Rajasthan. So that is the reason there is a difference in the address, Your Honor.
No, that can't be said. What is 138 proceeding alva?
Illa, 482, this is
411 application.
Please.
Sir, yes. Overruled Monday.
Petitioner, my lord. Office objection, my lord, to produce the.
Overruled Monday.
Much.
Objection is production of entire certified copy of the order sheet.
You are not produced?
I have not produced.
When do you produce?
The entire certified copy may be dispensed, my lord.
Why?
Because 138 proceedings, challenge the order of under section 45 of the Evidence Act.
Evidence Act.
Please.
Monday, overruled. Next.
For petition, my lord. Office objection is the petition name that is forthcoming in charge sheet is not as the.
Overruled Monday.
Public.
Deletion of third respondent. A week's time to comply with the office objections. Next.
8.
Entire order sheet is, sir. What is up to date order sheet?
Overruled Monday.
R2 is not necessary party.
Why have you made him a party?
Wrongly I have.
Wrongly made.
Yes, my lord.
Rightly you delete it now.
Yes, I will.
Yes.
Permission may be granted.
Learned counsel for the petitioner seeks leave of this court to delete the second respondent from the array of parties, as according to him, he is not a necessary party.
Please. Thank you.
ಮೆಮೊ ಹಾಕಿ ಒಂದು
ಆಯ್ತು.
ಭುಜಬಲ್ ಏನವ್ರೆ
ಆಯ್ತು.
ಒಂದು ಮೆಮೊ ಹಾಕಿ. List on Monday.
10.
I have submitted entire charge sheet, my lord.
Overruled Monday.
11 is, my lord. Fatima and Noor Fatima, both are one and same.
Fatima, Noor Fatima.
I
How
have,
can they be same?
I have submitted the records also, my lord.
Yes. Overruled Monday.
12.
ಕೊಡಿ ಯಾರಿಲ್ಲ. a week's time to comply with the office objections. Next.
13.
Overruled Monday.
14.
Next. Monday.
15.
Maintainability, why?
The second petition of
Where is, what happened to the first petition?
withdrawn.
Already withdrawn?
Withdrawn.
Office objections, maintainability stands overruled. Post the matter on Monday in the fresh matters list. Next.
16.
I'm for petition. 311 application ಹಾಕಿಲ್ಲ objection ಹಾಕಿಲ್ಲ. ನಾಳೆಗಿದೆ 311
Could not secure the objection for officers. This is not correct. Our objection ಇಲ್ಲದೆ ನಾವು stay ಕೊಡಕ್ಕಾಗತ್ತಾ? ಇದು ತಪ್ಪು. Secure it and get it. List the 10 days time is granted to do the needful. In the event needful is done prior to the said date, the registry to post the matter immediately on the next day in the fresh matters list without a memo from the court.
ನಾಳೆಗಿದೆ 313 statement.
ನಾಳೆಗಿದೆಯಾ? ಏನ್ ಮಾಡಕ್ಕ? 313 statement ಅಲ್ಲಿ ಇದೆಯಾ? ಹಾಗಾದ್ರೆ ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ. Anyway, yes.
17.
For the petition, charge sheet have produced, my lord. Entire charge sheet has been produced, even though it has been raised.
Monday.
18.
Ready to compromise.
Ready to compromise.
Ready to, although it is non.
Offense ಏನು sir?
395. Since
376
395 some.
390.
15 to 21.
ಆಯ್ತು ಈಗ ಏನ್ ಮಾಡೋಣ ಹೇಳಿ?
Friday
ಆಯ್ತು.
compromise. I will keep him present.
ಆಯ್ತು. Learned counsel, the petitioner submits talks of settlement between the parties have been fruitful. List this matter on Friday at 2:30 PM to report.
Please, sir.
settlement. Yes, next.
19.
Lord, for petitioners, Lord, respondent number 2 is only a formal party. I'm filing a memo to delete the respondent number 2.
Kavya, ಅದ್ ಮಾಡ್ತೀನಿ. Memo for deletion.
Lord, there are two other office objections, my lord. One is regarding the correct address of petitioner. My lord, she stays in the same address.
Overruled
where-
Monday, except memo on deletion, overruled Monday. Next.
20.
ಕೊಡಿ ಮಾಡಿ. Overruled Monday.
21.
Entire charge sheet filed, madam.
Entire charge sheet?
Filed by law.
Counsel submits office objections have been complied with, office to verify. In the event they are complied, list the matter on Monday in the fresh matters list without a memo before the court. Yes.
22.
Manjunath. Sir, ಕೊಡಿ. Week's time to comply with the office objections. Next.
23.
Wakalat has not been executed before embassy. Wakalat has been executed before the notary in.
ಇದು ಯಾವ್ದು allow ಮಾಡಿದ್ವಲ್ಲ ಮೊನ್ನೆ?
Yes, madam.
Identical matters are allowed?
Yes, your lordship has only one, but it is not released. Your lordship has
Number.
criminal petition 3034 of 2000. Last week again. 25.
The special CC 95 of 2004.
Same. Yeah. These matters along with the others also. Yeah.
ಅದೇ ತಾನೆ special CC
ಹೌದು,
of 2004.
Also. 23, 24, 25, 26 serial numbers, same.
ಆಯ್ತು. We will dispose it. Yes. same.
31, 33, 37 and 39. There are 8 matters.
ಇದರಲ್ಲೇ ಇದೆಯಾ?
ಹೌದು.
ಆಯ್ತು.
ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 8 matters.
ಆಯ್ತು. Disposed.
Yes.
Yes. Next.
24 also.
ಆಯ್ತು. ಅದು ಯಾವ್ಯಾವ್ದು ಇಟ್ಕೊಳ್ಳಿ ಮಾಡಿ.
27.
Split charge sheet ಅಲ್ವಾ? Split charge sheet. Split charge sheet ಏನ್ ಮಾಡಿ? ಹಾ. BS Prasad, correct. ಅವನು BS Prasad ಬಂದು ಹೇಳಿದ್ದು. Yes,
But
yes.
in this
all
case,
right.
my last date hearing, I have produced online downloaded copy.
27
What date
now?
in the, yes, madam.
ಪರಲ್ಲ.
Yes, my lord. I have produced online downloaded copy. Only one day, last date of hearing, I have produced online downloaded copy. In our
Overruled
state.
Monday. Yes.
Same, 28 also same. my lord.
Same. 29.
Petitioners are.
One minute, sir. ಅದರಲ್ಲಿ BS Prasad. notice also, permitted to file local.
Office objection is with regard to objection that the petitioners 2 to 4.
2 to 4?
They are residents of Mysore now. Adra Aadhaar card alli different agide anta ಹೇಳ್ತಾರೆ. They are residents of Mysore, my lords, along with their son they are staying. 498 proofs.
Overruled Monday.
Much of it.
Overruled Monday. ಅದೇ ಪ್ರಿಂಟ್ ಸೇಮ್ ಸೇಮ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ. ರಾಮ್ ಸಿಂಗ್ ಇಲ್ಲ ಇದ್ರಲ್ಲ ಕೊಡಿ. Overruled Monday.
33.
Same.
34.
Overruled Monday ಹಾಕಿ ಅದು Axis Bank. Where is she?
She's engaged now.
Yes.
35.
Lords, it is an appeal against acquittal, my lords. Lords, during the pendency of the appeal, the parties are compromised, my lords. Therefore, my lords,
Office objection square maintainability stands overruled. List the matter on Tuesday ಹಾಕೋಣ.
lords, another matter has to be listed along with this, my lords.
ಎಲ್ಲ ಕಾಂಪ್ರಮೈಸ್
Both are compromised.
ಕೊಡಿ.
Avenging it of both the same parties.
ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಬರ್ಕೊಡಿ. Yes. Tuesday ಹಾಕಿ.
36.
I have produced the entire charge sheet, my lord.
Overruled Monday.
37.
Same.
38.
But in this case, my lord, last one date, I have produced online download copy, entire certified copy. I have produced.
39.
Same.
40.
Order sheet, my lord, manuscript portion, my lord, the office is asking for type copy.
Okay, we are not relying on that.
No, I'm not relying.
If you rely one word of it, I will dismiss the petition. Yes. Overruled Monday.
Objection is that.
Yes, Tahir, what is this?
Well, the complainant was not made a party. For that reason, the office has.
Complainant party beke ಬೇಕು.
Actually, we are not seeking quashing. While seeking a bail order, while granting a bail order, that the session court has imposed a condition for bank guarantee. We challenge that order subsequently under
Bank
413 and
guarantee.
1B.
Overruled Monday.
Yes.
Yes.
42.
ಏನಿದೆ ಮೇಡಮ್? ಕಂಡೋನಬಲ್ 42 ಕೊಟ್ಟಿದ್ದೀರಾ? ಇದನ್ನ 42 ನನಗೆ. ಆಯ್ತು. ಕೊಡಿ. Overruled Monday.
43.
The last date of the proceedings, I produce a true copy of the extract from the eco.
This is what you have been moving.
Please, my lords.
And it's still in office objections.
Summons is returnable.
Did you
to
make
the
hue and cry when there is still in office objections?
My lords, there's only one.
Whatever it is,
minor office
objection is objection. And you
Summons.
not listing.
ಇವತ್ತಿಗೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸರ್.
ಏನಾರು ಇರಲಿ. ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿರ್ಬೇಕಲ್ವಾ? You should also be correct on your side. We can
I
also
complied with all the
tackle the registry then.
My lord, there's a IA for interim stay, my lords.
Not today, sir. Why? In urgency?
See, the summons returnable today. So the matter is being heard today in the trial court.
Where? Let it be.
Sakleshpuradalli. And the matter,
ಎಲ್ಲಾದ್ರೂ ಇರ್ಲಿ sir. So what?
my lords, the procedure adopted by the learned magistrate is pregnant with
Overruled
legal
tomorrow in
information.
the fresh matters.
Please, my lords, please.
Next.
54.
My lords, I appear for the petitioner, my lords, in this case. My lords,
Overruled.
my lords, in
Monday.
this case,
Monday, sir. Yes.
much obliged, my lords.
45. Why is senior counsel there?
This is
45.
two matters along with serial number.
ಇವತ್ತಿದೆ ಗೊತ್ತು.
All of them are
We'll
connected,
take it. Yes.
please.
These two matters,
List two nalli,
ಅಲ್ಲಲ್ಲ ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿರೋ ಎರಡು ಮ್ಯಾಟ್ರು
that list one nalli.
List one,
31.
list one, 31.
Please, Your Lord.
28/5/24 is the FIR.
Please.
You will have to convince me. Yes.
47,
ಎಷ್ಟಿದೆ ಮೇಡಮ್? You 75 ಕೊಡಿ. ಆಯ್ತು, ಸರಿ. ಮಂಡೇ, ಓವರ್ ರೂಲ್ ಮಂಡೇ.
48,
ಮಂಡೇ ಏನು ಕಮ್ಮಿ ಇದೆಯಲ್ಲ ಮೇಡಮ್? ರೆಸ್ಟ್ಮೆಂಟ್ ಮಂಡೇ ಕಮ್ಮಿ ಇದೆಯಲ್ಲ? ಜಾಸ್ತಿ ಏನಿಲ್ಲ, ಎಲ್ಲ ಹೋಗಿದೆ, ಅದಕ್ಕೆ ಹಾಕಲ್ಲ. ಎಸ್.
Serial number 48, production of managerial portion of the order sheet.
40?
Type to 40. I'm not relying upon that.
ಮಂಡೇ.
What's up?
49,
Petitioner, my lord, office objection is production of entire order sheet, my lord, whereas I am challenging the investigation, it's still in investigation, my lord.
ಮಂಡೇ.
Overruled.
ಓವರ್ ರೂಲ್ ಸರ್.
Please.
50,
ಮಂಡೇ.
51,
Crime stage order sheet now not filled.
Huh?
Crime stage order sheet file ಮಾಡಿದ್ವಿ.
ಪ್ರೈಮ್ ಸ್ಟೇಜ್ ಆರ್ಡರ್ ಶೀಟ್. ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
ಆರ್ಡರ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದೆ ಸರ್.
ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಏನು ಆರ್ಡರ್ ಶೀಟ್ ಇರುತ್ತೆ? ಎಸ್, ಓವರ್ ರೂಲ್ ಮಂಡೇ. ನೆಕ್ಸ್ಟ್.
52,
The petitioner, well, there are two objections. One is we have filed an IA for release of properties. Other one is the address, there is a mismatch in the Aadhaar card and where they are residing right now. The petitioner currently they are living in rented property.
For that, what is the proof?
No, we have,
Submission. Monday.
well, there is a IA for stay here.
Monday.
ಅಲ್ಲ, one submission. ಇದು ರಮ್ಮಿ ಇದನ್ನ ಪೊಲೀಸ್ನವ್ರು ಬಂದ್ಬಿಟ್ಟು
ರಮ್ಮಿ.
This is there's a company which runs Rummy. Everything is recorded. The Honorable Court was pleased to pass an order similarly recently where a stay was granted. Either we have all proof the police came on their own when the establishment was closed, claiming that we are running a business which is against the law.
All right.
So now the police have taken away all our material and locked it, and they are saying in this case we also filed a writ petition, and we also filed a contempt petition which is pending with the Honorable Court because the police have been harassing us repeatedly. Kindly, a stay on investigation will be granted because we have
Overruled tomorrow in the fresh matters list. Look into it, madam.
there might be a violation of some condition.
No, whatever it is, license violation, you have no business to ask. If there is any violation of law, then yes, license is between them, trade license between BBMP and them, whatever. ಬೇರೆ ಏನೋ ರಮ್ಮಿ ಆಡ್ಬೇಕಾದ್ರೆ gambling or whatever you 7980 you want to bring in under that, you tell. Otherwise, no harassment. Tomorrow you seek instructions in this and come. Yes. Copy ಕೊಟ್ಬಿಡಿ ಒಂದು.
Yes.
53,
ಆರ್ಡರ್ ಶೀಟ್, ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ objections ಇದೆ.
ಮಾಡಿ.
ಲಾಸ್ಟ್ ಟು
Overruled Monday. Yes.
54,
Overruled Monday.
55,
One date order sheet is missing.
Monday. Overruled. Yes.
66,
56. P95. ಏನು ಮಾಡಿ 10 days time to comply with the office objections. Next.
57,
Maintainability, why?
My lord, we had by mistake filed writ petition instead of criminal. So we're seeking, we'll file a memo for conversion, my lord.
No conversion, file a fresh petition.
With liberty to
Yes.
file. Much
Petitioner seeks leave of the court to withdraw the petition and file a fresh petition on the same cause of action appropriately. Yes. Liberty so sought is granted.
58,
Disposed as withdrawn. Next. Food safety and standard. Overruled Monday.
59,
ಎಲ್ಲ ಆಗಿದೆ ಮೇಡಮ್, ಇನ್ನೂ ಇದೆ ಇವು. Original complainant is a necessary party. 10 days time is granted to comply with the office objections. Next.
60,
Same order.
61,
VB Shivkumar. Overruled Monday.
62,
Complainant is a necessary party. Same 10 days time. Next.
3,
Same complainant is a necessary party.
64,
Same
65,
Office objection with regard to filing of entire charge sheet.
ಯಾವ್ದು?
65.
Overruled Monday.
My lord, 65, my lords, I am for the impleading applicant. My name is not.
Impleading
shown.
application.
Yes, my lord. I am the victim in this case, my lords.
You are not a party here?
No, my lords.
No,
Why?
because the-
Apparently, the sub-register has filed a complaint with regard to fake katas, my lords. The fake kata belongs to my property, my lords.
We'll see. List on Friday in the fresh matters.
Gratefully.
Yes. 66.
Yes. Name may be shown in 65 minutes.
So and so submits that he has filed an impleading previous matter, madam, 65. Impleading application registered to print the name of so and so as appearing for the impleading applicant. Next.
56,
ಅದ್ ನಾಳೆಗೆ ಏನ್ ತೋರ್ಸಿರಲ್ಲ?
Yes.
ನಾಳೆಗೆ ಇರಲ್ಲ ಅದು. By the
Friday.
time it gets uploaded, you may not be, but come.
Accused number 1 was made as a party respondent.
Friday, sorry. Friday.
Which it may be kindly be connected matter is their criminal petition 8149. May be posted along with it.
Tag this petition along with criminal petition 8148,
8149.
8149 of 2023. List them both on Tuesday in the fresh matters list. Office objections overruled. Next.
67,
Office objection is to produce the original photographs, my lord. You have taken the photos by mobile and it is printed there.
Overruled Monday.
Because of the
Fresh
reason-
matter ಇದು?
Day after, fresh matter, day after tomorrow, man, because the petitioner is a space citizen.
Monday.
Day after tomorrow.
Why, sir?
Because they each and every day they are calling, they give the statement, you already given the statement, in spite of it, they are giving trouble to us. Day after tomorrow.
Friday.
Achha.
Yes.
67, sorry, 68,
ನಾಳೆ ಬೆಂಚ್ ಇದೆ ಮೇಡಮ್. ನಾಳೆ ಬೆಂಚ್ ಇದೆಯಾ?
68 and 70 are together, your lord.
We will hear them together on Monday. Fresh matters ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ Monday.
10th,
ಏನ್ 155 to
yeah, 10th, your lord.
10th? ಆಯ್ತು. List office objections overruled. List them both 68 and 70. List them both in the fresh matters list on Wednesday.
69,
Next Wednesday. 10th.
69, blood, page number 36, column number 17 is clear. Legible copy of FIR
Overruled-
registered.
Overruled Monday. Yes.
Oblige me.
71,
For the petitioners, my lord. There's one of the options that the PCR number is not mentioned in the order sheet, my lords.
Mention. Order sheet.
PCR complaint.
Overruled Monday.
Lords, before the trial court, it's on 9th for charge, my lords.
Monday is 8th, sir. Before 9th. Yes.
72,
P. Prasanna Kumar. Yes, madam.
Lordship, there are 3 office objections.
Ah.
One of the office objection is the charge sheet is not legible copy, my lord. That may kindly be overruled and court fee has to be paid.
That you have to.
I'll pay it during the course of the day.
Learned counsel submits that the court fee will be paid in the course of the day. Rest of the office objections are overruled. If they are complied with, list the matter on Monday in the fresh matters list. Yes, Mahesh.
That's
53,
The charge sheet is complete, my lords, but they've raised an objection saying charge sheet is not complete.
Overruled Monday. Yes.
74.
Office objection is, my lord.
4 weeks time to comply with the office objections.
No, my lord. Office objection is, my lord.
Ah.
I have not produced entire charge sheet documents, my lord.
Overruled Monday.
Please.
Yes.
55.
Yes, madam. Prasanna Kumar.
For the petitioner.
ಇಲ್ಲ ಇದ್ದೀರಾ? Photographs are produced reference purpose.
Page number 45, my lords.
Color photographs ಬೇಕಾ registryಗೆ? Overruled Monday. Yes.
Slides. My lords, if I make a small submission, my lords, I deeply apologize. I was held up in chief court. My colleague took sick. Serial number 42, my lords.
In the second list.
In the second list.
What happens?
There are just two objections, my lords. The petitioner's address does not tally with the FIR. Overruled, my lords. Grateful, my lords.
This one, fresh matter, still number 1.
Also, I appear for respondent number 2, my lords. Also, in this matter, I may have to file a counter, my lords, for AFO vacating stay.
There is absolutely no reason.
No, I know that. He wants, last two occasions you were not present. That is why I posted it today. The learned counsel, Joshua Samuel, seeks 2 weeks time?
Yes, madam.
2 weeks time to file statement of objections. The matters of the year 2022, therefore finally 2 weeks time is granted to file statement of objections, comma, if any. List the matter on 18th. Interim order subsisting shall continue till the next date of hearing.
Number 2.
For petition, my lord, the entire allegation is against accused number 1. My lord,
Yes, Harish. You are accused number 2.
accused number 2 and 4, my lord. In respect of accused number 4, he comes into picture after the commission of alleged act.
Yes.
353, my lord. Page number 147, my lord.
130?
147. ಎಲ್ಲ ಸೇರ್ಕೊಂಡು ಅಪಾಯವನ್ನು ಅರಿತು ಲಾಸ್ಟ್ ಒಂದು 4-5 ಲೈನ್ಸ್ ಮೇಲೆ ಒಂದು ಸುತ್ತು ಗುಂಡು ಹಾರಿಸಿ ಆರೋಪಿತರು ಬಂದಿರುವ ಕಾರನ್ನು ಮುಂದೆ ಚಲಿಸಿಕೊಂಡು ಹೋಗದಂತೆ ಕಾರಿನ ಚಕ್ರಕ್ಕೆ ಒಂದು ಸುತ್ತು ಗುಂಡನ್ನು ಹಾರಿಸಿದಾಗ ಆರೋಪಿತರ ಸಹಚರರಾದ ಆರೋಪಿ 4ನೆಯವರು ಆರೋಪಿ 5, 6 ಮತ್ತು 7ನೆಯವರಿಗೆ ಒಂದು
ಸಾಕ್ ನೋಡಿದ್ದೀನಿ.
My lord,
File discharge.
my lord, one submission, my lord. The allegation, my lord.
ಇದನ್ನ ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಅಂತ ಮೂವ್ ಮಾಡ್ತಿರೋದ? ಕೊಡೋ ಕೇಸೇ ಅಲ್ಲ ಇದು.
No, my lord, entire allegation is against accused number 1. My lord, the allegation is against accused number 2 is that, my lord, he was accompanied by accused number 1. My lord, accused number 1 takes out the sword and swings it against the police official. My lord, that is the allegation against accused number 1.
Sir, 1, 2 and 3 ಕಾರಿನಿಂದ ಇಳಿದು ಬಂದು ಆರೋಪಿ ಠಾಣ ಸೋಣಿಸೋ ಇವರಿಗೆ ತಲ್ವಾರನ್ನು ಬೀಸಿ ಕೊಲೆಗೆ ಪ್ರಯತ್ನಿಸಿದ.
That is by accused number 1.
No, sir. 1, 2 and 3.
My lord, in the complaint, my lord,
Complaint act, charge sheet ಹೋಗಿ.
my lord, he specifically describes the act of accused number 1.
No.
My lord, insofar as
You
accused
want,
number
I
4.
will answer on merits, no problem.
No, my lord, I will try to persuade, my lord. My lord, the entire episode, my lord, narrated by the prosecution is this, my lord. My lord,
And
I
this is 307 ಇದೆ.
307, please, my lord. My lord, in a Maruti Ritz car, my lord, they allege that I was carrying 6 cattle
Yes, sir.
along with 3 accused persons in a Maruti Ritz
ಬರೀ
car.
cattle carrying ಇದ್ರೆ I would have definitely stayed it. That's not the issue.
My lord,
You have done something more when you were intercepted.
my lord, after that, my lord, what incident takes place is important, my lord. My lord, they allege that I was carrying, the accused number 1 was carrying 6 cattle and 3 accused persons in a Maruti Ritz car. My lord, it cannot accompany more than 4 persons. And apart from that, my lord, after police stops me, the accused number 1 comes out of the car and swings the sword against
One minute.
It's a Maruti Ritz car.
ಯಾವ ಜಾನುವಾರುಗಳು?
6 cattle, my lord, 6 cows.
ಕೌಸಾ?
ಹೌದು.
ಆ?
ಹೌದು.
6 cows in a Maruti
6
Ritz car.
ಕೌಸು?
ಫುಲ್
ಅಲ್ಲ, ಒಂದ್ ಕೌ ರಿಡ್ಸ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ ನೋಡೋಣ.
ಸಾಧಾರಣ ಹಾಗೆ ಹಾಕಿಲ್ಲ ಅಂತೆ, ಎಲ್ಲ ಕಟ್ಟಿ ಪ್ಯಾಕ್ ಮಾಡಿ ಹಾಕಿದ್ರು.
ಹೆಂಗ್ ಕಟ್ಟಿ ಪ್ಯಾಕ್ ಮಾಡಿದ್ದಾರೆ? ಅಲ್ಲ, ಮಾರುತಿ ರಿಡ್ಸ್ ಕಾರ್ ಗೊತ್ತು ತಾನೆ?
ಹೌದು.
ಸ್ಟೇಷನ್ ವ್ಯಾಗನ್ ಅಲ್ಲ ಅದು.
ಅಂತ ಹೇಳಿದ.
ಅಲ್ಲ 6 ಜಾನುವಾರುಗಳು. ಜಾನುವಾರಿದಲ್ಲಿ ಕೌ ಸ್ಲಾಟರ್ ನೀವು ಬುಕ್ ಮಾಡಿದ್ದೀರಾ ಬೇರೆ, ಆಬ್ವಿಯಸ್ಲಿ ಯು ವಿಲ್ ನಾಟ್ ಬಿ ಕ್ಯಾರಿಯಿಂಗ್ ಸಮಥಿಂಗ್ ಎಲ್ಸ್. 6 cattle inside Ritz car. Is it even possible? ಅಲ್ಲ ನೀವು ಚಾರ್ಜ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಬೇಕು. ನಿಮಗೆ ಬೈದ್ರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಏನೇನೋ ಮಾಡ್ಬಿಟ್ರು.
ಅಲ್ಲ, apart from that, my lord, they have shown the talwar.
ತಲ್ವಾರ್ ಸರಿ, ಈಗ ಫಸ್ಟ್ ಬೇಸಿಕ್ ಫೌಂಡೇಶನ್ ತಪ್ಪಾಗ್ಬಿಟ್ರೆ ಹೆಂಗೆ? Rids ಅಲ್ಲಿ our cows cannot get into Rids at all. So if you don't believe this, how can you believe talwar?
I'll take instructions.
And apart from that, my lord, the police inspector shots 2 rounds of fire in the air and the car, tire of the car. After that, accused number 4 comes into the place. And my lord, he never shoots the car of the accused number 4. He escapes the.
ಪರಾರಿಯಾಗಿದ್ದಾರೆ ಅಂತ ಇಲ್ಲಿದೆ.
Please, my lord.
Accused number 4 ಗೆ.
Accused number 4.
But the very fact of carrying, you should seek instructions, sir.
ಹಿಂಸಾತ್ಮಕವಾಗಿ ತುಂಬಿಸಿಕೊಂಡು ಅಂತ
ಅಲ್ಲಿ ಹಿಂಸಾತ್ಮಕವಾಗಿ ಎಷ್ಟು ತುಂಬಿಸಿದ್ರು 6 cattle inside Ritz that doesn't have a boot also.
I'll take it.
ಇಲ್ಲ ಬೇರೆ ಕಾರಣ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ನೀವಲ್ಲಿ. You're right. Yes. The petitioner is before, petitioners are accused 1, 2 and 4 are before this court calling in question proceedings in so and so. The learned counsel for the petitioner takes this court through the summary of the charge sheet to demonstrate that the entire case is shrouded with improbability. Improbability is for the reason that the petitioner, the accused are alleged of carrying 6 cattle in a Maruti Ritz car, which in the considered view of the court would not even be, does not have a space even to carry 1 cattle, let alone 6 cattle. Till the learned HCGP would secure instructions and make submissions with regard to how the cattle were being, 6 cattle were being carried in a Maruti Ritz car, which is admittedly a hatchback, by the next date of hearing. Till such time further proceeding before the concerned court, where the petitioner shall remain stayed.
Grateful.
3.
Yeah, for the petitioner in this case, my lord. Petitioner is accused number 2, challenging the CC proceedings for offence punishable under section 420 and 66 of the IT Act. At the first instance, my lord, the director of KEA receives an information for the case at Karnataka state eligibility test. Some person, being the accused number 1, had circulated on WhatsApp certain questions which were found placed in the question paper. At the first instance, the petitioner herein is not made an accused in the FIR. Now, subsequently, my lord, after investigation, petitioner herein, who was the then PhD guide of the accused number 1, is made the accused on the ground that he was one of the persons who was involved in setting of the question paper that was determined by the case at committee, and that by negligence he had left his book, the book containing several questions.
Not by negligence, by design. By design, why did you take all the things home when it was not permissible to be taken? That's the allegation against you.
Please, my lord. However, even if that was the case, my lord, there were 3 sets of questions that were made, 3 sets of 125 questions that were made for 3 that were being 375 in number. Why this question paper was set, the petitioner has no knowledge. That they do not disclose. There was not even any foreseeability of what questions would come or not come in the paper. More than anything else, my lord, there was nothing for this petitioner to gain out of this entire process.
That's a different. Yes. What do you gain is a different thing. These examination malpractices should stop, and its period it should stop. Come to page 75.
Please,
What is
my lord.
against you is at paragraph 2 there, and at the last paragraph at page 76.
Yes, my lord.
Yes.
ಆರೋಪಿಯಿಂದ ತನ್ನ ಮನೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದು.
Why? ಮನೆಗೆ ಯಾಕೆ ತಗೊಂಡೋಗಿ ಆನ್ಸರ್ ಪೇಪರ್ ಕೀ ಆನ್ಸರ್ಸ್ ಇಟ್ಕೊಂಡ್ರಿ?
My lord,
Why?
this was a
ಇಲ್ಲಿ ಬಂದು ಸೆಂಟ್ರಲ್ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು ಮನೇಲಲ್ಲ.
My lord, this was a question paper booklet that he had of 1,500 questions which he had gathered over the years of his practice as a professor, my lord. Now, at the end, when he has entered the, for the 6 days when the committee sat, when he's entered the committee and he's left, he's been scrutinized. Even these documents are marked. They say not to carry any books. However, they permitted him themselves. If that were the case, my lord, something must have come forward in the DE.
That's all right. We will haul that person also who permitted you to carry the book. But why did you carry these key answers, question papers, all to your house when everything had to be done in the center?
My lord, I do concede that this is
Then-
wrong. However, this is only negligent, not an intentional act, my lord. In fact, even his suspension was quashed by this honorable court. And even then it's noted that the DE was not comment. My lord, in page 4, para 4, therefore admitted by the university itself through though an order of suspension was passed.
This is
no
reversed by the
inquiry-
division bench. This is reversed by the division bench.
I'll-
Yes.
My lord. My lord, another point, my lord, is these examination results were neither revoked nor weakened. The same results were published and the same was also carried out, my lord. They did not change the results. If they truly found something of a malpractice of nature, then the examination result ought to have been challenged or
Where is N.K. Ramesh? Complainant avare alva? Yes, sir.
Number 1, my lord.
You're ready?
ಇಲ್ಲ full ಆಗಿದೆ. It's not served.
ಯಾವ ಮ್ಯಾಟ್ರು ಅಂತ ಗೊತ್ತಾ?
ಗೊತ್ತು but my lord, charge sheet is not served, my lord.
Charge sheet is not served. Charge sheet is filed?
Charge sheet copy is there.
Serve a copy on the
Please.
council also. Court ಕೊಟ್ಟಿಲ್ವಾ?
no, my lord, I had served the body, I have annexed the body of the charge sheet.
Look into it.
Please.
I'll take it on Tuesday next.
Please.
My lord, I have this difficulty, any date after 17th, my lord.
All right. List the matter on 18th.
18th.
Please.
Grateful, my lord. My lord, if I may be permitted to submit.
Add kodi. Take it on record. Yes.
Grateful, my lord.
Counsel for the petitioner files the entire charge sheet, the same is taken on record. And
Please.
ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತೆ ಬಂದೆ.
Please.
The learned counsel for the petitioner serves a set of the charge sheet papers upon the counsel for the second respondent and files it before the
My
court.
lord, if
Same
I
is
may be
taken on record.
permitted to tender a synopsis also, I have
Yeah, give it.
given their copies.
Give everything. Yes. Yes.
Grateful.
Hmm.
420 read with 34 of IPC, my lord.
Hmm?
420 read with 34 of IPC, accused.
Spurious gold
Please,
pledged
my
to the bank.
Please.
Yes, sir.
Petitioner is the accused number 2 in this matter. The only allegation against him, my lord, he has phone called the bank manager and instructed to grant
Loan.
gold loan to accused number 1. This is the allegation, my lord. And
HCGP ಅವರೇ ಇವರೇನೋ spurious gold ಕೊಟ್ರು. How did the bank take it? If there is no connivance with him and the bank manager who has taken it, how can a spurious gold get into the bank and loan be granted against them? They have a goldsmith sitting there to see whether it is spurious or not. How did he take it?
Sometimes, my lord, while receiving the gold, my lord, they will not check. After that only.
That is the folly on their side. ಇವರು ವಾಪಸ್ ಕೊಡ್ಬೇಕು. See, what happens in such cases, these people will tell, we gave original gold. While giving back, bank has given spurious gold. That does not happen at all. It is assessed at the time when gold is deposited. If it is assessed, then how do you now allege that it is spurious? Anyway, learned counsel for the petitioner submits that he is accused number 2 and is alleged of making a phone call to the branch manager, accused number 1 adu.
accused number 1, yes.
Accused number 1
Accused
to
two, my lord.
your 2. Phone call to branch manager who is accused number 1.
No, my lord, sorry. Branch manager is not made as a accused, my lord.
Not made accused at
Not
all.
as the
Then who is accused number 1?
accused number 1 who has pledged the gold.
To the branch manager requesting to accept the gold. Except this, there is no other allegation against this petitioner. This is discernible from the complaint itself. Therefore, finding no allegation of 420 against this petitioner in particular, there shall be an interim order of stay of further investigation in crime number 46 of 2023. ಆಮೇಲೆ add ಮಾಡ್ತಾರೆ branch manager.
Even as per the last.
And I will see to that the branch manager is added.
Please.
Yes.
Under investigation, yeah.
It is made clear investigation against others shall continue.
Right?
306, 498 ಕಷ್ಟ. ಸುಮ್ನೆ.
Today filed some documents, my lord, on merits of the case, my lord. Today parties also is not present, my lord. Incident is happened on 13/11/2014, my lord. Since 2024, husband is not married, my lord.
Husband is?
Husband is not married, my lord. See,
Settlement ಮಾಡ್ಕೊಂತ ಇದ್ದೀರಾ.
settlement, today's parties is not present, is a respondent number 2 is art patient, Friday is present.
ಆಯ್ತು Friday ತಗೊಳ್ಳ.
Is not present, interim order ಕೊಟ್ಟರೆ I'll keep present the parties.
Interim order ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ, next date present ಇರ್ತೀವಿ. Is a heart patient due to his ill health, he was unable to.
Fix ಮಾಡಕ್ಕಾಗಲ್ಲ. But the husband is taking care of the children. ಮತ್ತೆ ಈಗ ಒಳಗಾಕ ಏನ್ ಮಾಡ್ತೀರಾ?
Lord, I see the photograph, Lord.
ಫೋಟೋ ಏನು ಗೊತ್ತಾಗ ಯಾರ ಹಸ್ಬೆಂಡ್ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ, ಫೋಟೋ ಏನು ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ?
No, date of the incident, my lord, 13/11/2014. See, my lord, 3/12/2014, this kids, my lord. See, now.
Whose kids, sir? Who knows? ಯಾವ್ದೋ ಫೋಟೋ ಮಕ್ಕಳು ತಗೊಂಡ್ಬಂದ್ಬಿಟ್ರೆ ನಾನೇ ತಗೊಂತಾ ಇದ್ದೀನಿ ಅಂತ ಕೇರ್ ಅಂತ.
I'll produce the.
Let me see, let them tell. Settlement 306 ಕಷ್ಟ. Let me see, we'll try to answer on merits. ಯಾವತ್ ಬೇಕು? Next week?
Next week, my lord. Meanwhile, interim, I'll keep present the parties, my lord. In
Senate
earlier
counsel
also
for
a
the petitioner and the respondent both in unison submit that after the death of the wife, the father is taking care of the children and are wanting, and the complainant, the in-laws are wanting to settle the dispute for the sake of the children. Therefore, I deem it appropriate to grant an interim order of stay of further proceedings qua the petitioner till the next date of hearing. List the matter on Friday, 19th.
God bless.
ಅವತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರೀತೀವಿ.
I'll keep present.
Short accommodation, your lordship, because they are producing one employment, your lordship.
138, ಇದು 138 420 ನಾ?
420.
420.
138 ಮಾಡಿದೀರಾ?
ಇಲ್ಲ sir, 420
ಹಾಕಿಲ್ವಾ?
ನಡೀತಿದೆ.
138 ಹಾಕಿಲ್ವಾ?
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರ ನಮ್ದು ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವ್ರದ್ದು ಆಗಿದೆ ಅಲ್ಲಿ. ಆಲ್ರೆಡಿ ಇಸ್ ಆಲ್ಮೋಸ್ಟ್ ಎಂಡ್ ಇನ್ ಸ್ಟೇಜ್.
ಏನ್ ಬೇಕು? ಟೈಮ್ ಕೇಳಿದ್ರ ಫಸ್ಟ್? ಟೈಮ್ ಕೇಳಿದ್ ನಾನು ಪ್ರೈಮ್ ಅಲ್ಲಿ.
ಸಾರಿ ಸರ್.
ಅದು ಎಕ್ಲಾನ್ಮೆಂಟ್ ಕೊಡಿದ್ರೆ ಇಸ್ ನಾಟ್ ಲೆಜಿಬಲ್, your lordship.
ವಾಟ್ ಇಸ್ ನಾಟ್ ಲೆಜಿಬಲ್?
ಅವರು ಪೋಸ್ಟಲ್ ಎಕ್ಲಾನ್ಮೆಂಟ್ ಕೊಟ್ಟದು. I want
But they are postal account
because
have
they
been produced
compared
before the
to
PCR,
March.
my lord.
ಈಗ ಸ್ಟೇ ಆಗಿದೆ ಅಲ್ಲಿ?
Stay ಇದೆ sir.
Stay ಇದೆ.
That is a difficulty, my lord.
Yes sir, what is the matter?
Your lordship, that the check was given.
This is 379 420
420, your lordship.
against you.
Yes, your lord.
You
Before
have
that-
initiated 138.
138.
When did you initiate 138?
138, your lordship, that the check dated, your lordship, that
21/12/2020, my lord.
21?
12/2020.
22.
22.
I have presented on, it is written on 23/12/22.
ಅಷ್ಟ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರಲ್ಲ ಇವರು?
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು
17/11/22.
23/12/22, 28/12 ಅದು.
ಅಲ್ಲ ನೀವೇ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಕ್ಕೆ ಇಷ್ಟು ದಿನ ತಗೊಂಡ್ರಿ?
My lord, I had given a complaint to jurisdictional police. They have not taken the action.
Where is the complaint?
My lord, I have produced along with my documents, my lord.
It is a
At
postal.
page number 14, my lord.
1 minute. Page
14, my lord. Annexure B to the PCR I have filed, my lord.
Annexure?
B to my PCR, my lord. Page number 14. I had filed additional documents on 18th June, my lord.
28/12/22.
Yes, my lord. I had given a complaint, my lord, but the action was never taken.
ಅವರು ನನ್ನ 3 ಚೆಕ್ಗಳನ್ನು ಕಳ್ಳತನ ಮಾಡಿಕೊಂಡು ಅದರಲ್ಲಿ ಒಂದು ಚೆಕ್
Even before that, my lord, I had given a stop payment, my lord.
ಹಾಜರುಪಡಿಸಿ 28/12/22.
Even before, my lord, 18th November, I had given a stop payment to the bank, my lord. I didn't know who took the check. So I just gave a stop payment.
ಇದರಲ್ಲಿ ಏನು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಈಗ?
ಇಲ್ಲ ಸ್ವಾಮಿ, crime stage ಅಲ್ಲಿ stay ತಗೊಂಡು.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿ.
Your lordship, that
We'll direct investigation, not filing of the charge sheet. Yes.
Your lordship,
Yes,
that
my lord.
in page number 24, your lordship.
Let's see, sir. Yes.
Your lordship, kindly pay the page 24, they are produced document. The commissioner, he was large complaint 24th March, your lordship, that 24th March.
Additional documents ಇದೆ.
Your lordship, that
Anyway, let investigation go on.
sent a message, your lordship,
The
that on
petitioner is
24th November, your lordship, that they are handed the three checks, WhatsApp messages are there.
investigation ಏನು ಪ್ರಾಬ್ಲಮ್ ಈಗ? ನಿಮ್ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರ?
Because the check.
ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರ? ಇಲ್ಲ ತಾನೆ?
130 is almost ending stage, your lord.
No problems. Yes. The petitioner is before this court calling in question proceedings in crime number 101 of 2023, investigation in crime number, registered for offence punishable under section 379 and 420 of the IPC. The issue relates to stealing of checks. The counsel for the respondent submits that 3 checks, checkbook, three check leaves were stolen from the residence officer. Residence of the petitioner, and wanted to register a complaint on 28/12/2022 itself, which was not taken, is his submission. The learned counsel for the petitioner submits that after the registering the proceedings under section 138 of the NI Act, the impugned crime is registered on 23/4/2023, while the fact is otherwise. Therefore, the matter be investigated into by the investigating officer, who shall not file the charge sheet without the leave of the court. It is made clear in the garb of investigation, no coercive action shall be taken against the petitioner. Yes.
Even the reply, they are not taken condition regarding complaint, your lord. That's why I
We'll
want to
see,
verify that.
We'll
postal
see
assignment.
early investigation.
Please,
You already on bail, why do you worry?
please.
Next.
7.
Please, my lords, I appear for the second respondent.
Trivikram.
Please, my lords. Lords,
ಏನೇನು ಕೇಸ್ ಇಲ್ಲ.
Alala, 498 my lords is a continuing offense. The triggering factor, my lords, is.
No, I am not on delay at all. Forget it. You
That
tell
only,
me
my lords.
what is
Alla,
the
ನಾನು
offense here?
ಅದಕ್ಕೋಸ್ಕರನೇ ಅವ್ರಿಗೆ ಏನ್ ಹೇಳಿದೀನಿ ಅಂದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿ ಅಂತ I myself proposed, my lords. My sincere request is let the matter be referred to Bangalore Mediation Center.
ಮಾಡಿ.
Let the parties.
Intermodal ಇಲ್ವಾ ಇಲ್ಲಿ? One
ಇಲ್ಲ
minute.
interim order.
The parties to learned counsel appearing for the complainant and the petitioner would in unison submit that if the parties are given a chance for exploring possibilities of a settlement, it would become fruitful for a disposal of the petition. Parties are directed to appear before the Karnataka Mediation Center on ಯಾವತ್ತು ವಿಕ್ರಮ್?
Any date, my lords, any date.
Any date ಅಂತ ಯಾವುದು ಇಲ್ಲ, ಡೇಟ್ ಹೇಳಿ. Yes.
22nd, my lords, if it is suitable for mine.
22nd at 3 p.m.
Please.
22nd is July 22nd. 22nd at 3 p.m. In the light of the said circumstance, there shall be an interim order of stay of further proceedings.
My lords, not there is, my lords, absolutely, my lords, kindly look into the complaint, my lords. It's a matter of trial, except the fact that
No, sir. Matter of trial, I will answer. I am only saying this is wholly frivolous.
No, my lords, my lords.
Husband is not before the court?
Yes.
Husband is also before the court. Let the matter be stayed insofar as the parents in law.
Yes, then all sincere efforts to take her to.
ಅದು ಗೊತ್ತು, one minute. There shall be an interim order of stay insofar as accused number 2 and 3 is concerned. Insofar as the husband is concerned, it would be considered in the event no settlement comes about.
Very well, please, great.
Yes. Eleven. Respondent. We'll finish it, close it.
Make only 2 points, my lord.
Yes, sir.
Actually, trial court record is required because there is no dispute. He has issued, the respondent issued the 4 checks, subject matter of 138 proceedings. Dishonored. Demand notice has been issued. Reply has been issued.
Now we are on 311 applications. Where is the order?
Meanwhile, no, I will.
My lords, the order is at page.
Sir, I will make
1 minute, I'll get back to you. Yes.
15, my lords, page
Page?
15. Page 15. Is
Page
issued order.
15. Sir.
15 is order.
311 application ಮೇಲೆ order ಎಲ್ಲಿದೆ?
Page 15, my lords.
50.
15.
15 is this, sir.
No, the next page, my lords. That's the starting of the page, my lords.
Page number 19, order operative portion.
ಅದೇ ಹೇಳಿ. ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು.
Reasons that page 17.
What is your explanation, sir?
My lords, the check, the amount in question is, my lords, 6,47,962.
Yes.
two invoices in concern, there are 4 checks involved, my lords.
All right.
It's the defense of the accused, my lord, out of 6,47,000. I am the complainant, my lords.
You are the
The
complainant.
complaint 311 has
I have
been
initiated
rejected.
the 138
Yes,
proceedings.
sir.
Defense taken by the accused was that out of 6,47,962, I have made a payment of 1,49,000. My lords, may I kindly see the evidence of the.
So you want to re-examine him?
No, means I want to, so specifically, I have stated in the evidence that the part payment that was made 1,49,000 with respect to previous transactions. In order to prove that these are previous transaction, I'm only seeking production of the previous bill, my lords.
What's the problem in that?
I will make 2 submissions.
My lords can,
Let him complete it. Then I will slowly.
my lords can,
Slowly, there's no question of
Let him-
slowly here.
No, his piecemeal is continuing. That's it.
Wait, you finish your full meals now.
Yes. My lord, this is the subject matter of the 2 invoice. Your lordship kindly see his demand notice also. Dishonor of check out of issuing to completion of the 2 invoices. And I replied also for the demand notice, stating that there is no such due to the extent of you demanded. And
Mere, 1 minute, mere production of this document will be proof, is it? He still has to prove it, sir.
No,
In accordance
that's
with
why
law.
that is-
Mere marking of a document will not amount to its proof.
It is not a subject matter, my lord. It
That's
is-
all right,
No,
then
no.
court will take care of
I
it.
will come, 2 minutes, my lord. I will
Yes.
complete I filed the objection, detailed objection also. My lord, his demand is only for 2 invoice, you have issued the 4 checks. And check has been dishonored. Checks have been dishonored. And I answered, subsequent to this thing, I made the payment to the extent of rupees 1,49,000. So evidence completed, cross-examination completed, defense evidence is completed, matter of argument also completed. When matter is posted to be posted for judgment, he filed this application. That is earlier one.
Order sheet you produced?
Page number 19, last your lordship posted defense side argument finally, page number 19.
Where is the order sheet? Give it.
petitioner's evidence was closed on 17/4/2023, my lords. Thereafter, defense evidence was closed on 12/10/2023. When the matter was posted for the arguments, I filed the application for 311, my lords. When it come to my knowledge that there were bills were supposed to be produced, inadvertently, they were not produced to prove that these are previous transactions, my lords.
Not at that
My lords,
stage.
may I kindly
civil
see
case
the
for
evidence of
recovery.
PW1? My lord, may I kindly see the evidence of PW1? It's at page 62. Why it's required for production of these documents, my lords?
You have cross-examined him. Arguments are over.
Arguments are not over. It's a stage.
My
of
argument is over, my lord. My argument is over. By that time, they filed the application.
May I kindly see page 62, my lords? From the bottom is the 6th line. ಈ 4 ಚೆಕ್ಗಳು ಬ್ಯಾಂಕಿಗೆ ಹಾಜರುಪಡಿಸುವ ಮುನ್ನ ಆರೋಪಿ ಇವರ ಖಾತೆಯಿಂದ ನಮ್ಮ ಖಾತೆಗೆ 1,49,000 ಹಣ ಬಂದಿದೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ
Anyway, let one opportunity be given.
My lord, it is not a subject matter because he has not produced before trial.
No,
As
argument
and
ಇದೆಯಲ್ಲ. One day he will finish it.
ಅಲ್ಲಲ್ಲ ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಪಾಯಿಂಟ್
ಹೇಳಿ.
ಬಿಕಾಸ್ ತಾವು ಮಾಡಿ ರಿಮಾಂಡ್ ಮಾಡಿದ್ರೆ ವಾಟ್ ಇಸ್ ಅಡ್ವರ್ಸ್ ಎಫೆಕ್ಟ್ ಟು ಮೀ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ subject, it is not a subject matter. He has not exhibited the document till conclusion. As and when I suggested, finally he is agreed after confronting the amount transferred to his account. He admitted that I have received 1,49,000. For a moment, my lord, kindly see his notice. What is the demand? Only 2 invoices, you have issued the 4 checks. That is the only subject matter. Now he cannot go back some other invoice. Your lordship, kindly see his notice. Page number 46, my lord. Their petition, page number 46.
Anything else, sir?
You have customers of one nimsha. Invoice number so and so, so and so, so and so. After that, you have issued the 4 checks. And second option, he has filed this complaint for the punishment or the penalty or the compensation. But this is not a civil case for recovery of the amount. Whatever the earlier invoice pending all this thing. And he has.
They are on marking of a document. That's all. Yes.
Document, as per my
submission,
my lord.
The petitioner is before this court calling in question an order dated 14/9/2021. 49 another. 29/1/2021 by which an application filed by the
Impugn notice 29/1/2024.
29/1/2024, by which an application filed by the petitioner to produce evidence has been turned down. Why did you make it in 311? Should have made it in 91.
My lord, it's in my custody only, my lord, this invoice. I have to produce.
Oh, you are in our custody only. So and so. The concerned court rejects the same. It is therefore the petitioner is before this court in the subject petition. A transaction between the petitioner and the respondent leads to certain proceedings being instituted by the respondent invoking Section 200 of the CRPC for offense punishable under Section 138 of the Negotiable Instruments Act. The matter was set for the evidence of the respondent, and the respondent had closed his evidence. It is then the petitioner files an application under Section 311 of the CRPC seeking production of a document which is in his own custody that he had not produced earlier, which according to him would cut at the root of the matter. The concerned respondent files his objections to the said application.
No, he doesn't file
Oh, he
it in the
didn't
trial
file.
court.
The respondent does not file objections to the said application, oral objections, like how we have done here.
No, I
Yes.
made it on the.
Does not file his objections to the application under Section 311. The concerned court rejects the application on the score that it has nothing to do with the transaction and it is a previous transaction between the two. The learned counsel for the petitioner, the complainant is therefore before this court in the subject petition. Learned counsel for the petitioner would submit that marking of the said document would clinch the issue as wapas kottidira duddu antana. Why do you want that?
Those are with respect, I have to prove that the payments which I have received from him are with respect to a previous transaction, previous invoice.
The learned counsel for the petitioner submits that the document, marking of the document is imperative as it would cut at the root of the matter to ascertain, demonstrate that it was the transaction that is the the accused is now claiming is a transaction that was earlier done between the parties and not the one that is in the case before the concerned court. The learned counsel appearing for the respondent would vehemently refute the submission to contend that the issue before the concerned court is entirely different and the document that he wants to mark is of certain previous transaction which has nothing to do with the present transaction which is pending consideration before the concerned court. He would seek dismissal of the petition. I have given my source. Therefore, narrated facts are not in dispute. The issue that has driven the petitioner to this court in the subject petition is rejection of an application under Section 311 of the CRPC. The concerned court, by its order dated 29/1/2024, rejects the application on the following reasons. Para 5 and 6, Saki Madam, page 17 to 19. The application filed, where is your application?
My lord's application is at page 65, my lords.
Page?
65.
The application filed by the petitioner reads as follows. In the application, the petitioner has reasoned out as to why the document is to be permitted to be marked in his defense. No objections are filed by the accused. The concerned court records the objections orally made by the accused and holds that it is not necessary to be produced as it was in respect of a previous transaction. The learned counsel for the petitioner has demonstrated that the previous transaction, the production of the document as a previous transaction has some bearing on the present transaction. Therefore, the concerned court ought to have permitted the production of the document as it is imperative, it is prima facie imperative for the petitioner to prove that the point that he has sought to project before the concerned court. As mere marking of a document would not amount to its proof. Even then, the petitioner will have to prove the issue.
There are 3 documents which I am producing.
Whatever you have asked in that. So and so. not permitting the marking of document or further examination, which is the spirit of section 311 of the CRPC, would run foul of the judgment of the apex court in the case of Varsha Garg versus so and so 2022 SCC online SC page 986, quote para 31 to 40. The said judgment is again followed by the apex court in the case of Satbir Singh versus State of Haryana, reported in 2023 SCC online SC page 1086, quote para 9 to 12. In the light of the circumstance that the petitioner projected before the concerned court and the judgments rendered by the apex court, the order is rendered unsustainable and therefore is required to be set aside. It would not mean that the petitioner can drag the proceedings any further on the score of marking of the document. One opportunity shall be given to the petitioner to mark the document. The examination or cross-examination on the said document should get concluded should be concluded on the date that the concerned court will fix for such examination or cross-examination as the case would be.
It will be documents, not because
Documents, yes, documents. For the aforesaid reason, the following order: allowed, quashed. The application filed by the petitioner stands allowed. The concerned court is directed to permit the petitioner to mark the said document, fix a date for examination and cross-examination of the said document, and conclude both these on the same day that the court would fix. Ordered accordingly.
I got para 5 of my objection, one line.
Para 5
objection. I filed the objection here.
Where?
Here.
Allah kilwal.
What is the circumstance I brought to the notice just?
No problem. Yes.
Just to observe one line, my lord. See, regarding my para 5.
Vehemently opposed ಅಂತ ಹೇಳಿದಿನಲ್ಲ.
ಅಲ್ಲ, vehement opposed.
Sir,
para 5.
ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
It is not a part and parcel, my lord.
Prove it. He will lose it. Leave it.
Once he entered the.
He gets acquitted by the document, is it?
I'm the complainant, my lord.
Sorry, he's a complainant. You get convicted by the document, is it? No, sir.
One observation of my para 5, my lord. At least
Yes.
one line, my lord.
And has sought to, ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, not filed objections there, but has sought to file objections before this court and places reliance upon paragraph 5. Those are noted only to be rejected. Yes.
For the satisfaction of the party, not.
Huh?
Only to the satisfaction of my party. He should not think that I am not.
No, sir. One document ಏನಾಗುತ್ತೆ? Not all right. Yes. ಏನ್ ಜಡ್ಮೆಂಟ್ ರಿಸರ್ವ್ ಆದ್ಮೇಲೆ ಮಾಡಿದ್ರೆ ಅದು ಬೇರೆ. Yes.
9.
Driver.
This case charge sheet is filed.
Filed. Challenge ಮಾಡಿ. If you want. Yes.
Direct the respondent number hospital address to produce the.
Sir, charge sheet ಹಾಕಿದ್ದಾರೆ, ಚಾಲೆಂಜ್ ಮಾಡಿ. ಇದನ್ನು FIR stage. Even then you are a driver, ಕಷ್ಟ. Yes.
But my contention, my vehicle is not involved.
Huh?
My vehicle is not involved. My contention.
See, that's a matter of trial, sir. Yes.
2 weeks to file objection. I'll file my objections.
13-1.
Similar matters are posted for 5th, my lord. May I request for?
ಅವ್ರು ಹಾಕಕ್ಕಾಗ್ಬೇಕಲ್ಲ ಎಲ್ಲ. Objections ಹಾಕಿ.
I'll file my objection.
I'll take this on 12th.
Interim order may be extended.
ಇದೆಯಾ? Oh, this is the Chanchalapati Dasa I had quoted.
Yes.
No, before the check period, there is a blank in the, that is the, during the check period, we are mentioned everything in the source report.
ಯಾಕೆ ಬ್ಲಾಂಕ್ ಬಿಟ್ಟಿದ್ದೀರಾ?
Not prior to that, nothing was
Check
there.
period ಇಲ್ವಾ?
Check period is, we are mentioned in the source report. What he has relied that, that is the prior to the check period, we have put it in blank.
Correct. Prior to the check period, blank ಇರಬೇಕು.
That is their argument now. Prior to the check period, they have mentioned it as a blank.
What check period have you taken?
Lord, after the service, joining the service.
Joining the service.
Please, Lord. That is on 2002. He has joined as a police constable. Subsequently, 2012, he is written KS exam and appointed as.
Then ಅಷ್ಟೇ ಇದ್ರೆ argue ಮಾಡಿ. Objection ಬೇಕಾ?
I'll file written.
List on 12th in the fresh matters list. Interim order subsisting shall continue till the next date of hearing.
Great.
Difficult if that is the argument.
Yes.
Yes.
We'll attend.
They appear for he himself
Petitioner's counsel.
videographer.
No, that itself is the crux, my lord. He himself admits, means what does it mean?
Yes,
Can
sir.
I, my lord, very
Section
interesting.
12, sir.
Correct, but not let.
How you're a teacher there? You're a teacher, ಹೌದಾ?
I'm a teacher.
You are a
Absolutely,
teacher.
I'm a teacher.
How
I'm-
can you photograph children changing their clothes? That's all.
That is all manipulation. May
Ah.
I take, my lord, I will not take much time. I
It's
will
a matter
only
of trial, sir.
precisely, my
If a
lord,
teacher indulges in photographing the girl students changing their clothes,
that is the
there is
allegation.
no end to it.
That is the allegation.
It should be tried. It should be tried, not at the
Lord,
stage of
would
crime.
Lordships kindly see the complaint. I will not take.
Absolutely, sir.
For my satisfaction, my lord, I subject.
Yes,
Subject to what your lordship say permits me, my lord, I will argue this.
sure, sir.
Would kindly see the complaint, the way in which, my lord, complaint is lodged. Page 18, my lord. Page 18 typed copy. ವಿಷಯ ಮುನಿಯಪ್ಪ ಕಲಾ ಶಿಕ್ಷಕರು ವಿಡಿಯೋಗಳನ್ನು ಮಾಡಿ ಸಾಮಾಜಿಕ ತಾಣದಲ್ಲಿ ಬಿತ್ತರಿಸುವ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ 15/12/2023 ರಾತ್ರಿ 9:30 ಗಂಟೆಗೆ ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆಯ ಸಹಾಯವಾಣಿ ಕಂಟ್ರೋಲ್ ರೂಮ್ ಗ್ರೂಪ್ ಟಿಕೆಟ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಈ ದೂರಿನ ಅನ್ವಯ ಮುರಿದಿನವೇ ನಾನು ಮತ್ತು ಜಿಲ್ಲಾ ಸಮನ್ವಯಾಧಿಕಾರಿಗಳು ಕರ್ನಾಟಕ ವಸತಿ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆ ಕೋಲಾರ ಜಿಲ್ಲೆ ವೆಂಕಟರಮಣಪ್ಪರೊಂದಿಗೆ ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆ ಯಲವಳ್ಳಿ ಭೇಟಿ ನೀಡಲಾಯಿತು. My lord, he goes and visits there.
Who goes and visits?
My lord, my lord, the one who, my lord, registered the complaint.
All right.
Very well. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಘಟನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿದ್ಯಾರ್ಥಿಗಳು, ಶಿಕ್ಷಕರು, ಸಿಬ್ಬಂದಿಯವರೊಂದಿಗೆ ಪ್ರತ್ಯಕ್ಷವಾಗಿ ವಿಚಾರಣೆಗೆ ಒಳಪಡಿಸಲಾಯಿತು. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸಿಸಿಟಿ ಪರೀಕ್ಷೆಗೆ ಹೋಗಿ ತಡವಾಗಿ ಬಂದಂತಹ ಸೆ ಮುನಿಯಪ್ಪ ಕಲಾಚಿತ್ರ ಶಿಕ್ಷಕರಾದ ಇವರನ್ನು ವಿಚಾರಿಸಲಾಗಿ ಈ ಘಟನೆಗೆ ಸಂಬಂಧಪಟ್ಟ ಎಲ್ಲಾ ವಿಡಿಯೋಗಳನ್ನು ನಾನೇ ಚಿತ್ರೀಕರಿಸುತ್ತೇನೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸಮನ್ವಯಾಧಿಕಾರಿಗಳು ಹಾಗೂ ನಾನು ಸದರಿಯವರು ವಿಚಾರಿಸಿದಾಗ ಸದರಿ ಮುನಿಯಪ್ಪರವರು ನಾವು ಪ್ರಶ್ನೆ ಮಾಡುವ ಅಧಿಕಾರ ನನಗೆ ಇರುವುದಿಲ್ಲವೇ ಎಂದು ಜಾಯಿಂಟ್ ನಿರ್ದೇಶನ ಪ್ರಶ್ನೆ ಮಾಡಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ನೀವು ಒಬ್ಬ ಜವಾಬ್ದಾರಿಯುತ ಸರ್ಕಾರಿ ನೌಕರರಾಗಿದ್ದು ಈ ರೀತಿ ವಿಡಿಯೋಗಳನ್ನು ಛಾಯಾಚಿತ್ರವನ್ನು ಚಿತ್ರೀಕರಿಸಿ ಮೇಲಾಧಿಕಾರಿ ಗಮನಕ್ಕೆ ತಾರದೆ ನೀವು ಮಾಡಿರುವ ತಪ್ಪು ಎಂದು ತಿಳಿಸಿರುತ್ತೇನೆ. ಆದರೆ ಮರುದಿನವೇ ಘಟನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅಪ್ರಾಪ್ತ ವಿದ್ಯಾರ್ಥಿ ಛಾಯಾಚಿತ್ರವನ್ನು ಚಾಣದಲ್ಲಿ ಬಿಟ್ಟು ಪತ್ರಿಕೆಯಲ್ಲಿ ಬರುವಂತೆ ಮಾಡಿ ಇಲಾಖೆ ಮುಜುಗರ ಉಂಟು ಮಾಡಿದ್ದಲ್ಲದೆ ದಿನಾಂಕ 17/12/2023 ಹೆಣ್ಣು ಮಕ್ಕಳ ಬಟ್ಟೆ ಬದಲಾಯಿಸುವ ವಿಡಿಯೋ ಮಾಡಿರುವುದಾಗಿ ಟಿವಿ ಚಾನೆಲ್ಗಳಲ್ಲಿ ಪ್ರಸಾರವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ my lord, this is the complaint. My lord, my fundamental submission is the way in which, my lord, complaint, my lord, intimation they get, my lord, on 15th of December 2023, my lord, late night.
Yes,
Complaint is lodged, my lord, on
17th
17th,
December.
my lord, at 5 p.m.
17 December.
No, one, I know. No, the things, the way in which, my lord, complaint has been, my lord, before filing the FIR, registering it, my lord, the person who registered complaint, my lord, goes to the school, asks the parents, asks the teachers, asks this man also. What type of, how can it be done without filing register, without doing the FIR?
That's not investigation.
No, I know, my lord. No, I know. It is a, my lord, what you call a pre-investigation, I can say. But would it be done even asking this man? Then, my lords, kindly see the handwritten complaint, David Nodi. All handwritten manipulation, page 16, my lord. Page 16.
ಅದೆಲ್ಲ matter of trials.
ಅಲ್ಲ ಅದ್ರ ಮ್ಯಾನಿಪುಲೇಷನ್ ಎಷ್ಟಿದೆ. ಹ್ಯಾಂಡ್ ರಿಟರ್ನ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ರಾತ್ರಿ 9 ಕೈಲೇ ಸೇರಿಸಿದ್ದಾರೆ. ಆಮೇಲೆ ಬಟ್ಟೆ ಬದಲಾಯಿಸೋನು ಕೈಲಿ ಸೇರಿಸಿದ್ದಾರೆ. ವೆರಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್. ಪೇಜ್ 17 ಆ ಹೆಣ್ಣು ಮಕ್ಕಳು ಬಟ್ಟೆ ಬದಲಾಯಿಸು ಅನ್ನೋದು ಅದನ್ನ ಇಂಟು ನಾಟ್ ಹಾಕ್ಬಿಟ್ಟು ದೇ ಪುಟ್ ಇಟ್ ಮಲಾಟ್ ಬೈ ಡಿಫರೆಂಟ್ ಲೈನ್. ಮಲಾಟ್ ಇಟ್ ಇಸ್ ದ ಬೇಸಿಕ್ ಆನ್ ಮೇಜರ್ ದಟ್ ಕಂಪ್ಲೇಂಟ್ ದೇ ಡೂ ಇಟ್ ಮಲಾಟ್ ಇವನ್ ಬೈ ಕರೆಕ್ಷನ್. ವಾಟ್ ಇಸ್ ಟೈಪ್ ಆಫ್ ಮಲಾಟ್, ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್?
What is all this? ನೀವು ಮಾಡಿರೋದು ಹೇಳಬೇಕು, ಇವರು ಅಲ್ಲ.
No, ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. Lord, can I get a confession from him before registering the complaint?
We'll see. Those are matters of trial.
Investigation almost completed.
Kodi.
Only FSL report.
Where is the
secure, my lord.
FSL? ಯಾವ್ದಕ್ಕೆ? Pictures.
ಅದೊಂದು ಮಾತ್ರ.
How long is the FSL taking?
10 days.
Yes. ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ?
Complete ಆಗಿದೆ.
Where are the investigation papers? With the FSL you produce before the court, before filing before the concerned court.
Please.
Yes. They heard the learned senior counsel SP Kulkarni appearing for the petitioner. The learned senior counsel would submit that it is the instant case is a classic case of manipulation of the complaint itself. The investigating officer appears to have visited the institution, secured confession from the hands of the petitioner that he has shot the videos, taken the pictures or the videos of the girl children changing their clothes in the school as he was an arts teacher in the said school. The allegation is horrendous, which would completely attract the provisions of Section 12 of the POCSO Act. The learned HCGP would submit that the investigation is complete and what is awaited is the FSL report with regard to the photographs. And would seek 10 days time and 10 days time so that the FSL report also be placed before the court. List the matter on 19th in the fresh matters list. The prosecution shall not place its final report before the concerned court concerned court without the leave of this court. Yes.
Yet another 65B, they can't get over. Supreme Court recently has said, 65B also, they can't escape.
We'll see.
Very interesting.
We'll see.
They are not produced.
Whether they cannot escape or you cannot escape, I will answer.
So that your lordship should hold of that then.
Yes, no, sir.
Anyway, I shall do my best.
Such teachers should not be left scot-free.
Subject to
How
procedure.
can you take pictures of girl children changing their clothes? Period over. You should not be a teacher at all.
ಲಾಸ್ಟ್ ವೀಕ್ ಇದ್ರ ಹಿಂದಿನ ವೀಕ್ ಅವನ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಬೇಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಓದ್ದೆ ನಾನು ಆ ಹೆಡ್ ಮಾಸ್ಟರ್ ಹೆಡ್ ಮಿಸ್ಟ್ರೆಸ್ ಮಲಾಡ್ ದೇ ಮೇಕ್ ಮಲಾಡ್ ಕ್ಲೀನಿಂಗ್ ಆಫ್ ದಟ್ ಮಲಾಡ್ ಗಟಾರ್ ಬೈ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಂತ ಟಿವಿ ಅಲ್ಲಿ ತೋರಿಸಿದ್ರು ಅಂತ. ಇದು ಏನು ನಮ್ದು ಏನು ಬಂದಿಲ್ಲ ಅಂತ ಪಾಪ ಬಂದೇ ಇಲ್ಲ, ವಾಟ್ ಕ್ಯಾನ್ ಐ ಡೂ ಮಲಾಡ್ ಅಂತ ಅವ್ನ್ ಪಾಪ ಅವ್ನ ಸಬ್ಮಿಷನ್.
We'll see.
ಅದರ್ವೈಸ್ ವೆರಿ
Let the investigation
Very, very-
papers come.
ವೆರಿ ಗ್ರೇಟ್.
12.
And for the petitioner.
Petitioner is directed to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect.
Already.
ಆಗಿದ್ದೀರಾ?
served,
Sir,
already
ಮಾಡಿದ್ದೀರಾ?
served, madam. Already served, madam. It is
ಹಾ.
4/6/2024. It is served and already.
List the matter on 19th till such time further proceedings before the concerned court shall remain stayed. Wait, yes.
13.
Interim order ಇದೆಯಲ್ಲ? ಮತ್ತೆ fresh matter ಬಂತು?
Last occasion, this court directed to.
ಅದೇ Excise Act, Jagdish ಅವರೇ.
It was a non-compliance of section 54 ಅಂತ ಹೇಳಿ.
Those Excise Act cases 53, 54. Non-compliance of 53, 54. ಅಲ್ಲ, ಅದು ಯಾವತ್ತು ಹಾಕಿದ್ವಿ ಮೇಡಮ್?
Last time, ಇಲ್ಲ, ಇಲ್ಲ.
Next. We'll take all of them on a particular day. ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ? 10th. List on 10th.
Last time, the government advocate-
Interim order ಇದೆಯಲ್ಲ?
Yes, that I'm not. Why?
List on-
ಯಾಕೆ ಬಂದಿದ್ದು ಅಂತ ಕೇಳಿದ್ದಕ್ಕೆ.
List on
Yes,
10th.
said that it is non-compliance.
List on 10th. Yes. Okay. So you say this is covered by this. I am not following this. Not a correct position of law at all. Runs counter to plethora of Supreme Court. Panchnama in the FIR Act, but on the 157 cannot be stretched to this extent. In search and seizure, definitely you find something else. That is why 157 is there. And after that, you come and register the FIR. No problem.
My submission.
No,
once credible-
Panchnama FIR register ಮಾಡಬಾರದು ಅಂತ ಕಾನೂನೇ ಇಲ್ಲ.
No, my submission, my lord, once credible information is received, which is a
Now, if
cognizable
this is
offense.
the issue,
Cognizable
ITP
offense.
offenses ಮಾಡಕ್ಕೆ ಆಗಲ್ಲ. Because first they have to search and then seize and then come back. No offense can be done if this is the view.
In fact, Lalit Kumari, my lord, in two judgment.
Yeah. It runs counter to constitution and judgment, sir. You are asking me to follow that judgment. I will not. Sir.
I leave it to lord.
I will not. We'll answer this. Yes. ಅದೊಂದೇ ಗ್ರೌಂಡ? ಬೇರೆ ಏನಿಲ್ವಾ? ಕಷ್ಟ. ಅದಾದ್ರೆ ಕಷ್ಟ. We'll have to answer this. ನೋಡಿದ್ದೀರಾ ಇದು ನೀವು?
Two judgments, my lord, that.
No, Lalit Kumar ಇಲ್ಲ ಇದೆ. It's a constitution bench judgment. Yes. 157 ಬಗ್ಗೆ there are 3 paragraphs dedicated in Lalit Kumar as to what is to be done in 157 ಅಲ್ಲಿ. Here conviction is set aside on the ground that FIR is registered on the ground on the Panchnama. 157 cannot be stretched to that. In 157 is meant only for that. On receipt of credible information. 154 and 154 one will register, it has to take, law has to take its course. Suppose on credible information they go and search, they don't find anything, they need not register the FIR. That is why 157 is there. ಸುಮ್ಮನೆ ಎಲ್ಲಾದ್ರಲ್ಲಿ FIR ಆಗ್ಬಿಟ್ರೆ then you have to come here, you'll have to seek bail and all those things happen. That is why 157 is. ಅದರ ಮೇಲೆ ಪಂಚನಾಮ ಮಾಡಬಾರ್ದು.
I leave it to lord.
Subsequently, two judgments of the Supreme Court clarified that position, my lord, and said that registration, conducting an inquiry, even they went to the extent of saying that investigation could continue.
No, investigation cannot. This is only
Inquiry.
They use the
Inquiry.
word, my lord, the investigation.
No, if you see para 120.6 of Lalit Kumari, where on 7 circumstances the Supreme Court directs that there should be a preliminary inquiry, including these corruption cases, matrimonial disputes and everything. There, a reference is made to 157.
Yes.
And 3 paragraphs preceding that is commentary on 157, what should be done. This runs counter.
Yes.
That's what. ನಾನು ಅದಕ್ಕೆ ಟೈಮ್ ತಗೊಂಡಿದ್ದು ನೋಡ್ತೀನಿ. Because I had not seen this view. Yes, I'll post it on Friday and dispose it.
Yes.
ಅದೊಂದೇ ಗ್ರೌಂಡ್ ಆದ್ರೆ ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ ಅವರೇ ಇಲ್ಲ.
First,
Yes.
2022 volume 30, 670.
ಯಾವ್ದದು?
There are 30 my lord.
ಅಲ್ಲಲ್ಲ, ಪಾರ್ಟಿ ನೇಮ್.
Party names, State of Jammu and Kashmir, Dr. Salim Surre.
We'll see, yes.
For the petition, Lordship.
ಇಲ್ಲ Friday dictating ಆಗುತ್ತೆ.
May I?
And for auto my lord, wife.
Lordship, there is,
Yes.
Lordship, there's a restitution petition 498A DV complaint filed by the wife. Petitioner has filed divorce petition. Petitioner husband evidence was discarded by the honorable family court because he could not make the complete payment of interim maintenance. It is a wife evidence alone and the contradiction during a cross examination which led to dismissal of a restitution petition and grant of
Now what have you challenged? The entire proceedings. Why?
Lordship, there's a clear finding that there was no demand for dowry. Husband has been
Who has rendered that finding? Who has given that finding?
It's in the divorce.
Where is it?
Yes. Lordship, may kindly see page number 125. One 128. There's a divorce judgment.
This has become final?
This has become final.
All right. Yes.
Sixth line. Though RW1, that is a petitioner here, has failed to tender himself a cross-examination, the facts admitted by the parties to proceedings leads to the conclusion that he suffered cruelty in the marital life due to refusal of PW1 for consummation of their marriage and by showing disrespectful attitude towards the family members of RW1, which amounts to cruelty. This is with respect to cruelty. Lordship, with respect to demand for dowry, may kindly see page number 124, para number 37. Though PW1, that is the wife, the respondent number 2 herein, has contended that there was a demand for dowry as discussed in the previous paragraph. She filed the said complaint subsequently after her husband filed the petition for dissolution of marriage. Even in the entire email produced for the court, both by the petitioner as well as by the respondent, there is no reference regarding the demand for the dowry. Lordship, with respect to cruelty with the family members, may kindly see page number 125.
Family members, only the husband is here. Why are you taking the family members?
Lordship, with respect to the payment of dowry at the time of marriage, there is in the cross-examination page number 40, page number 140. Paragraph number 4, 5th line. There are no, this is the cross-examination, there are no documents to prove that we have given 5 lakh to my husband at the time of marriage. This is the allegation made in the present 498 complaint. And Lordship, with respect to the finding of the court, that there's a false 498A complaint made by the wife, that is in page number 115.
115.
115. Paragraph number 28. Paragraph number 128, 1, 2, 3, 4th line. She filed false complaint against him and his family members. Petitioner subjected them to cruelty, though the PW1, that is respondent number 2 wife herein, was subjected to cross-examination in length in support of allegation made by the respondent husband in his petition filed for dissolution of marriage and MC.
Right.
Nothing has been elicited in her cross-examination in support of her case. This is the finding of the family court.
Also, before I go into it, when the case came up yesterday, Lordship asked one question, whether there was a discharge petition and there was a submission stating that this petition has been withdrawn. Right? I'd like to bring to Lordship notice that the discharge petition has not been withdrawn and it is posted to 29/8/2024. It came on 28/5/2024. Accused absent, EP filed and allowed for appearance of accused and to hear discharge petition by 29/8/24. Just I want to bring to the notice of what is happening in the trial stage, trial court. Also, leaving aside these judgments, this is with regard to 13(1)(a), and for restitution of conjugal rights. So now the current case that is being challenged is for 498A, 423 and 4 of Dowry Prohibition Act. Worship, there is a clear and specific allegation against each one of the.
Each one is not before the court, only husband is before the
Their
court.
name is
You concentrate on the husband.
Yes, madam, but there is a specific allegation against on the husband that there was a demand of the dowry and it has been admitted by the husband in his statement.
Where?
Okay, Lordship's kind attention, and page number might be varying. It is 67, I believe. The statement of husband.
67,
or it might be 68, I'm not sure about. The statement of husband. Second, 68, the first paragraph, it is in Canada, but the contents of this clearly states that he has taken his wife to one person by name Maulana. After his returning from after meeting Maulana, he has demanded.
For what?
That is a different issue altogether. So that is where he is also one of the person who was instigating the petitioner's family for demanding 50 lakhs. That is another story. That's another fact which has been deliberately dropped in the FIR. So if you go through this paragraph, it clearly states he has admitted, saying that he has demanded 50 lakhs and he has sent a wife back to her home. There is no case of decision, but it's a clear case. There is a dowry harassment. There's a demand for dowry and there is a harassment. And also request the Lordship to kindly go through the copy of the respondent. Actually 50-51, I believe.
50-51.
Yeah.
Yes.
Okay. It says there is specific allegation against each one of them, including the husband. Let me read. After engagement, I and Abe started talking over phone regularly. Okay.
Now, don't start from the Constitution 1950. Come to the relevant portion.
I reached my in-laws' house. Okay, here I reached my in-laws' house at Ara 22nd April immediately. Mara and Dolly, that is sisters of the petitioner, started asking me to hand over all the ornaments to them, since it was not safe for them to carry in train. Even without the consent, they took the ornaments forcefully. 420 minutes. Me, my husband, and my mother-in-law and Dolly's sister, with their family, started on 23rd April to Karnal, Dolly's house. In Karnal, they started torturing me mentally to bring 50 lakhs from my family at the earliest. I was asked by my mother-in-law to ask my family to arrange it before we reach Bangalore. So the allegation is very clear and unequivocal that there is a demand for dowry and and the respondent too was harassed.
Where is the charge sheet?
Charge sheet has not been filed. It is not here.
Charge sheet is in page number 41.
Where is that summary?
Page number 42.
41.
42.
42.
42 and 43.
That's the list of witnesses.
Ah.
Where is the summary, man? ಹೇಳಿ ನೀವು.
So this is not like the respondent wife has not roped in everybody. There is a specific allegation against each and every one now, including
You had roped in everybody.
They have roped in everybody.
Investigation.
They have roped in
After investigation, they are dropped.
But even
not that
that's
you
the
have
fault
not
of the
roped
investigation. Not.
You have roped in everybody.
Yes,
Sister,
my lord.
brother-in-law, sister-in-law.
Yes, my lord.
Whomever
At
you
one
got
point
in your mind, you have roped
At
in.
one point of time, they have been harassing all the family members, including one third person by name Maulana, the Pujari in some temple. He has also been instigating the person.
Oh, he is also an accused, is it?
He is also an accused.
Oh. Yes, sir.
So this complaint, my lord. is
Where is the charge sheet? Complete charge sheet?
That was
When you produce, you should produce everything.
summary. I produced only summary. Watch me.
Yes, sir.
With respect to the allegations of
Another
the others and
argument,
with
sir.
respect to the statement given by the husband.
One more thing, just before you answer. Lordship, in this order, in this common judgment passed by the trial court, there was an interim maintenance order for 20,000 per month, and the amount is amounting arrears of interim maintenance amounts to 10 lakhs. Till date, it has not been
No,
paid.
that is not the scope of.
No, no,
this
just I
petition.
want to bring to the notice of the lordship,
Previous
lordship,
sentence was
the
discharged.
nature of the person who has been attempting to derail every other proceedings that has been initiated by the respondent wife, my lord.
You have children?
No.
No, no, my lord. They had lived
Marriage
only
is
for
not
46
consummated, that she
They-
has
they are-
admitted.
They have lived only for 46 days together. And even after that, she was sent away very tactically for a function. And then
Function.
there was a function, there was some function just been
You
mentioned. They
didn't come
said
back after the function.
They never come back.
No, you didn't come back.
No, that was also observed in the lordship's child sake that the petitioner husband has deliberately avoided taking her back by not giving her the correct address.
What correct address? From where did you go to the function?
From Bangalore to Patna, Bihar.
Oh, function you went to Patna.
Yes, my lord.
You knew from where you went.
Yes, my lord.
You should have come back to the same
Yes, my
address.
lord. They came back. The house was locked and she was informed that before 2 months they have vacated the place. Husband.
How much time you went for a function?
It was for 6 months period, but it
6
extended.
months function.
Yes, my lord. No, it has been deliberate. It was only for 1 month, but the husband deliberately avoided taking her back on one pretext, though there were many attempts were made by the respondent's family to unite them. Request the lordship, just one
Yes,
minute.
please, sir.
Page number 1110 blood of the reasoning part of the judgment.
110.
110.
Hmm.
Okay. The email correspondence in Exhibit P5, lordship there, clearly shows that at the instance of RW1, the parents of PW1 kept their daughter in their house for 6 months. On completion of the time prescribed by the respondent RW1, the petitioner and the family members started insisting him to take her back to her matrimonial home, expressing their willingness to send the daughter PW1 to her matrimonial home. The contents of Exhibit P5 supports the case of the petitioner wife that the respondent sent her to the parents' house for some ceremony, assuring that her return date will be decided after 15 days, and was also sent his mother to her hometown. Thereafter, he started making excuses that he has problem in his job and he's going to Mysore on the duty and is going to stay in office guest house. The contents of exhibit negatives the case of the respondent that his allegation the petitioner failed to return to her matrimonial home after the ceremony. So there has been it has been a planned attempt by the petitioner husband to avoid refuse to take back the respondent wife.
Who filed restitution of conjugal rights?
Restitution of conjugal rights filed by the wife.
Which is dismissed.
Why is it dismissed?
Because
you did not come back from the function at all.
No, my lord.
That's why it is dismissed.
That is the reason that isn't mentioned. She came back from the function. It has been recently, my lord. It's a part of the
No,
judgment.
don't generate tension because of function. You will see.
No, I'm just reading out from the judgment copy saying that where
is summary of the charge sheet, madam?
I'll produce it.
Should you not produce entire documents? Heard the learned counsel appearing for the petitioner and the counsel appearing for the respondent. The petitioner shall place on record the entire charge sheet as it is short placed before the court. List day after tomorrow in the fresh matters list.
They posted after 20 because the next hearing date of discharge petition is 28th, my lord.
28th of this month.
Yes, my lord.
July.
Yes, my lord.
I will not permit that to happen. Don't worry. Sir. Yes.
Lordship, we have already not pressed the discharge application. We are producing the memo.
By then get it.
Yes, we'll advance.
Yes.
it.
Online application shows it has been posted for next hearing.
I'm posting it day after tomorrow. Get the charge sheet material.
Yes.
Oblige and get
Not the entire material, madam. I only want the summary of the charge sheet. State ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಇಲ್ಲ. I think you will get it faster than get it. Yes. Thursday in the fresh matters list.
Oblige.
Petition. Last time your lordship was asked him to file an affidavit to the extent that because he continued to commit from 2019.
It is not the case. What my case is, in 23 it is shared. This video is already there in 2019. Anyhow, I have already been apologized on my social media also. Now I am, through the affidavit, I am seeking an apology.
If it is a video already on the social media and it is tagged or forwarded again Would that make out 153A? What did you do to that 2019 video that is subsisting?
It's only, the appears, my lord, he only posted it in
No,
2019.
no, sir. No, sir. I have just extracted what is
ಹಿಂದೆ
available.
2019 ಇಂದ ಇದೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
2019 ಇಂದ ಇದೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ I have placed that document, not that it is I who have generated it.
The petitioner is before this court calling in question registration of a crime in crime number 49 of 2024 registered for offense punishable under section 153A of the IPC. The learned counsel, the petitioner gets embroiled into this crime on the score that he has tagged a video on his social media, Facebook ಏನಿದೆ?
Twitter.
On Twitter.
Twitter, Facebook and Instagram.
ಯಾವ್ದು ಬಿಟ್ಟಿದ್ದೀರಾ?
No, only on Instagram, sorry, only on Twitter, only on Twitter. Only on Twitter.
Twitter, Facebook or Instagram as the case would be. The issue is whether this would amount to an offense under section 153A of the IPC. It is the submission of the learned counsel for the petitioner that he had only tagged or shared the video on Twitter, which was subsisting in the social media since 2019, and he cannot be hauled for for the offense under section 153A of the IPC. Prima facie, permitting further investigation into this issue would run foul of the judgment of the apex court in the case of Javed Hajam versus so-and-so 2024 4 SCC 156. The learned additional SPP is directed to accept notice for the first respondent. Ebru nivena? First, for the respondents, they are at liberty to seek vacation of the interim order if needed in
In
future.
fact, petitioner is ready with the affidavit. Petitioner is ready with the affidavit. Because last time it was told.
The learned counsel also
Student.
files an affidavit of undertaking that he would not indulge in such sharing, indulge in the acts that have now become section 153 of the, on all these, ಇದು ಆದ್ಮೇಲೆ madam, ಕೊನೆಯಲ್ಲಿ ಹಾಕಿ interim order. Yes.
Please.
Section 50.
50 clause 1.
There is one more 52, wait. We'll take it together. ಇಲ್ಲ ಇದೆ. It's serial number. ಯಾವ್ದು ಜಗದೀಶ್ ಅವರೇ? Serial number 36.
Please.
I'll take it with that, yes. Next.
18.
Pass over the matter. That in another court, my lord.
You are here,
My lord, so I'll undertake to file wakalat for respondent number 2, my lord.
respond number 2.
Please.
Why sir, wife has beaten children. ನಿಮ್ಮ matrimonial disputes ಎಲ್ಲ projecting children, don't register these frivolous crimes. Settle the dispute amongst yourself. ಅದು visitation li children ಹೊಡೆದ್ರು ಅದು ಹೊಡೆದ್ರು. Why would mother beat the child? 75 JJ Act. ಇಲ್ಲ husband will have an axe to grind against the wife or wife will have it. In this crossfire, children are finished. Yes, sir. Nimden, sir. Yeah. I'm staying it. Let him come. Yaar senior counselor.
ಇಲ್ಲ ಕೇರ ವಿಷಯ ಐ ಆಮ್ ದ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಮಾಡಿ ಈಸ್ ಹೆಲ್ಡ್ ಅಪ್
ಪರವಾಗಿಲ್ಲ.
ಇಂಟು ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇದೆ
ಆಲ್ರೆಡಿ ಇದೆಯಾ?
Please.
ಹಂಗಾರೆ ಡಿಸ್ಪೋಸೇ ಮಾಡ್ಬೇಡ. ಮೈ ಎಂಟ್ರಿ ಮಾಡಿ. ಎಸ್. ವಾಟ್ ಸರ್? ಟೇಕ್ ಕೇರ್ ಆಫ್ ದ ಚಿಲ್ಡ್ರನ್ ಸರ್. Such animosity you generate for the children, what would happen to the fate of the children? Both of you are registering crimes against each other. Holding the children in hand, projecting them. And you will have to tell the child, if it is not beaten, you will have to tell the child, tell that your father beat you, or mother beat you. ಅಲ್ಲೇ ಸುಳ್ಳು ಹೇಳೋದು ಹೇಳ್ಕೊಡ್ತೀನಿ. Yes. Friday will dispose it. Yes.
ಎಂಟ್ರಿ ಮಾಡುವ ಎಕ್ಸ್ಟೆಂಡ್
Interim order subsisting shall continue till the next date of hearing. Friday, fresh matters lack. Petitioner is directed to Nimdala, next matter. Petitioner is next year Nimda. Petitioner is directed to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement in the next 2 days. Place the matter on 19 till such time further proceedings before the concerned court shall remain stayed.
Okay.
Application ilva?
Application ಇಲ್ಲ entry ಮಾಡ್ರಿ. Disposal ಕೇಳ್ತಾರೆ. The disposal
Disposal
as per-
ಆಗಲ್ಲ. List on 19th. Entry ಮಾಡ್ರೆ ಕೇಳಿಲ್ಲ ಮತ್ತೆ. Yes, next.
20.
311.
Responded by.
What happened to your hand?
Practice.
You should have appeared on VC. Yes, really.
I have filed 311 application production. of the-
What is the problem in allowing?
ಇದರಲ್ಲಿ the document on the witness sought is not the his side. From my bank account, he wanted to be examined. In no way, this is a very old case, 2019 PCR and 2021 CC, and all the evidence was over. Cross-examination again.
What stage was the proceeding in?
Reply arguments, final arguments of the accused. And also the finding of the learned magistrate at page number 18.
Was this the first application?
First application. So far, that is, I am not numerically, I am not on the way, but if he has his own evidence and he wanted to examine his own witnesses, yes, there is bona fide. Here, what is the reason? Here, he has to explain to the court. At least this court, the court has given a reason in the considered order, 18, page number 18.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕನ್ಕ್ಲೂಡ್ ಆಗಿ ಜಡ್ಮೆಂಟ್ ಇದ್ದಾಗೆಲ್ಲ ಇದು ಮಾಡೋಣ.
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ನನ್ನ ಎವಿಡೆನ್ಸ್ ಚೀಪ್ ಆದ ತಕ್ಷಣನೇ ನನ್ನ ಕ್ರಾಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ put it the suggestions. I have produced the 29
The
documents.
registry is directed to secure the concerned court records by telephonic instruction by the next date of hearing. List on 12th. Interim order subsisting shall continue till the next date of hearing.
I take rest for my lordship. After 2 weeks, I take rest, my lordship.
ಈಗ ಬಂದಿದ್ದೀರಾ?
ಇವತ್ತು ಮೊನ್ನೆ ಶುಕ್ರವಾರ ಆಯ್ತು, ಇವತ್ತಿಗೆ ಹಾಕೊಂಡು ಫೈನಲ್.
ಇವತ್ತು ಯಾಕೆ ಬರಕ್ ಹೋದ್ರಿ? 12th, 18th. Take rest till 18th and come. If I see you in any other case, I will prepone this. Yes.
21. Same.
Same.
22.
ಏನ್ ಮಾಡಿದ್ರಿ? ಭಾರತ್ ಮಾತಾ ಕಿ ಜೈ.
Mata ki jai. But the complaint has been given as afterthought and counter blast, my lord, in the next day during the.
I placed the record, my lord, last day of hearing.
ನೋಡಿದ್ದೀನಿ, ಅದಕ್ಕೆ ಹೇಳಿದ್.
Is the case where.
What he says is correct. ಇವ್ರು ಫಸ್ಟ್ ಕೊಟ್ಟಿರೋದು ಕಂಪ್ಲೇಂಟ್.
Complaint you could correct, but your lordship see the station of diary I have produced. Station of diary has the extract of what happened previously. I'm not disputing about the filing a complaint. But the incident happened first.
ಅದೇನಾಯ್ತು? ಎರಡು ಟ್ರಯಲ್ ಆಗ್ಲಿ ಬಿಡಿ.
But they are all innocent people, my lord. They know as a counter blast this has been given, my lord.
This is the classic case, my lord, where 153A can be invoked, where action resulted in violence.
And when the police were present, my lord, they were not registered any suo motu case, nor they have given complaint. This is only, my lord, next day they register the case.
So statements also have produced.
That they
ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ.
That makes it very clear, my lord, to overcome the FIR registered against their team, my lord. Now they filed this. And those who are, my lord, victims in that FIR, they are not arrayed as accused in this. They made others as accused. So therefore, my lord, it is a clear case.
But you entering the mosque is what?
No, didn't to enter, my lord. Even videos are there, my lord. We can demonstrate straight away. That is not so, my lord. It is a concocted story.
ಎಲ್ಲ why all this?
No, they.
Where is the 153A cases are so much on the rise?
My lord, they were traveling in the two-wheeler. And at that time, they chased them and, my lord, assaulted. And to overcome that, this complaint has been lodged.
We'll see, let the investigation papers be there. Heard reserved.
I place this further material.
ಕೊಡಿ. ಏನಿದೆ ಎಲ್ಲ ಕೊಡಿ. Let me see. Interim order ಇದೆಯಲ್ಲ?
Interim order, no coercive and precipitative action. That
No
means-
coercive. Yes. Till interim order subsisting shall continue till the disposal of the petition.
Right.
Yes.
23.
For petition number.
In the meantime, next.
24.
Granted, sir. Yes. Four 306.
Eastman. Some benevolence man, 22 years after the marriage, man, having 2 kids of college.
Yeah, but
kids.
this is a lethal combination.
Yes,
Three not 6 and 498A.
Even on
Or
merits.
304B and 498A.
On merits also, man, some extent, adding to this, man, merits also. After lapse of 20 days, my lord, there is no way concerned to the matrimonial affairs.
You are the husband, sir.
I am the husband.
Ah.
And the first informant, my lord, first informant is the brother of.
It's all right.
deceased.
First, you forget about
And
the first
stays
informant.
stays in Ranebellur, my lord. And after immediately after realizing, my lord, his fault in filing the complaint, you would go to the police station and file the affidavit stating that by mistake of fact I filed the complaint and I wanted to withdraw it. But despite this fact,
That is the only factor which has kept this petition till now. Yes, government. ಎಲ್ಲಿದೆ ಅದು? ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ affidavit. ಎಲ್ಲಿದೆ? Where is the affidavit?
ಅಲ್ಲೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
Who is the complainant?
My brother-in-law.
Get the complainant, we'll see.
Please.
Not here, ಈಗಲ್ಲ. Notice ಮಾಡ್ತೇನೆ. One,
Then
HCGP. Two, emergent notice. The petitioner is also at liberty to serve on the complainant by way of hand summons. ಆಗಿಲ್ವಾ? Issue emergent notice ಆಗಿದೆಯಲ್ಲ ಆಗ್ಲೇ?
ಆಗಿದೆ.
ಮತ್ತೆ ಯಾಕೆ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಅಂತ ಬಂದಿದೆ? Wait. Yes. In the meantime, you get the records.
Sheet is filed, my lord.
ಇದು FIR ಚಾಲೆಂಜ್ ಮಾಡಿರೋದಾ?
Not FIR, my lord, charge sheet only.
ಹಾ, ಮತ್ತೆ
Charge sheet.
SC ಮಾಡಿರೋದು.
Yes.
Yes. Let him come. Yes. Post immediately after service of notice upon the second respondent.
One particular date.
ಅಲ್ಲ, ಅದು ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲ?
Any date.
Or 12th, whichever is earlier. Yes.
Say number 25. We take a stay before the NCLT at page 71. Because there was
Heard the learned senior counsel Vivek Reddy appearing for the petitioner. 1 HCGP, 2 emergent notice returnable by 19th. On the score that a commercial transaction between the two is sought to be given a color of crime, albeit prima facie. Further proceedings shall remain stayed till the appearance of the complainant.
Please.
List the matter on 18th.
Please. Oblige.
26.
A perusal at the complaint would clearly indicate that it is registered for recovery of money of, but ದುಡ್ಡು ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ನೀವು? 6 ಕೋಟಿ
ವಾಪಸ್ A1 ವಾಪಸ್ ಕೊಟ್ಟಿದ್ವಿ.
ಕೊಟ್ಟಿದ್ದಾರಾ? Anyway, recovery of money of 6.25 crores, permitting further proceedings, and the criminal law is set into motion for recovery of such amount. In the light of the issue being recovery of money which is impermissible for, in the light of the issue being recovery of money and it being impermissible through criminal proceedings, further investigation shall remain stayed, failing which early judgment. It would run foul of the judgment of the apex court in the case of Usha Chakravarti versus so and so, 2024 SSC online SC page 171.
And also, my lord, 16 months delay in complaint.
Yes.
Great.
ದುಡ್ಡು ಬರ್ಲಿಲ್ಲ ಅಂತ ಅಲ್ಲಿಗೆ ಹೋಗಿದ್ದಾರೆ ಅಷ್ಟೇ. ನೀವು ಕೊಡೋದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಅಲ್ಲ, ನಾವು A3 ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ.
Yes.
What I received in my account, same day.
Pay the petitioner ಅಂತ ಮಾತ್ರ. Yes, list on 24th.
27.
Yes, sir.
Lordship, may kindly see in page.
Guitar
24,
teacher.
Malcolm.
I told you yesterday, a guitar teacher should hold the plectrum in the guitar and not lay his hand somewhere else. What have you done here?
Other students are present, my lord, at the time of incident, my lord.
The other students are present.
In page 24, my lord.
24, come to page 30, sir.
In the complaint, my lord, she is reveals that, my lord.
No, your hands have been engaged in something else. That's why this has a.
Also, my lord, there is no detailed order in the cognizance taken.
Huh? Class ಮುಗಿದ ನಂತರ. Guitar teacher.
She was not shouting, my lord. She was
not shouting. You want her to shout, is it?
And also, my lord,
ಆಚೆ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
also
ಏನೋ
present.
ಕಂಪ್ಲೇಂಟ್ ನೆಕ್ಸ್ಟ್ ಡೇ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಡೇ ಇಲ್ಲ, ಆಚೆ ಬಂದ ತಕ್ಷಣ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
The reception is also present, my lord.
ಅರೆ ಕ್ಲಾಸ್ ಮುಗಿದ್ಮೇಲೆ ಅಂತಿದೆ ಎಲ್ಲ.
The reception is also first was present at the.
Guitar teacher should play guitar. ಅಷ್ಟೇ.
So there is no detailed order in the
Huh?
cognizance taken by the magistrate. My lord.
ಅದೇ, don't worry about it. I'll handle that. No reason, na? Cognizance orderly.
The first informant is also, my lord, the CW6 is the first informant, my lord. He was,
ಆಮೇಲೆ ಕಳಿಸ್ಬಿಟ್ಟು ರಾತ್ರಿ ಎಷ್ಟೊತ್ತಿದ್ರು ಕಾಲ್ ಮಾಡು, ಪರವಾಗಿಲ್ಲ. ಗಿಟಾರ್ ಹೇಳ್ಕೊಡ್ತೀನಿ. No, sir. You want to file discharge, you file. Otherwise, I'll answer it now.
discharge.
Yes. So and so seeks leave.
I appear for petition.
Bala Manjunatha.
So, but the lordship, the allegation
Records
is
are
that
there,
I
madam.
have threatened.
Records ಇದೆಯಾ? ಕೊಡಿ.
Even the call records from which the accused has made a call.
But Nanalla, the accused number 1 call record, I was in custody.
Records ತಗೊಳ್ಳಿ ಮೇಡಮ್.
He had called the uncle of the victim.
It's not me.
Taken call to the mother of the victim. The call, conference call has been produced.
No, ಒಂದು pleading ನೋಡಿದೆ.
Yes, sir.
That they threatened you for ransom, that they would upload all your intimate videos. What videos were there? No, 1 minute, I'll get back to you. What videos were there? So there was something.
No, but in for.
That is a pleading.
No, insofar as this impunity affair is concerned, complaint is concerned, so far as against me, there is no such allegations. Even single allegations is not there because I was in custody. Your lordship, 7/3/2021, an affair is registered against me. I was arrested on 8/3 on the very same day. And 8/3/2024, your lordship, I was produced before the court. And the FIR is registered on 9/3/2024, my lord.
In this,
And yes, your lordship, may kindly see that.
why were you taken to custody?
I was taken into custody
which
in
crime?
another matter.
Which crime?
That is there is case registered against.
Another matter, ah?
Yes, your lordship, against the FIR is registered under the POSCO Act.
POXO Act.
Yes, your lordship. That's why I was taken to the custody, and thereafter I was produced before the court. I was in the, even thereafter I was sent to the judicial custody also. And this affair is registered after that.
On 9/3/2024.
Yes, Lordship,
At that time, you were in custody.
I was in custody. Your lordship, may kindly see the order sheet which I produced along with the petition, Annexure G.
ಅದ್ಯಾವ್ದು POXO case ಯಾವ್ದು?
That is pending for, charge sheet is also filed, my lord. Charge sheet also filed, now it's pending for trial. And your lordship, may kindly see.
What is the allegation here?
Your lordship, here.
On 9/3/7:30 ಗಂಟೆ prime so and so.
See, the victim, she lodges complaint saying that, your lordship, her uncle called her, her uncle, one Krishnamurthy, called her, saying that, your lordship, he inquired about the complaint, have you registered the complaint? He inquired. Thereafter, what happened, because he put the call through conference, and one Manoj was connected. Manoj is the accused number 1, your lordship.
Manoj is
Whole
A1.
allegation,
Manoj is A1.
A1. Whole allegation is against A1. But only one sentence.
Who is Manoj?
I don't know. That's
You don't
devotee
know?
of the temple.
He's a follower of Swami.
Devotees, my lord.
He was
Working with him.
And even otherwise, your lordship, for sake of argument, your lordship, assume that there are allegations.
But against him, he was not even there on that day. Yes.
Here there was a FIR registered in CR 14/2024, my lords, in Sen police station, Tumkuru, my lords.
That
Punishable under section 384, 67E, ITI, 120B, and 34 of IPC.
yes.
The complainant in this case is Swamiji, my lords.
Against his two persons.
Yes, sir.
She was working, my lords. The pleadings which she has made in the petition, my lords, with respect to some photographs and.
Yes.
He had some problem on his private parts, my lord. For that, he consulted one doctor. The doctor asked him to call on video call and show the pictures and all. For that purpose, this CR 14 came to be registered. That was CR 14. CR 50 registered by the same victim who is the complainant in 52. The FIR under challenge, my lords. For the offences punishable under 4 and 6 of POXO Act.
No, that trial is on.
Yes, the charge sheet has been filed and trial is. when Manoj, who happens to be the follower and who used to work with Swamiji, my lord, he came in contact with Swamiji and he thought like she is the person who has lodged complaint against Swamiji. So he called over phone and asked his Chikkappa whether she has lodged a complaint. In turn, Chikkappa taken conference call to his mother that I have produced.
So
my
that
lord.
you have said threatening calls were made.
That is the threatening call to take this CR 50
Hmm.
or else they will kill. This was the case.
No, why is this man then an accused in this? He was already in custody.
My lord, because upon his instigation only he has made a call.
No.
That's
no,
difficult.
They cannot.
Custody in the
improve their
instigation.
allegations. They cannot improve the case like this.
As a visitor.
No, wait.
No, they cannot, my lord.
No,
because
no.
There is
He is in police custody or judicial custody?
police custody.
Judicial custody, he instigated him to do this.
Therefore, verify whether he is on bail or he is still. in
Now he is on
custody.
bail, my lord. Now he is on
Well,
bail.
no, as on the date 9/3/2024 is the incident. He was taken into custody on 8/3/2024. So he was in custody. Where is the instigation in custody? You continue with that crime and continue against this A1. That may not, continuing against him may not be correct. Though you may not deserve anything, but facts.
No, but even otherwise, your lordship,
But-
allegations are there. Even if you assume that there is allegations, but affair cannot be registered, your lordship, because under CRPC section 195,
Hmm.
allowed to lodge complaint, your lordship. I can only see the,
Private complaint
yes, your lordship.
for offences under 195A.
Yes.
Anyway,
May I read, my lord, 195A
yes.
of the CRPC? So 195, procedure for witness in case of threatening, etc. A witness or any other person may file a complaint.
Now complaint is by this Tanushri,
She-
who is said to have been threatened.
Yes, she is the victim. Witness or any other person may file a complaint in relation to an offense under section 195A of the Indian Penal Code. So complaint that is defined under the CRPC.
No
2D,
complaint there is a private complaint.
Yeah,
We have held
it
it.
has to be private complaint. And there is one judgment of the Honorable Supreme Court.
That will see, that will help A1 also. Wait. Yes. You are arguing only for A2 alva? A1 is
Yes, A1, A2,
then
ಮಾತ್ರ.
A1, A2.
A2, yes, madam. A1 is Manoj, my lord.
So you are not for Manoj.
No, I'm not.
Don't argue for Manoj. Yes. On the ground that he was in custody, I'll state. Heard the learned counsel appearing for the petitioner, Srimati Leela Devadiga, and the learned additional SPP, Asma Kausar. The petitioner is said to be the pontiff of one Vidya Chaudeshwari Mata. He gets embroiled in a crime which includes offences punishable under the provisions of the POCSO Act and is taken into custody on and is sent to judicial custody on 8/3/2024. This is an admitted fact. The pontiff is taken into custody in crime number 15 of 2024. 50, na? 50 of 2024. If the petitioner was in judicial custody, it is ununderstandable as to how the allegation can spring against him in the case at hand. The allegation against the pontiff is that he has at 7:30 PM called the complainant and threatened her. It is a common allegation made to both accused number 1 and 2. Since the petitioner was already in judicial custody, instigating accused number 1 to make the said call is prima facie untenable. Therefore, the charge or the allegation must be answered only by accused number 1 in the aforesaid peculiar circumstance. Though Herculean effort is made by the learned additional SPP for stalling of grant of an interim order, I deem it appropriate to grant an interim order of stay, qua the petitioner accused number 2 on the aforesaid score. Next.
29.
The petitioner is accused number 4, Lord.
When did you grant loan, sir?
2017, Lord. There was a norms, Lord.
Is a departmental inquiry is initiated against you?
No.
No, for discharging loan contrary to law.
Yes, that violation of circular of 2019, they saying, Lord.
Where is that?
The circular I had produced at annexure, annexure D, Lord, that is issued on 14 June 2019. The norms were regulated as per the circular date 2019. I had issued the loan, processed the papers in the year 2017 by following the circular dated 2016. That is annexure C, Lord.
We'll see. Learned additional SPP is directed to accept notice for the first respondent. The second respondent, emergent notice to the second respondent complainant returnable by the 24th of July. Till such time further proceedings, investigation, further investigation in 26 of 2024, where the petitioner shall remain stayed on the score that the petitioner, on the strength of being the manager, had processed certain loan and granted the loan on 30/6/2016, following in 2017, following a circular that was in subsistence as on that day, which is dated 30/6/2016. The learned counsel for the petitioner submits that following of the circular cannot lead the petitioner to the web of crime, as fraud is alleged against the petitioner even. Lest this matter date. Madam, what is this?
67 accused were there.
There are 60 accused there in there.
Brokers, they have cheated the people.
Oh, yes.
I'm the accused number 26, 27 and 28, Your Honor.
Huh.
Already I repaid the loan in the year of 2018, Your Honor. And it needs to annex.
Who is the complainant?
Complaint is the Rajesh Export, Your Honor. Who is the?
Who is he? Rajesh Exporta.
Rajesh Export Finance.
ಅವ್ರ ಹತ್ರ ತಗೊಂಡಿದ್ರ ದುಡ್ಡು ಎಲ್ಲಿ ರೀಪೇ ಮಾಡಿರೋದಕ್ಕೆ ಎಲ್ಲಿದೆ?
I will place the order sheet, Your Honor, which is in page in 88, Your Honor.
Discharge deed execute ಮಾಡಿದ್ದಾರೆ?
After the payment of the entire amount, Your Honor.
Madam, you have seen this? Annexure F.
In the court only, Your Honor, in the year of
The
2000.
petitioners are accused 26, 27 and 28 are said to have secured certain finance from the second respondent, Rajesh Export Company. The learned counsel for the petitioner submits that the entire loan that they had secured have all been repaid. After repayment, Rajesh Exports also executes a discharge deed of discharging the mortgage in favor of these petitioners. Despite this, the subject crime comes to be registered long after the discharge deed being executed. Therefore, till the appearance of the complainant, there shall be an interim order of stay only against these petitioners on the aforesaid score.
Please, much of,
List on 24th.
please.
Yes, sir. FIR is too fresh.
No, the connected matters,
This
connected
matter,
matters.
my lord, your lordship has protected the accused number 1.
That is the,
Kodi ಅದು.
please.
Is
Court
accused
of-
number 2. Is that Valmiki?
Who's one? Then how, one minute. You are what?
They're all executive directors of the Union Bank.
Bank, Union Bank.
No, no,
Director.
sir.
Complaint is against them. Your lordship may see page 30.
The Valmiki scam da.
Page 30. We are all based in Mumbai. And the
Let's see,
complaint
let's
against
see.
us is at page number 30. Your lord.
Well, let's see. All the matters ಯಾವ್ಯಾವ್ದೈತೆ ಕೊಡಿ ಎಲ್ಲ.
Your lordship has already posted them on 23rd.
Yes, I'll take this on 23rd, get the investigation papers. ಎಲ್ಲದರಲ್ಲೂ ಏನು, all of you are non-executive directors.
We are executive directors based in Mumbai.
So what?
Incident takes place in Bangalore.
So what?
No, but the role of them in this offense of 468.
23rd ಬೇಡ. Well, I'll take it on Friday. ನೀವಿಲ್ವಾ? Next ಯಾವ 10th? List heard the learned senior counsel Kiran Javli appearing for the petitioner. The learned counsel submits that there is an interim order of protection granted to the other petitioners who are similarly situated. Interim order is that the petitioner shall cooperate with the investigation and no action, coercive or any kind, be taken against these petitioners. The same order is passed in all these cases. The petitioners are directed to cooperate with the investigation. The learned additional SPP to place on record the investigation, progress in investigation on the next date of hearing. Yes, in all serial numbers ಎಲ್ಲ ಕೊಡಿ.
What 45 and 46 of list 2.
ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಆಯ್ತು. ಆಮೇಲೆ
First, this is first list here.
Second list.
Earlier in the. there
Second
was-
list ಅಲ್ಲಿ
Second list 45, 46.
ಎಲ್ಲ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. Tag all these petitions and post them all at 3:30 PM on 10th. Yes.
My lord, proceedings under 138, my lord. Pursuant of the initiation of proceedings, we had filed a joint memo. They have defaulted in payment of the
Yes, sir.
terms.
Joint memo ಯಾವಾಗ ಹಾಕಿತ್ತು?
ಜಾಯಿಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ದು 4/4/2019.
4/4 ಎಲ್ಲಿದೆ ಜಾಯಿಂಟ್ ಮೆಮೋ?
Yes, joint memo at page 57 annexure C.
57.
ಹೌದು. As per this joint memo, the order was passed. That may be seen.
You have signed on the joint memo?
Yes, madam. I am for the company petition number 1 and accused number 3, petition number 2. I am the signatory, madam. Madam, here only question is, this joint memo was accepted. Can FLW and NBW may be issued in the proceedings because the court become punctus official. On that ground, we have challenged it, madam. We are not denied we are ready to pay during the pendency of this case, we have paid 20 lakhs. And I also offered to pay 10 lakhs each instance.
What is the, where is the joint memo?
Yes, madam. 57, madam.
50?
57. Annexure C. As per this, madam, first page, 5 installments are paid, madam. As per this joint memo.
When do you pay the remaining, sir?
Remaining not paid, madam.
When do you pay?
I have filed a memo insisting every month I will pay 10 lakh rupees because what happened, it went in liquidation. I produced all those documents. 3 years it was in, lastly, my lords, the
Company goes into liquidation. Company goes into liquidation. That will not absolve your personal check.
It's not personal check, my lord.
Then what, company check?
Company check, yes, sir. Personal check.
Yes, sir.
I told that principal amount, whatever I agreed, I will pay in installments and paid 20 lakhs. They are telling, no, you have to pay interest. They are finding 1,22,000 interest has to be given on.
Definitely. What can be done?
My lord, earlier, including the interest.
I will revive the criminal proceedings now by my order.
Yes.
I'm going to revive the criminal proceedings. ಎಲ್ಲ ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕಿ ವಿಕ್ಟಿಮ್ಸ್ ಹತ್ರ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡು ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ರೋಮಿಂಗ್ ಫ್ರೀ ಎವ್ರಿವೇರ್ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಟು ನಾಕ್ ದಿ ಡೋರ್ಸ್ ಆಫ್ ಎವ್ರಿ ಕೋರ್ಟ್.
ಫ್ಲಾಟ್ ಇನ್ನೂ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಇದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ, ನಾವು ಏನ್ ಮಾಡ್ತಿದೀವಿ, ಒಂದು ಫ್ಲಾಟ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
I will revive the criminal proceedings, let it go on.
Please, my lord.
That is the order I'm going to pass in all these cases where joint memo ಹಾಕ್ಬಿಟ್ಟು accused walks free everywhere.
ಇಲ್ಲ, ಇನ್ನೂ ಅವ್ರ ಹತ್ರ 3 ಸೆಕೆಂಡ್ ಇದೆ, 3 ಅಗ್ರಿಮೆಂಟ್ ಇದೆ, GPA ಇದೆ. ನಾನು ಹೇಳ್ತಾ
I have already passed one order.
ಅಲ್ಲ, ಒಂದು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅವರಿಗೆ.
If you are paying, pay it, or criminal proceedings will get revived in this. If you breach the joint memo or the settlement that is arrived at and get away with the conviction or the proceeding, you can't, accused cannot roam free.
I am offering that. One flat I will give.
My lord, we are not
It's worth
acceptable
rupees-
to.
If you both sit and settle, no problem. Otherwise, I'm going to revive this.
My lord, no, sir, we are not acceptable to the settlement, my lord.
Whatever, you fight it in the court. The settlement goes.
I will give in 1 week's time. madam.
I will give you a
Yes.
week's time.
My lord, this is what's been happening from past 1 year, my lord.
Don't worry,
They-
sir. Don't take cue from the court's mind. Yes. Just on 19th.
Stay may be kind.
Stay ಇದೆಯಾ?
Stay ಇದೆ.
Just on 19th, interim order subsisting. ಬರೀ ವಾರೆಂಟ್ ಮಾತ್ರ ಅಲ್ವಾ?
How
But we have no
FLW and
objections to
NBW.
allow this petition insofar as the FLW has been issued.
No, wait. I'm on something else. Yes. So and so. List on 19th.
19th.
ಬೇಡವಾ payment?
19th ಬೇರೆ. ಅವ್ನು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್.
18th.
2 ದಿವಸ ನಾನು
22nd.
ಆಗ ಮಚ್ಚ.
ಇದು ಎಕ್ಸೈಸ್ ಆಕ್ಟ್. All Excise Act cases.
Complied with your lordships.
53, 54 complied.
Complied. Record of reasoning put to the rest at the
Good.
time of seizure itself.
Yes, sir. What is your ground? More matter there.
The ground is only that your lordships that the,
53, 54 non-compliance.
please your lordships.
Excise Act ಕೊಡಿ madam.
Since they were traveling in the car with the liquor bottles, your lordships, on Gandhi Jayanti, October 2nd.
On Gandhi Jayanti.
In this, in my petition.
ಯಾಕೆ ಅವತ್ತೇ ಕುಡಿಬೇಕು ಅಂತಿತ್ತು.
9 liquor bottles have been recovered.
9 whiskey bottles.
Liquor bottles.
Liquor.
Whiskey.
What is the permissible limit to carry?
6.1 liter.
How much were you carrying?
9 bottles means,
9 liters.
no, not 9 liters, 750 ml.
1 liter of bottle.
Full bottle and 750 ml.
Hmm.
That comes around 7 liter. 6.75.
6.75. 650 ml ಜಾಸ್ತಿ ಇದೆ. Now you are on 53 and 54.
Yes.
Additional SPP says it's complied.
Not complied, man.
Ah.
After, in Sthala Mahajar also, they have conducted Sthala Mahajar, that they have only stated that,
Your lordships, if
that
they are not,
24 may not be.
if they're not able to secure permission at the time of seizure, they can record and state the reason, because your lordships, they were in
No,
the
no,
car.
that is permissible. I'm not on that.
They have not stated any reason, my lord.
ಎಲ್ಲಿದೆ reason ಇದೆ ಅಂದ್ರೆ?
There's no
Lordships, that
reason.
they will escape from the spot.
No,
And
no,
also there
reason is that I'm not saying that you have to register FIR, go and then seize. They will finish everything and go. That's not the thing. But where is the reason? Reason should be recorded in writing if you want to dispense with registering the crime.
Lordships, it's in their part of the own records, your lordships.
Page?
That Sthala Mahajar in page number 24.
ತಾಳ ಮಹಾಜರ ಅಲ್ಲ,
Sorry,
ಅದಕ್ಕೆ ಮುಂಚೆದು.
that FIR itself is registered.
ಈ ಬೇರೆ ಕೇಸ್ಗಳೆಲ್ಲ ಅವತ್ತೇ ತಗೊಂತೀನಿ ಹಂಗಾರೆ.
In my, in
ಯಾವತ್ತೂ ಹಾಕಿದ್ದೀನಲ್ಲ.
33.3, my lord, there is no record of reasons.
10th.
In 33, my lord,
All
yes,
additional SPPs be ready in
my
there.
lord. In the, my lord, in 33.3, my lord, I filed an application for release of the vehicle, my lord,
ಯಾವ ವೆಹಿಕಲ್ ಸರ್? ಕೇಸ್ ರಿಲೀಸ್ ಆಗ್ಲಿ ಫಸ್ಟ್, ಆಮೇಲೆ ವೆಹಿಕಲ್.
as directed by this honorable court, my lord.
Wait sir.
Filed.
Yes, list on ಏನ್ ಮಾರುತಿ ಸ್ವಿಫ್ಟ್?
Erratica, my lord.
Ertiga. ಸರಿ. ಎಷ್ಟು ಬಾಟ್ಲ್ ಇತ್ತು?
As directed by, 6 bottles, 6 liters.
6 liters ಇತ್ತು.
but-
ಬರೀ 6 liters ಇತ್ತಾ?
Yeah. No, no, my lord, there are 6 people who are, my lord, going. We have produced the purchase bill also, my lord.
ಎಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ರಿ?
We are going to the farmhouse, our farmhouse
Hmm.
at Sakleshpur.
Hmm.
After purchasing the liquors.
ಅದು
from
ಗಾಂಧಿ
the-
ಜಯಂತಿ ದಿನನಾ?
No, 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 my
Oh,
lord.
ಇದು
In-
ಬೇರೆ ದಿನ.
In April, my lord. Before election, my lord.
ಹ್ಮ್.
Before election, my lord.
Election problem. Then we will
No,
release
no.
this vehicle.
Yes, my lord.
ಅದನ್ನ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ? ಕೊಡಿ, where is the application?
Filed an application on
Serial number?
33.3, my lord.
ಅದು ಕೊಡಿ ಮೇಡಮ್. We'll only answer the application. The petitioner has order na ಏನ್ ಮಾಡಿ. The petitioner has filed an application. Stay ಅಂತ ಹಾಕಿದ್ದೀರಾ? Release stayನಾ?
Release of the vehicle, my lord.
For release of stay further investigation. Where is the application?
Another application is not put up, I think.
Madam,
It's a
ಹಾಕಿದ್ದೀರಾ?
separate in-
ಕೊಡಿ, ನಿಮ್ದು ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ. ಹಾಕಿದಾರಲ್ಲ?
22-6.
22-6. The petitioner, the IA number so and so 22-6. The petitioner has filed a subject application seeking release of his vehicle, Maruti Ertiga, bearing number so and so. The petitioner gets embroiled in a crime for the offences punishable under the Karnataka Excise Act 1965. The allegation against the petitioner is that he was carrying 6 bottles of liquor.
6 liters.
6 liters of liquor at the time when the code of conduct was in subsistence. The learned counsel for the petitioner submits that the act permits carrying up to 6.1 liters of liquor in a vehicle, another,
A car, my lord.
in a car. In that light, the vehicle that is seized by the respondent police shall be released to the petitioner on production of
Personal
adequate surety,
Personal bond.
adequate surety and indemnity bond to the satisfaction of the investigating officer. In the event the same is fulfilled, the vehicle be released within 24 hours from its fulfillment.
Surety, my lord, the personal surety, my lord. Bank surety.
Bank surety ಅಲ್ಲ, for surety, yes.
Surety means personal surety.
We will see. ಅದು ಬೇರೆದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದೀನಿ ನೋಡಿ ಮಾಡಿ. Yes. ಬೇರೆ ಯಾರ್ದಾರ ವೆಹಿಕಲ್ ಇದೆಯಾ?
In first case also.
ನಿಮ್ದು ವೆಹಿಕಲ್ ಇದೆ. ಏನು?
Maruti Swift.
What car?
Swift Desire.
Yes. Same order ಅದರಲ್ಲಿ. Serial number?
First one, my lord.
33.
33.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
I have in a prayer column.
ಸರಿ ಆಯ್ತು. ಅದ್ರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಅಂತ ಮಾಡಿ.
3.2, my lord.
ನಿಮ್ದ್ರಲ್ಲೂ ಇದೆಯಾ ವೆಹಿಕಲ್?
ಇದೆ ಎಲ್ಲ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Extend.
Yes, next. This is covered.
Kindly pass over. It's covered by the judgment.
Covered, sir. Pass over. Please. Pass over, but ನಾಳೆ ಅಂತ ಹೇಳಿ ಮೇಡಮ್. ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಹಾಕಿ.
I should have it sometime next week, this matter, my lord. This is the
Departmental
departmental inquiry.
List on 19th.
18th.
Interim order subsisting shall continue till the next date of hearing. Next.
36.
ಇದರಲ್ಲೆಲ್ಲ ಹೇಳಿ. Reason ಇದೆ ಅಂತೆಲ್ಲ ಹೇಳಿ.
Certificate.
Certificate.
Yes.
Let him come. Sandesh Chota was here. Let him come. Nobody is here. ನಾಳೆ ಇದ್ದೀರಾ? ನಾಳೆಗೆ ಹಾಕಿ. No representation tomorrow.
Regarding
36 same. Regarding 36.
ಅದು ನಾಳೆ.
May be connected.
ಪಾಸ್ವರ್ಡ್ ಎಲ್ಲ ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ. ಪಾಸ್ವರ್ಡ್.
It may be connected. It may be connected.
No connection. Wait.
37.
For the petitioner, your lordship. The petitioner belongs to a mutt, your lordship. The investigation papers were to be procured by the SPP.
Yes.
Lordships, the challenge FIR, your lordships.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ?
I'll have to verify your lordships regarding that, but FIR is challenged and matter is still under investigation.
True. Investigation papers I asked you to get.
I'll secure it to your lordships.
The learned additional SPP is directed to secure the investigation papers and place it before the court on the next date of hearing. ಯಾವತ್ತು?
Next week.
10th ಆಗ್ಬೋದಾ? List on 10th interim order subsisting shall continue to the next date of hearing.
Grateful, your lordship.
For petitioner, my lords. Charge sheet has not been filed in the and the petitioner, even before the petition number, respondent number 2 filed a case against us, the petitioner number 2 had filed an NCR. To counterblast that, she filed an FIR in 498
That
case, my
argument
lords.
won't work in this court.
After that also, my lords, she has filed a restitution of conjugal right.
Come to the complaint.
Yes, my lords.
Page 16.
Yes, my lords.
All of you have beaten her.
My lords, even before
Let the
that,
complainant come. Get the investigation papers by then, madam. One additional SPP ಆಗಿದೆಯಾ notice? Why there is delay in 9 months ಅಂತ ಕೇಳಿದೀನಿ. Why delay?
I'll verify.
498 ಅಲ್ಲಿ 9 months ತಗೊಂಡ್ರೆ ಯಾಕೆ?
I'll verify.
Last time you had short time for that only. I've already directed. The learned additional SPP seeks time to comply with the order dated 24/6/2024. ಇದು 10th ಹಾಕ್ತೀನಿ. List on 10th. Otherwise, no case.
petitions.
Case and counter case.
Also.
Hmm.
So I have sustained severe injuries, my lord, and I belongs to scheduled caste. And no offenses have been added in the SC/ST Act, my lord. Subsequently, I have made a representation to the
Add
SP.
ಮಾಡಿದಾರ ಆಮೇಲೆ?
ಮಾಡಿಲ್ಲ.
Permission.
Even an endorsement stating that in annexure J.
Records ತಗೊಂಬನ್ನಿ, we'll see.
As an annexure J.
Learned, same 10th, madam. Additional SPP is directed to secure the investigation papers and place it before the court. As the allegation is, the victim belongs to scheduled caste and the offences under the Atrocities Act are deliberately not added.
Though I have given a representation, it is not considered.
That we'll see, yes. List on 10th.
Next one is, my lord, though he is a victim, my lord. And other two persons, my lord, they are not arraigned as an accused in any FIR. my lord.
ಎರಡರಲ್ಲೂ ಕೇಳಿ.
So 107.
Let the instructions come.
Please.
Yes.
40.
ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಕೇಳಬೇಡಿ.
Passed.
I will adjourn it by 8 weeks. ನೆನ್ನೆನೂ ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ರೆ.
Maybe taken up at 2:30 minutes.
Finally, list the matter tomorrow in the fresh matters list. Yes.
Like execute the investigation officer. The lordship may have it tomorrow, my lord. I'll place all the material.
ಈಗ ರಿಲೀಸ್ ಮಾಡಿ ಮತ್ತೆ. Nothing doing.
Then I'll.
Where is the conditions of,
Lordship have it
where are the conditions of arrest being shown to?
Your lordship have it at 2:30, my lord. I'll place.
2:30 is all right.
Yes.
Yes. ನಾಳೆ ಅಂದ್ರೆ ರಿಲೀಸ್ ಮಾಡಿ.
I'll.
My lords may kindly pass over. My lords may kindly.
Tomorrow.
My lords, there is an urgency in the matter. My
Then you should be here.
My lords may kindly have it at 2:30 minutes. Kindly pass over.
All right. ಅದು ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಮೇಡಮ್. 40 ಪಾಸ್ ಓವರ್ ಮಾಡಿ. 40, 41, 42. ಅಲ್ಲ ನಾಳೆ ಅಂತ ಹೇಳಿದೆ ಅದನ್ನು ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಟ್ಟ ಬೇಡ ಬೇಡಿ ನಾಳೆ ಹಾಕಿ. ಎಸ್.
42.
Yes, sir. What is this? Office objections.
43.
43, alva?
For the R2, my lord, we comply with the office objections in.
Complied?
In a week's time.
Counsel for the respondent seeks a week's time to comply with the office objections qua the statement of objections.
Date may kindly be.
Entry ಮಾಡಿದ್ಯಾ?
Entry ಮಾಡಿದ್ರು.
Yes. List after 4 weeks. Yes.
44.
Furnishing of so and so. Post immediately after, the needful be done in a week's time. Enter ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. In terms of the memo withdrawn.
46.
Post immediately after service of notice upon.
45 with liberty to challenge charge. 45.
ನೀವು ಮೆಮೊಲಿ ಏನ್ ಹೇಳಿದ್ದೀರಾ?
Liberty ಕೇಳಿದ್ದೀವಿ.
ಅಷ್ಟೇ. In terms of the memo. ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಏನು ಮಾಡಕ್ಕ?
Liberty ಇದೆ.
Post immediately after service of notice upon second respondent yaru?
Coming, advocate is coming. Second respondent is complaining. The matter has been already settled.
Settled?
Settled.
2:30.
Compromised. So.
Pass over, 2:30 I'll take.
On the order sheet itself, it's
2:30 I'll take, sir. Not tomorrow, today. Yes.
7.
I appear for the petitioner, my lord.
Non-compliance of office objection. Vacating stay. Who has filed? State.
Respondent, my lord. My lord, office objection may be overruled. First office objection is that we have highlighted bank statements in the.
ಇದೇನಾ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ನೀವು?
My lord, no more.
ಯಾವ್ದದು?
ಅದು ಲಿಸ್ಟ್ ಆಯ್ತು, my lord.
ಆಗಿತ್ತಾ?
ಆಯ್ತು, ನೆನ್ನೆ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡಿದ್ರಿ?
ಸ್ಟೇ ಆಯ್ತು.
ಅಷ್ಟೇನಾ? ಅಷ್ಟಕ್ಕೆ ಇಷ್ಟೊಂದು ಗಲಾಟೆ?
ಮೇಡಮ್, my lord, ಗಲಾಟೆ ಅಲ್ಲ. ಏನಂದ್ರೆ ಪ್ರತಿದಿನ ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ಸಾಹೇಬ್ರು ಇವತ್ತು 600 ಕೇಸ್ ಮಾಡಿದ್ರು ಅಂತ ಬರುತ್ತೆ.
ಅದಕ್ಕೆ ನನ್ ಮೇಲೆ ಅಟ್ಯಾಕ್. ವಾಟ್ ಇಸ್ ದಿಸ್?
ಕ್ಲೈಂಟ್ ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ, ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ಅವ್ರು ಇವತ್ತು 600 ಕೇಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಒಂದ್ ವಾರಕ್ಕೆ 5 ದಿನಕ್ಕೆ 3000 ಕೇಸ್ ಬರ್ತಾ ಇದೆ. ನಮ್ದು ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ?
ನಾಳೆಯಿಂದ 50 ಕೇಸ್ ಹಾಕಿ ಮೇಡಮ್. ಯಾವ್ದು ಹಾಕ್ಬೇಕು?
ಆ ಪ್ರೆಷರ್ ನಮ್ಮ ಮೇಲೆ ಆಗ್ತದೆ.
ಇದು ಸೆಂಡಿಂಗ್ ರಾಂಗ್ ಸಿಗ್ನಲ್ಸ್ ಗೊತ್ತಿರಲಿಲ್ಲ ನಮ್ಗೆ. ನಾಳೆಯಿಂದ ಓನ್ಲಿ 50 ಕೇಸ್.
ನೀವ್ ಹೇಳಿದ್ರಿ ಗಲಾಟೆ ಅಂತ. ಗಲಾಟೆ ಅಲ್ಲ, ಅದು ಒಂದು ಹೋರಾಟ ಆಗಿದೆ ಸ್ವಾಮಿ. ನಿಮ್ಮ ಮುಂದೆ ಲಿಸ್ಟ್ ಮಾಡೋದೇ ಒಂದು ಹೋರಾಟ.
ಎಂತ ಮಾಡುವುದು ಹೇಳಿ?
ಇಡೀ ಕರ್ನಾಟಕದವರು, ಕರ್ನಾಟಕದ ಜನತೆ ಏನಂದ್ರೆ ನಾಗಪ್ರಸನ್ನ ಸಾಹೇಬ್ರ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕು, ಅವರ ಆಸೆ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಅಲ್ಲಿಗೆ ಆಯ್ತು ನಮ್ ಕತೆ.
My lord,
ನಾಳೆಯಿಂದ ಓನ್ಲಿ 50.
ಮೈಲಾಡ್ ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದು ಸಣ್ಣದಾಗಿದೆ, ದಪ್ಪ ಮಾಡಕ್ ಆಗಲ್ಲ. ಅದ್ರ ಮೇಲೆ ಮಾರ್ಕರ್ ನಾವು ಹೈಲೈಟ್ ಮಾಡಿದಿರಿ, ಅದನ್ನ ತೆಗಿಯಕ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ ಹೈಲೈಟ್ ಮಾಡಿರೋದನ್ನ.
ಆಯ್ತು. ಆಮೇಲೆ
ಮತ್ತೆ ಎರಡನೇದೇನಂದ್ರೆ ಕಂಪನಿ ಸೀಲ್ ಬೇಕು ಅಂತ ಕೇಳಿದ್ರ ವಕಾಲತ್ ಮೇಲೆ, ಅದು HUF ಆಗಿರೋದ್ರಿಂದ ಕಂಪನಿ ಸೀಲ್ ಇಲ್ಲ. ಸೊ ಮೈ ಲಾರ್ಡ್ ದಿಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇ ಬಿ ಓವರ್ ರೂಲ್ಡ್ ಮೈ ಲಾರ್ಡ್.
ಆರ್ಡರ್ಡ್. ಆಮೇಲೆ
ಆಮೇಲೆ ಅವರು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗೆ
ಇಲ್ಲೇ
ಹಾಕಿದ್ದಾರೆ.
ಇದಾರೆ.
ಚೆಕ್ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ 2016ರಲ್ಲಿ ಚೆಕ್ ನಂದು ಕಳ್ದೋಗುತ್ತೆ.
ಕಳ್ದೋಗುತ್ತೆ. ಓ ಸ್ಟೋರಿ ಹೇಳ್ತಾ ಇದ್ರ, ಹೇಳಿ.
1/6 ನನ್ನ ಚೆಕ್ ಕಳ್ದೋಗುತ್ತೆ, 2/6 ನಾನು ಕಂಪ್ಲೇಂಟ್ ಬ್ಯಾಂಕಲ್ಲೆಲ್ಲ ಕೊಟ್ಟಿರ್ತೀನಿ ನನ್ನ ಚೆಕ್ ಕಳ್ದೋಗಿದೆ ಅಂತ. ಇವರು 2022ರಲ್ಲಿ ಚೆಕ್ ಎತ್ಕೊಂಬಂದು ಹಾಕ್ಬಿಟ್ಟು ನಾನು 138 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಎಸ್ ಸರ್.
6ನೇ ತಾರೀಕು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಆ ಪ್ರೆಷರ್ ಕ್ರಿಯೇಟ್ ಮಾಡೋದಕ್ಕೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದಾರೆ ಇವರು.
ಓ ಅಷ್ಟೇನಾ ಸರ್?
Time bar date is not a question of passing the entire proceedings.
It's a matter of evidence.
It is a mixed question of fact and law.
ಆಮೇಲೆ
That is to be decided, it is to be decided on full-fledged evidence.
Full-fledged evidence. We'll do it, sir. Yes.
And one more thing is that, that recently Apex Court held that, in so far as the 138 proceedings is concerned, it cannot be quashed in pre-trial stage.
ಕ್ವಾಶಿಂಗ್ ಯಾವಾಗ ಬರುತ್ತೆ? ಪ್ರೀ ಟ್ರಯಲ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಕ್ವಾಶಿಂಗ್ ಬರುತ್ತೆ.
ಅದರಲ್ಲಿ if the so far as the grounds is concerned, in this case, they have taken.
Ready ಆಗಿ tomorrow in the fresh matters list. Be ready, we'll dispose it.
My lord,
Interim order subsisting will continue till the next date of hearing.
Tomorrow,
fresh matters.
Please,
Yes.
Much obliged.
My lord, appearing for the petitioner.
Settlement.
Settlement has already been carried out, my lord, at 5/7, and based on that, decree was also drawn up in the MC, my lord.
Respondent yaru?
Mediation report that they will cooperate with the closing the case.
Should we wait? We'll close it recording this. In 498 ena?
Yes, my lord.
So
498A, 506 and.
I'll leave it. 498A singly will never be there.
Yeah.
504, 506 is there. 504, 506 is like bada badi. Yes. Or matter dispose. Signatures and bada straight away settled and record.
Petition 413 and bail, my lordship. Last time fresh matter list ಮಾಡಕ್ಕೆ ಇದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿದೆ ಹಾಗೆ ಅಂತ.
List the matter tomorrow in the fresh matters list.
ಆಯ್ತು.
Interim order ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್ ಬೇಲ್ ಇದು 413 and bail.
ಇಲ್ಲ 430 ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಾ? ಕೊಡಿ.
ನೋಟಿಸ್ ಆಗಿ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಮೊನ್ನೆ ತಾವು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ನಾಳೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ. Yes. What is that? Fourth time? Second time?
Second time, sir. On the
Fresh matter
parity
ಹಾಕಿ madam ನಾಳೆ.
tomorrow.
Bail matters will close it fast.
Yes.
Mediation ನಲ್ಲಿ
mediation 5th ಗಿದೆ.
ಸೆಟ್ಲ್ ಆಗ್ತದೆ.
Week any date madam.
ಆಗುತ್ತಾ?
Settle ಆಗುತ್ತೆ.
Counsel for the parties would submit that the talks of settlement are at the final stage and would report the settlement on 5th akla?
5th ಇದೆ.
On 12th akla.
12th.
On 12th at 2:30 PM. Interim order substitute.
Interim order is vacated.
Last
Subject to
will
deposit of the
last will extend
2 lakhs rupees, my lord, is not interim order is not there.
Interim order ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ಇಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಇದೆಯಲ್ಲ.
ಅಲ್ಲ, subject to deposit of 2 lakhs rupees. Earlier, my lord.
ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಯಾಕೆ? ಸೆಟಲ್ ಆದ್ರೆ ಆವಾಗ ನೋಡ್ಕೊಂಡು. You should negotiate without fear, sir. And should have never, should not have fear to negotiate. Yes. Non-compliance of office objections.
I am appealing for the respondent. I will comply. Just it is not affixed that stamp on the move.
Interim order ಉಂಟಾ?
ನನಗಿಲ್ಲ. Accused number 3 ಗೆ ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದೇನೆ.
ನಾನು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನ?
ನೀವಲ್ಲ.
ಅಂದ್ರೆ ಮೊನ್ನೆ ಅಂದ್ರೆ ನಾನೇ ಕೊಟ್ಟಿದ್ದೆ. Your ಮೊನ್ನೆ is 3 months.
23 April madam.
ಅದೇ your ಮೊನ್ನೆ is 3 months.
ಮಹೇಶ್ ಕುಂಭಕರ್ಣ ಅಲ್ಲ ಬಿಡಿ ಸರ್. ಮಹೇಶ್ ಕುಂಭಕರ್ಣ ಅಲ್ಲ. ಅಲ್ಲ. ಎದ್ರೆ 6 ತಿಂಗಳು ಮಲಗಿದ್ರೆ 6 ತಿಂಗಳು ಅಲ್ಲ.
He is all 24/7 active.
24/7. Anyway, let me file objection.
Except on weekends.
ಬೇಡ ಅದು. ಬೇಡ ಅದು.
ಸರಿ.
I will file
Yes,
objections along.
same order.
Please.
Take this
Date may
petition
make it
along with sounds.
Because of non-50 bail was granted.
ಈಗ ಏನ್ ಸ್ಟೇ ಬೇಡವಾ?
Stay ಬೇಕು. ಅಲ್ಲ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ lordship can dispose it.
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲರೂ ಕ್ಯೂ ಅಲ್ಲಿ ಇದಾರೆ ಅದಕ್ಕೆ. ಯು ನೋ ದಿ ಪ್ರಾಬ್ಲಮ್.
Very well.
ಎಸ್. ಲಿಸ್ಟ್ 4 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಬೇಕಾದ್ರೆ.
Please.
ಟ್ಯಾಗ್ ಮಾಡಿ 4 weeks ಆದ್ಮೇಲೆ ಡೇಟ್ ಕೊಡಿ. ಎಸ್.
Oblige.
1st August, yes.
Here for the petitioner.
R3, sought for vacating of stay. Last time it was a
could you-
311 application.
311 application that I had filed.
50?
52, my lord.
ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು ಹಾಕಿದ್ದಾರೆ.
We'll hear it. 311 application.
311 application, my lord. Tahsildar.
Is
summon
only
ಮಾಡಿ, cross
what
ಮಾಡಿ.
they have tried to, in fact, the application was preferred by prosecution.
Hmm.
They are the first informant, son, first informant is no more.
Hmm.
Now they want to examine Tahsildar.
Hmm.
The impugned order, or it is my case that I am not disputing the fact what they are trying to bring. The allegation is,
ಮತ್ತೆ ಹಾಕ್ಬೇಕು ಅಪ್ಲಿಕೇಶನ್?
My lord,
I will record this and
Well, if
close
that is
it.
the case,
that is what it is cited in the impugned order also.
let it be recorded.
Okay,
My lord, another issue.
Stay
is, my
ಆಗಿದೆ
lord,
ಇದು?
Stay
stay ಆಗಿದೆ. Another issue is, my lord.
where there is a
Tahsildar-
direction also by this court itself, 6 months ಅಲ್ಲಿ dispose ಮಾಡಿ.
ಅದು 2014 ಇರ್ಬೇಕು ಡೈರೆಕ್ಷನ್.
ಇಲ್ಲ ಇಲ್ಲ,
Yeah,
direction
recent
of
ಇಲ್ಲ.
last year,
Direction.
last year July.
My lord, one submission.
He is saying he is not disputing what you want to bring on record.
Indeed, my lord.
I will record that. It's over.
And also, my lord, respondent number 4, who was not present before who did not face trial at all before the trial court. Now he has come and he has filed a wakalat, my lord. Let there be a direction, let him come before, let him appear before the trial court.
ಯಾರು?
Let him face trial.
ಯಾರು accused number 4 ಯಾರು?
Accused number 4 is Ramesh Reddy.
Where is he filed ವಕಾಲತ್ನ?
They have filed wakalat.
Why did you make these people parties here? Because you have filed, made these people party, why should you need co-accused as party, sir? You are the complainant.
In fact,
Anti-complainant,
against
my
him,
Sorry, yes.
split up charge sheet ಆಗಿದೆ.
Split
He
up
is not at
ಆಗಿದೆ.
all required.
After that, my lord,
ಈ
he
case
has
is
not
ಸುಮ್ನೆ drag
faced trial
ಮಾಡಿದ್ದಾರೆ.
at all. He was absconding, my lord, since the
That
trial
he will
started.
take recourse to law. I will not observe anything in this. Let him avail such remedy as available in law. But insofar as this is concerned, I will say he is not disputing what you want to bring on record. Over.
My lord, and also, my lord, if once the Tahsildar comes and produces that record, my lord, that will.
He is not even
conclusively-
disputing that record. Why do you want somebody to say that?
That-
He is admitting that record. I will record his statement here and you continue with the trial.
Very well.
Yes. The petition is preferred by the complainant.
Complaints,
Complainants,
complainant's
son.
son,
Petition is preferred by the children of the complainant. Son obrena?
Ibru.
By the children of the complainant, calling in question an order dated 6/2/2024 by which the application filed under section 311 by the complainant comes to be rejected.
Allowed in part.
Allowed in part, huh?
There.
Allowed in part. What is that allowing in part?
One, they sought for examining himself, the petitioner.
That is allowed.
That is allowed. Insofar as examining or
Tahsildar.
summoning
The
Tahsildar,
summoning the Tahsildar was rejected.
Allowed in part. The concerned court answering the application filed by the present petitioners allows it in part by permitting examination of the complainant himself, further examination of complainant himself, and rejects the summoning of the Tahsildar for further examination, for
For
examination,
examination.
for examination.
And also production of documents.
1 minute, further examination. This Tahsildar is sought to be summoned by these petitioners to examine or to mark a document through him. The learned counsel appearing for your respondent.
R3,
For the
And-
third respondent would submit,
sole accused facing the trial.
third respondent would submit, third respondent, the sole accused who is now facing the trial, would submit that he would not dispute that document itself.
It's
He
already
is,
marked as exhibit
1
P3
minute,
and
exhibit?
P3 and P4 is already been.
He would not dispute that document, but in fact would admit the document which are produced as exhibit P3 and P4 before the concerned court. With this admission, the grievance of the petitioner is undoubtedly alleviated. In that light, I deem it appropriate.
May I
to-
make a small submission?
ಹೇಳಿ sir.
My lord, what I'm calling in question is a document, my lord. It's a record
that record is with the Tahsildar. I am summoning that record itself to be produced. My lord, conclusively prove
For what purpose?
to show, my lord, that there is no entry with respect to such that mutation which I am disputing, which has been fabricated.
No, he's admitting there is no entry.
My lord, let it come on record to say that it is.
No, he is
let it
admitting
admit
that-
it is being fabricated.
He's admitting that, sir.
Well, what I am saying is, my lord, it is been fabricated.
That you
That
try
record-
there. Yes.
That record has to come.
Why Tahsildar Act bada?
Exhibit P, page 134.
No, is that
One
exhibit P3 and
I'll
P4?
clinch the issue. I will
I'm
clinch the-
calling in.
Which is
question.
that document?
It is with him, my lord. The record is with him.
Where is the
Page
averment?
134, if it is seen for a moment.
Where is the averment for that?
Page 134.
130?
4. This is the MR extract. What they say is that it has been created document.
This is fabricated.
My lord,
Page 120, 136, if it is seen. This MR, which numbers as 6/8687 and 8. And there is an endorsement which has been issued at page 136
Who
by
has
the
issued?
Tahsildar office, which says for that relevant period, the entries have stopped at 3/8687.
Let him come and say that.
No. The endorsement is already been given by Tahsildar office.
Let him come and say that. So what?
No, if.
Hello, what
the-
heavens are
I'm
going to
not
fall?
disputing this. I'm not disputing this
No, he
endorsement.
wants to prove it that through the Tahsildar, the document that he has given.
This endorsement which has been given based on the
If
record.
it doesn't dispute the endorsement, then what's the position?
my lord,
Again, you want it?
I'm calling in question the mutation register, which is with the Tahsildar's office. That has to be produced to conclusively prove my
What's the
case.
problem?
That
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ ಅದ್ರಲ್ಲಿ?
they want to drag it. That's why it's a civil
No, I
dispute.
will,
I'm
I
only
will
a
fix one day for examination of the Tahsildar
Correct.
and cross-examination, whatever it is, and
Yes.
close.
Please, one particular date, my lord.
One
And
particular-
because, no, one another aspect.
Ah.
Because earlier on the last year when the petition was disposed, the time was fixed. The time was already ended in month of February. Even then they came up with this application. We said unnecessary.
One day I will fix
They are
because there is
dragging
an
on
order.
or the other reason.
No, it can't be a ruse to drag it on.
Please.
Yes.
2012 charge sheet,
Even-
please.
And I will direct the trial also to conclude.
Please,
Very well.
Yes.
please.
The petitioner is before this court. Petitioners, madam, redo ಮಾಡಿ. The petitioners are before this court calling in question an order dated 6/2/2024, whereby the concerned court partially allows an application filed under section 311 of the CRPC to recall, to further examine the complainant himself and the examination of the Tahsildar. The
Bangalore East Taluk.
Huh?
Tahsildar, Bangalore East.
Tahsildar, Bangalore East. The petitioners claim to be, heard so and so, petitioners claim to be the children of the
Original complaint.
original complainant. You are GPA holder, original complainant.
Only since he is no more.
And the
they-
complaint, when did he die? A private complaint comes to be filed in PCR 118 of 2011, and the learned magistrate, having referred the matter for investigation, investigation results in the crime being registered, and investigation leads to filing of the charge sheet against against the accused in CC 2811 of 2012. The learned counsel appearing for the petitioner submits that the Tahsildar has issued an endorsement with regard to the mutation register, the non-availability, na? With
Non-availability.
regard to non-availability of the mutation register at the relevant point in time. Based upon this, the learned counsel for the petitioner submits that he wants to confront the Tahsildar as the mutation registers that have now been produced or which forms the subject matter of the crime are all fabricated ones. To ward off the said fabrication or to buttress the said fabrication, he wants the Tahsildar to be examined in the proceedings. The petitioner would therefore file an application under section 311 of the CRPC, seeking his further examination and the examination of the Tahsildar.
Not the petitioner. It is the prosecution which fails. Petitioner is not the applicant before that.
Sorry, the prosecution files application seeking further examination of the complainant, of the complainant's children, and an application seeking and the summoning of the Tahsildar. That is partially allowed by permitting further examination of the complainants and not the Tahsildar. It is therefore the petitioner is before this court. Therefore, Beda, Tahsildar. The reason rendered by the concerned court too, where is the order? Impugned order.
175.
170?
5. One seventy-five onwards.
175.
231 is the.
175.
175.
Adalla.
This is the order, 6/2/24 order.
6/2 idena?
Howದು? Application comes to be filed on the very same day, objection comes to be filed on the very same day, order passed on the very same day.
No, you shall not trouble the Tahsildar saying that you should know all that. He
No,
has
my
given
lord.
the endorsement, he will only speak.
I'm seeking for him to produce a register which is in his office. Which is a non-existing according to. Mutation register, my lord, will clearly say, my lord, the mutation ended at number 3 on that day, in that year.
If it is an impossibility, then this
No,
court
my
will
lord, it's
not
not an
impose.
impossibility. I'm only seeking for the register for the year 1986 to 87 to be produced.
Have
which
you
is in
not,
their
have
office.
you not sought it in by other means before
No,
the? Why?
My lord, they have given me an endorsement that it has ended with.
Then
serial
what
number.
will he come and speak?
Now he has to produce the register before the court. That's all.
What register?
Mutation
He has
register.
issued an endorsement that it is closed, no register is maintained. Now what will he come and say?
My lord, he has to produce the register.
Yes, he has said register illa anta.
My lord,
Endorsement nodidira?
Indeed, my lord.
Endorsement ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ರಿಜಿಸ್ಟ್ ಮ್ಯೂಟೇಶನ್ ದಾಖಲೆ ಇರುವುದಿಲ್ಲ, ದಾಖಲೆ ಪ್ರತಿ ನೀಡಲು ಆಗುವುದಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಮ್ಯೂಟೇಶನ್ ದಾಖಲೆಯಂತೆ 86, 87 ಗೆ ಕೊನೆಗೊಂಡಿದೆ. ಏನ್ what will he produce?
The register, my lord, is.
ಇಲ್ವೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ. Entries ಇಲ್ಲ, it's not there at all. Register itself is not there.
Now, if that is the case, my lord, let them say that it has been fabricated. My case is that, my lord, it has been fabricated. If he comes and produces the register.
ಯಾವಾಗ ಸೇಲ್ ಆಗಿದ್ದು?
94 transaction, 2011 PCR, 2009 they suffer a civil suit.
ಅದಷ್ಟೇ ಸಾಕು.
My lord, at that time, my lord, this, it has already.
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
Challenge ಮಾಡಿದ್ದಾರೆ, twice it has been challenged, twice it has gone back.
Facts. In fact, earlier your lordship had given a stay saying that it is covered. They allege that a document which is produced to the court that is been allegedly fabricated by.
No, not that much.
That is what.
That is
earlier
not
your
what, that
lordship
is.
had given a stay in the earlier matter.
We discovered that it was a document which was, it was fabricated at the
Whether
time of.
Tahsildar has to be bought or not, what's the use of it? We'll continue in 2:30.
Please.
Yes. ಕರ್ದ್ಬಿಡಿ ಮೇಡಮ್, ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಮೆಂಟ್ ಅಲ್ಲಿ.
Page wise adjournment. Page 7, 52 to 56, page 8, 7 to 6.
My lords, item 67, my lords. My lords, I'm in some personal difficulty in the. 67, my lords. I'm in some personal.
Respondent ಹೇಳಿದೀರಾ?
I'll inform my lords. Could I request for day after, my lords? There's some urgency in that.
66.
1 minute. 67 I'll finish.
There's some.
At the request of the counsel for the petitioner, inform.
I'll inform. My lords, could I?
ತೊಂದ್ರೆ ಇಲ್ವಾ?
Day after.
ಅಲ್ಲ, ಯಾರು ಮೆನ್ಷನ್ ಮಾಡ್ತಿದ್ರೆ ನೀವು ವರಿ ಮಾಡಬೇಡಿ, petitioner ಮೆನ್ಷನ್ ಮಾಡ್ತಿದ್ದಾರೆ. Yes, connected, you are the petitioner. When do you want?
So, my lords, case counter case, my lords.
22, list on Tuesday ಹಾಕಿ ಮೇಡಮ್. 16th.
My lords, interim order to.
Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order subsisting shall continue till the next date of hearing.
Great.
Yes.
Lot 66. The parties are seeking settlement. They're discussing. Short date may be given. for this.
Parties are seeking settlement, you are seeking adjournment.
Yes.
All right, yes.
56.
At the request of.
56. 1 week time.
ಒಂದು ನಿಮಿಷ ವಾಪಸ್ ಹೋಗ್ಬೇಕು, wait.
Respondent.
66 to report settlement on 19th. Yes.
Mashu.
Next page.
Page 10, 71 to 77, page 11, 78 to 84. Page 12, 85 to 91, page.
80?
Page
Hmm.
13, 92
ಒಂದು
to
ನಿಮಿಷ
98.
86 ಏನು?
I am for the respondent number 2 complainant, my lord.
No problem.
I am for the respondent number 2 complainant, my lord. I seek time to file objections. my lord.
ಆಯ್ತು. Learned counsel for the respondent seeks 2 weeks time to file statement of objections. List after 2 weeks. Entry ಮಾಡಿದ್ಯಾ? Yes, list after 2 weeks. Next.
Your Honor, item 55, excuse me, Your Honor.
Wait, I have to come back. Yes.
Page 13, 92 to 98.
Hmm.
Page 14, 99 to 104. Page 15, 105 to 110.
Yes. What is it?
Serial number 15, my lord. Request the lordship to post it on serial number 15, a first list. I posted on Thursday. So request the lordship to post on Friday. I'll inform
All
the
right.
secretary.
You tell that council lady.
Obliged.
whoever- Yes.
Serial number
54. 54. ಏನ್ ಬೇಕು? ಮಾಡ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ. ಸ್ಟೇ ಇಲ್ವಾ? ಮತ್ತೆ ಬಿಡಿ. ಎಸ್.
My lord, 56.
Serial number 114, my lord.
ಹ್ಮ್.
Reporting for settlement ಹಾಕೊಂಡಿದ್ದು, my lord, parties ಬಂದಿಲ್ಲ, my lord.
ಬಂದಿಲ್ವಾ? ಆಮೇಲೆ ಹೇಳಿ, ಕರೆದಾಗ ಹೇಳಿ.
My lord, 56.
ಹಾ ಹೌದು, ಹಾಕಿದಾರ? ವೆರಿ ಗುಡ್. ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ. ಎಸ್.
My lord, one submission, my lord.
Your matter,
Yes, ma'am.
I was to do it today. I'll probably Thursday. Tomorrow there is bench. Thursday we'll do it. It's
Great,
ready.
Great.
I told her that I'll do it
Yes,
today. Yes.
My lord, list 2,
My
serial
lord, 56,
57,
One
order
more
was
time.
passed to be withdrawn with liberty to file. If a direction may begin for return the originals, my lord.
Definitely.
Sure.
ಅದರಲ್ಲಿ
My lord,
return the
serial,
original documents. Help ಮಾಡ್ತಿರಲ್ಲ?
my lord, cause list to serial number 12, my lords. I have completed all the office objections on 24/6, my lords. Kindly it may. be
ಏನಾಗಿದೆ
over.
ಮೇಡಮ್ ಅದು?
List 2.
Cause
Serial number
list to
12 is
serial
second.
number 12.
My lord, 56. 1 week time. Non-compliance of objection.
You have complied?
Yes, my lords, on 24/6.
Learned counsel submits, office objections have been complied with. In the event they are complied, list the matter on 8th in the fresh matters list.
Much obliged.
My lord, 56.
ಏನು ಸರ್?
Non-compliance of subject.
ಏನಾಗಿದೆ?
1 week time.
Huh?
1 week time.
ಒಟ್ಟಾಗಿದೆ. Yes.
My lord, serial number 53, my lord. I'll undertake to file wakalat.
ಯಾವ್ದ್ರಲ್ಲಿ sir?
53, my lord.
In which list?
Serial number 53, my lord. First list.
Awaiting. Learned counsel so and so undertakes to enter appearance for the second respondent. Registry to print the name of so and so appearing in second respondent. List the matter on Friday in the fresh matters list.
Your Honor,
Criminal petition 5952, yesterday listed and it is posted today, but today not listed.
ನಾಳೆ ಬರುತ್ತೆ. Yes. ನೆನ್ನೆ ಹೋಗೋದು 6 ಗಂಟೆ ಆಗಿತ್ತು. ಏನಾಗುತ್ತೆ? Yes.
Your Honor, serial number 55.
What do you want, madam?
Reporting settlement and the petitioner and the respondent, they're available on video conference.
Huh? What is the offense?
406, 408, sorry.
Okay, we'll see. 2:30.
30.
ಇದೆಲ್ಲ ಕೇಸ್ ಹೇಳಿ.
On
Apologies
Monday,
rejected.
my lords, your
Yes.
lordship, kindly hear me.
Tell me, ma'am.
On Monday, my lords, a matter was listed before your lordships. Your lordships was pleased to stay the matter on the grounds that connected matters are stayed and tagged along, to be tagged along with
Alright.
those matters. My lords, this morning we've received the order copy. My lords, the order of stay is not forthcoming in the
Very
order.
tagging
copy.
idea.
Please, my lords.
Yes.
My lords may kindly have it on.
Which serial number?
My lords, it
On
was
Monday.
listed on
Monday is
Monday.
yesterday,
No, my lords, on 24th.
24th.
Please, my lords. I'll hand over the serial number and the details.
List number
Grateful.
2.
My lords,
serial
date,
number
my lords.
58 permitted to withdraw.
First, let me see what is the order. I'll get it.
Please,
posted.
please.
Milords, one submission, Milords.
ಯಾಕೆ ಇಷ್ಟೊತ್ತಲ್ಲಿ?
ಇದರಲ್ಲಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಮೆಮೊ ಕೊಟ್ಟಿದೆ.
ಹಾ.
ಅವ್ರು ಅಫಿಡೇವಿಟ್ ಕೂಡ ಹಾಕಿದ್ರು.
ಹ್ಮ್.
ಪೊಲೀಸ್ ಕಾನ್ಫರ್ಮ್ ನೀನು ಹೈಕೋರ್ಟ್ಗೆ ಹೋಗಿ ರಾಜಿ ಮಾಡ್ಕೊಳಂಗಿಲ್ಲ. ನಾನು ಹೇಳಿ ಸೈನ್ ಖಾಲಿ ಬ್ಲಾಂಕ್ ಪೇಪರ್ ಅಲ್ಲಿ ಸೈನ್ ತಗೊಂಡು ಎದುರಿಸ್ಕೊಂಡು ತುಂಬಿದ ಗರ್ಭಿಣಿ 8 ತಿಂಗಳು.
ಪೊಲೀಸ್
ಪೊಲೀಸ್
ಜಗದೀಶ್ ಪೊಲೀಸ್ ನ್ಯೂಸ್. ಇಲ್ಲ ಪೊಲೀಸ್ ಸ್ಟೋರಿನ ಹೇಳ್ತಾ ಇರೋದು ಅವರು. ಅವರೇ ಸೆಟಲ್ ಮಾಡ್ತಾರಂತ. ಪೊಲೀಸ್ ಸೆಟಲ್ ಮಾಡ್ತಾರಂತ.
ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಸೆಟ್ಲ್ ಆಗ್ಬೇಡ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ.
ನೀನ್ ಹೋಗಂಗಿಲ್ಲ ಅಲ್ಲಿ, ನಿನ್ ಗಂಡ ಇದ್ರೆ ಅದೆಲ್ಲ ಇಲ್ಲ, ನೀನ್ ಮದ್ವೆ ಆಗಿರೋದು ಮೈನರ್ ಹಾಗೆ ಅಂತೆಲ್ಲ ಎದುರಿಸಿ ಥ್ರೆಟ್ ಮಾಡಿ ಸೀದಾ ಕಳ್ಸಿ. ಅಫಿಡೇವಿಟ್ ಎಲ್ಲ ನೀನ್ ಅಲ್ಲಿ ಹಾಕ್ಬೇಡ, ನೀನು ಹೋಗ್ಬೇಡ.
ಯಾವ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇದು?
ನಂದಿನಿ ಲೇಔಟ್ ಪೀಸ್.
ಬರಕ್ ಹೇಳದ? ಎಸ್. ಮ್ಯಾಟ್ರ್ ತಗೊಳ್ಳಿ ನಾಳೆಗೆ.
Lord, serial number
Obligement.
58, my lord, list number 2 is discharged from charge, your honor.
Disposed.
Permitted to withdraw.
Yes, sir. Withdraw in terms of the memo. Serial number 50?
58.
ಬರ್ಕೊಂಡ್ರೆ ಮೇಡಮ್ ಅದು?
Okay.
Yes, Jagdish, look into it.
Yes.
Why police is showing overindulgence? Hoaxo. ಅದಕ್ಕೆ ಇಲ್ಲಿ ಹಾಕ್ಬೇಡ ಅಂತ. If the statement is correct, then.
I'll check, my lord.
Yes.
I'll call me.
Yes. ಇದೇನ್ ಮಾಡಿದ್ರಿ?
Yes, my lord. We
Pass
got
over
the-
ತಗೊಳ್ಳಿ.
Yes, my lord. We got the, I got the entire case file. The issue, my lord, is that he claims that he is not the director of the company, which is right. He's resigned from the company in 2016.
Yes.
We are not prosecuting him as a director.
All right.
But issue, my lord, he has the permanent office in the head office, chamber in the head office, where he operates and he uses the official, the phone which belongs to Attica Gold, which is activated in 2019, and he continued to use the same phone from 2019. More importantly, my lord, Kavita is the one who manages the entire show. Kavita is an employee of the Attica Gold. There are about 1,300 page call details with respect to Kavita and the Babu, and also the accused number 3 in connection with this particular case. The modus operandi, my lord, that every case he has improved his operations. If he come to know that we are prosecuting him as a director, he removes it and puts his wife and daughter. When we went after his wife and daughter, he removes them and put it somebody else. But ultimately, show is managed by him. Each time when he was picked up, gold have been given to police in connection with that crime. If you're not picked up, gold has not been given to.
So you mean to say it is stolen gold?
It is stolen gold. And in fact, my lord, on Telangana, he has multiple cases. In Telangana, he is police have recovered large amount of gold from him, where they arrest him, and then I've been told, my lord, in Telangana he has an about 85 cases.
No, that's now all right, but arrest has to have some
Arrest is based on
reasons for arrest. You'll have to give it to him. You have not given it to him.
No, we had given.
Where is it?
He signed the arrest memo.
Where is it?
I'll place that memo. He signed the arrest memo.
ನಿನ್ನೆ ಪ್ಲೇಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅದನ್ನೇ ಹೇಳಿದ್ ನಾನು. He says nothing is known.
He says, my lord, he also says that the remand application not produced before the magistrate, and magistrate passed an order without remand application. That's what his submission.
Yes, yesterday he said so.
Your lordship may see the remand application, remand order passed by the magistrate. Is he now saying that the
He
magistrate?
said, Tahir said you only appeared, no?
Yes, I only appeared, Lordship. Lordship, immediately after order was passed in 5:30, we had requested the court to grant a certified copy.
Yes, I
Court has sent the file, court sent the file to the copy branch. I was there in the copy branch. I verified the file, all the document I have taken it. Either maybe that point of time, the remand must be there either in the chamber of the judge, or maybe might have placed in the morning, next day morning. That is only.
Placed it later.
Maybe was not there in the file.
All right.
My lordship may see page
But what do you say about the crime? So many things.
My lordship, kindly see, Lordship, kindly see. I will just confine my argument this crime. Other crime I will answer also. But
Yes.
just start with this crime, Lordship. Kindly see the FIR is there in page number 18.
Yes.
It is registered on
Now,
crime.
two things are clear. Now, remand application is here. And the reasons for arrest memo, you have,
No, it was not served to him, Lordship.
He is
It was-
signed. I have the copy.
Yes, at the time, in the station, if he signed or while taking to the court, he be signed, that will not be considered as a, at the time of arrest.
reasons for arrest, prior to arrest, you should give it.
While going a police.
Would that not vitiate?
He is now challenging the remand order, saying that I am no more a company
Yes,
director.
I will
lacking
confine
power.
to that only.
You
I'll
confine to
confine
that.
others.
I'm,
But that is how, because I have taken a specific ground, why I have been implicated. I have taken, for that reason, I need to demonstrate few things. Lord.
Okay.
Kindly see the page number 18 is the FIR. Crime is happened on 20th and FIR registered on 21st, Lordship. Lordship, kindly see the next page, the description.
No, crime is registered on
20th December 2023 and crime is registered 21 December 2023. Crime actually has happened on 2023, 1 day before it is happened, Lordship.
Yes.
Next page is the page number 19, Lordship. See the property, Lordship. It's a 10 gram gold.
Where?
Next page, page number 19, 10 gram.
Page number 19.
Page number 19, column number 8. So admittedly, it's a chain
That's-
of 10 gram.
Property description, 10-gram gold
Gold
chain.
chain. Admittedly, it's a 10 gram gold chain.
Uh,
Admittedly, it's gold in it. My learned friend has also produced certain document is also there with him. They seized 91 gram gold from the Attica company.
91 grams.
91 gram gold they already seized. Yesterday they have seized, 2 days before maybe 91 gram for the complaint of 10 gram. This my learned friend has demonstrated some modus operandi. I also will demonstrate some modus operandi in respect to the police action, Lordship. Now, Lordship, kindly turn to the page number 84. This is the remand application of accused number 1 and 2, Lordship.
Accused number 1 and 2 yaar.
Accused number 1, who is the real culprit, actually. Page number 84, annexure K, Lordship. This particular remand application was placed before the court on 28/6/2024.
Page?
Page 84, Lordship. Annexure K. Second last page must be.
84.
84, annexure K, Lordship.
Yes.
This is the remand application of accused number 1 and 2, Lordship.
Attica gold and white
Attica gold and white gold Angadigaru.
All right.
2 people were there. Okay. Then 10 gram gold fact is also mentioned in the last line.
Yes.
Then Lordship, kindly turn to next page, Lordship. The second para, Lordship. 5th line from the down, Lordship. Obba Mahilaru ಕಿತ್ತುಕೊಂಡು ಎಂದು ಚೆನ್ನೈನ ಚೈನ್ ಅನ್ನು ಕಿತ್ತುಕೊಂಡು ಹೋಗಿ ಅಟಿಕಾ ಗೋಲ್ಡ್ ಮತ್ತು ಗೋಲ್ಡ್ ಕಂಪನಿ ವೈಟ್ ಗೋಲ್ಡ್ ಕಂಪನಿ ಕಡೆಯಿಂದ ಮಾರಾಟ ಮಾಡಿ ಬಂದು ಹಣವನ್ನು ಖರ್ಚು ಮಾಡಿಕೊಂಡಿರುತ್ತೇವೆ. So these fact he is stating on 26/6/2024 doing police custody, Lordship. There is no reference of dates, which date he has sold and to which company he has sold that one gold. It's the only admittedly there is a 10 gram gold chain was there. Now, Lordship, kindly refer the remand application. My learned friend have produced it. Otherwise, I'll place it before the honorable court. This is the remand application of accused number
4.
3 and 4, Lordship.
3 and
3 and 4.
All right.
Now, Lordship, kindly turn to next page, Lordship. Page number 3, Lordship. Page number 3 of the remand application.
It's remand.
Yeah, remand application. Notice later the year which you are supposed to produce. 29/6/2024.
ಪ್ರಕರಣದ
Remand
ನಾಲ್ಕನೇ
application number 3 and 4.
ಆರೋಪಿ
Yes, Lordship. Here, that page first para, Lordship. ಕರೆದುಕೊಂಡು ನಾವು ಹೋಗಿದ್ದು ಆರೋಪಿಗಳನ್ನು ಗುರುತಿಸಿ ದಿನಾಂಕ 18/4/2006 ರಂದು ಸದರಿ ಆರೋಪಿಗಳನ್ನು ಸೆರೆಗೆ ಸಂಬಂಧಿತ ಚಿನ್ನದ ಚೈನಿನಿಂದ ತೆಗೆದುಕೊಂಡು ಬಂದಿದ್ದು ಅದನ್ನು ನಮ್ಮ ಅಟಿಕಾ ಗೋಲ್ಡ್ ಕಂಪನಿಯಿಂದ ಮಾಲೀಕರಾದ ಅಯ್ಯೂಬ್ ಅಲಿಯಾಸ್ ಬೊಮ್ಮನಹಳ್ಳಿ ಬಾಬುರವರಿಗೆ 3,18,000 rupees. So 10 gram gold is sold at the cost of 3,80,000 rupees according to their own statement. It is 18/4, Lordship. Now, Lordship, kindly see the next para, Lordship. There is a statement of A4. According to them, after arrest, they have recorded statement. Then it is date is given 18/6/2024. So, and then subsequently, when they have taken him to the custody, they seize the 91 gram gold, Lordship. And there is no further statement is recorded in respect of the quantity of the gold. Or it is not the case that she has given a wrong statement and some others So in one crime, Lordship, and this crime is happened in December 2023. Then investigation has happened in 26/6/2024. After 6 months, nothing has happened, Lordship. All the cases which is in which I am referring, or maybe the police are waiting, all the cases registered 2023. All the cases investigation start from June after the completion of election. And the reason specific that. And now my Malayan friend said that there is one lady who deals handle the matter, Kavita, and she has several calls. Lordship, admittedly, he is an investor of the company.
Investor.
He is an investor. He has
Who?
that A4, the petitioner hearing. He is an investor. He is not a director. Director, manager, both are they have a different responsibility. He is not into the day-to-day affair of the company. Company is having a 300 offices in 4 states: Andhra Pradesh, Telangana, Tamil Nadu, and Kerala. We entertain more than 30,000 customers every month. Every month we entertain more than 30,000 customers. And there is a chances, because we take all the precautions. Company takes all the precautions to eradicate this kind of transactions. But in spite of that, some transactions comes, some transactions get mixed. And in spite of that, we inform the police and all. But every time what has happened is, Lordship, police always demand excess gold. That is the tendency of the police. In this case, 10 gram it has started. They have seized 91 gram gold. That is the tendency. And Lordship, a crime has happened sometime 6 months before. They come, they sold. It is not that we are regular course, we are buying it. We hardly, out of 3,000, maybe 2, 3, 4, maybe in a month, if comes. We take all the precautions. We take all the KYC details. Most of the time, the thief does not sell it himself. He sells it through his relatives, his wife, or any other persons. After 4 or 5 years, after 4 or 5 months, police comes and demand the gold. That time he does not have a gold. They insist to give another gold, alternative gold. Alternative the gold they insist. When they refuse that, they do this kind of tactics. And in this stage, what has happened in all the cases, all the 47 cases, whichever the always the case was this, at the instance of Mr. Babu, this particular case was happened.
No, all 47 cases are quashed.
There are 47 cases were quashed, Lordship, all in this. Lordship, there is I have a details of the cases where the accused himself has admitted he has sold gold to somebody else. In this case, so white gold. There is no investigation, Lordship, will find in respect of white gold. Not even an iota. I have a cases, more than 10 cases where accused himself has admitted that he has sold the gold to somebody else. Even police has recovered the gold, did the Mahajar. In spite of that, Attica Gold was a company, was a made accused person. Even Babu was specifically made accused person. There is a discrepancy in both the ends. We are not coming in the way of investigation. We are not saying that quash the case in respect to A3, stall the investigation, Attica Babu. Only my contention is that, Lordship, he is already resigned. He may have a relationship with the company. I am not denying that. He is not having a relationship. But he may be as an investor. Or maybe initially he was promoted the company. But for that reason, for every case, and they are doing it just because they wanted to extract the. And for what instance they are doing it, I really don't want to disclose it before the court. So these things has to be considered, Lordship. And more importantly, in this case, more importantly, this which is more important and shocking, Lordship has passed order on 28th. 6 o'clock it was served to the magistrate as well as the police. He didn't release the accused person there. He sent him to the judicial to the jail. Jail person did not release him. They kept him in the whole night. 6 o'clock, they facilitated the arrest of by this police. In that case, of the fact is like that. Only 40 grams were there. They were demanding 500 grams gold.
May place these.
That's all right. I will look into it. When I passed an order at 6 o'clock, why he was not released?
No, that is.
Why he was not released on the day that I directed the jail authorities to release him?
No, that I'll take instruction.
What instructions every time? This is not going to.
No, that is.
I have passed an order of release immediately after receipt of the copy. It is at 6 o'clock. Why he was not released and detained the whole night there?
That's a separate cause of action.
No, that's all right. No, not a cause of action. It is violating the order of the court.
Yes, my lord.
Then what is cause of action there?
If it is, that is an issue, my lord. I am now answering.
You answer anything. First, this I will come to this.
Yes, my lord.
First, I granted him an order and asked him to be released immediately. Why was he not released at 6 p.m. on that day?
No, that I.
Why was he not released? Answer I want.
No, that I.
That will be the reason for directing him released now.
No, that may make one submission.
Because you have held him the whole night without an order, despite the order of this court, I am going to release him now.
That may make one submission.
No, sir.
No,
you can't blow hot and cold or play hide and seek here.
No, may make one submission, my lord.
Yes, sir.
I have not taken instruction with respect to why he was detained in that night.
whatever it is. He is detained.
No,
He is detained.
I'm not sure, my lord, because I have to ask, my lord, the
That is his
concerned authority.
submission.
No, the
How, from where was he picked up?
Remand application it is mentioned.
From where was he picked up the next day in the next case?
He was picked up from outside the prison.
Where? Outside the prison.
Jail.
Why was he outside the prison?
When he was released from the prison, he was
When was he released from the prison?
early morning 8:30.
Why? That night, why was he not
No,
released?
that I have to ask the prison authorities. Prisoner, I have to ask the
Police
prison
custody. That point of time he was in police custody when the order was served.
Not judicial
He
custody.
was in police custody.
Why was he not released from police custody? He was in
authorities.
police
He was
custody.
in judicial custody, I've been told.
Lordship,
He was in police custody. He was sent to judicial custody. Why? Despite my orders.
remand of the.
I've been told, my lord, the magistrate has remanded him to judicial custody because another UTP was pending against him. And then from there, next time,
When was the order passed by the magistrate?
I'll place all those
When
materials.
was the order
There
passed?
is- After that, when it was served to the police person, they take him to the magistrate. We requested the magistrate, this order passed. In spite of that, police insisted that he has to go to the jail. There he has to file a release order. Then he is sent to jail around 11 o'clock in the night.
Those,
Deliberately, IO didn't come to the
And
station.
when have you served the reasons for arrest in this case to him?
no,
When have you served it?
it is done on, my lord, on.
There, whoever it may be. He may be a criminal. I'm not saying that. If you don't follow the procedure, definitely this court will interfere.
That
This is not the way
yes,
to do it.
Yes, my lord.
Where is the reasons for arrest served on him?
Arrest was intimated, my lord, at
What
8:30 a.m.
intimated when?
8:30 a.m.
8:30 AM. What time was he arrested?
8:30.
8:30.
Yes.
What time were you arrested?
He came out of the prison at 8:30 a.m.
Hmm.
He was arrested, intimated immediately to the control room. Also, the locks have been made to control room about his
And
arrest.
10 grams is the allegation. Why did you seize 91?
No, your lordship may see that it is.
A name allegation.
No, 5 cases are.
ಯಾವ 5 cases?
Accused number 1 and 2 have disclosed about 5 different crimes.
Against him.
Yes.
All right, but the seizure, the allegation is 10 grams.
In connection
Without
with this-
investigation, then how do you,
Connection with only this case, 10 grams.
in connection with which case did you seize then?
No, we have not seized anything. He has not given anything.
Then 90 grams is seized is
That
what
is
is
the
that?
accused number 1 and 2 have given a statement saying that the extent of gold which were given to him.
Where are those?
I'm placing the.
Where is the seizure panchanama? Where is seizure memo?
We have-
How did you seize?
No, we have not seized.
And then what have you
He is
done?
not given.
What do you mean he's not given?
Now he is saying that now yesterday he is saying that he's going to give the gold connection with this case. He's still not seized.
In this case connection, how much gold is it?
Not yet been recovered.
No, how much gold is it?
10 grams.
10 grams is not given?
Not given.
90 grams you have seized is what he says?
Not in connection with this case, my lord. He has
Then
not
in
been-
connection with this case, other case, which is the other case? Which is the other case, sir?
Nothing has been seized. There are cases are registered in Kolala and other places. In Tumkuru, nothing has been
In
seized. He is not
this
given.
connection, in the connection with this crime, did you search and seize?
No, we have not able to do it because he is not cooperating with investigation.
Who is not cooperating with
The
the investigation?
accused.
He's in police custody. What not cooperating with the investigation?
He is refusing. Now, yesterday, we have taken him to custody only yesterday.
Ah.
29th he has taken into custody.
Today, yesterday is first.
Yesterday he said that-
29th, Belege 8 AM he was taken into custody.
Yesterday he said he'll hand over, he'll give the gold, 10 grams gold in connection with this case.
10
We have-
grams gold.
Correct.
Why will he hand over?
Because without him, nothing moves in the Attica gold. That is what I'm trying to make my submission out because in fact, I wanted to print the call details. They got me the call details. It runs to 1,300 pages and I couldn't print. That shows that your lordship may see, he claims everything. Your lordship may see, I've taken the photographs of the company and other places. Still, his photos arrive displaced in the company. It is only front he is doing all these things to avoid from all criminal prosecution. In fact, I must say, my lord, one of the former chief justices of India, his house was robbed. 64 notices have been sent to him. 64 notices he has not answered.
And then maybe say all these things to influence the court, but
No,
about
it is
practice.
all right.
It is a fact.
Don't worry about that.
I will produce all this aspect.
But as far as procedure, nobody can prejudice this court. Yes.
64 notices have issued to him to hand over the gold which was stolen from his house. And unfortunately, it doesn't. Each time he comes, I'm sorry, my lord, we have not placed many material before.
Yes, you have let 47 orders in his favor. What
It
is
is our
that then?
mistake, my lord. It is our mistake.
What our mistake?
It is our mistake. we have not
Every
placed the-
order, see, there are so many produced. Come to page 52.
Yes, my lord, I completely agree, my lord. It's our mistake that we have not placed all this material.
Come to page 52. In every case, he is the petitioner.
Correct. Now, it is our mistake, my lord, that we
What
have not.
mistake, sir? Every case.
Now the is
Now,
also-
what do I do with all these things? There are about 47 orders passed. You
Yes,
want
my
me to
lord.
pass an order contrary to all that?
No, your lordship has to distinguish and say that it is,
How
these
distinguish?
issues have been dealt with in a connection with as a director of the company. We are not prosecuting today as the director of the company. We are aware that he has resigned from 2016. Thereafter, his wife and daughter become a director of the company, and they also resigned recently.
Now, in Prabir, what the apex court says, when should you serve the arrest reasons
Of course.
or arrest memo? When?
At the time of arrest, my lord, that will have to.
No,
Before arrest.
look into the judgment. On that ground, this arrest will go.
At least ಈಗೇನೋ ಕೊಡಕ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅದು ಹೋಗ್ಬಿಡ್ತದೆ.
ಏನ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ?
10 ಗ್ರಾಮ್ ಕೊಡಕ್
10 grams ಇಸ್ಕೊಳ್ಳಿ, ತೊಂದರೆ ಇಲ್ಲ.
Accused number 3 is there in their custody, lordship.
ಅವ್ರ ಹತ್ರ ಇಸ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ಅವ್ರು ಕೊಡಲ್ಲ, ಎಲ್ಲ ಇವ್ರದೇ ಇವ್ರ
ಕಿಂಗ್
ಸಿಗ್ನೇಚರ್
ಪಿನ್ ಇವರೇನಾ?
ಇವರೇ. Lordship may see that the photograph, lordship may see that. No, your lordship may see nothing moves. He has a big chamber in his own office and everything is video.
ಅವ್ರ ಆಫೀಸಲ್ಲಿ ಚೇಂಬರ್ ಇದ್ರೆ ಏನೀಗ?
ಅಲ್ಲ ಅವ್ರದೇ ಅಲ್ಲ ಅಂತಾರೆ ಅದಕ್ಕೋಸ್ಕರ. ಅವ್ರದೇ ಅಲ್ಲ ಅಂತಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಈಗ ನಾವು on the ground of the arrest memo not being served in advance, that will go. You redo the process, 10 grams ಕೊಡೋದು ಕೊಡ್ತಾರ ಅವ್ರು. You cooperate with the investigation. You don't cooperate.
Lordship, 10 gram, immediately he would have given. Why person will suffer? He is in a Jadeva hospital. For 50,000 rupees, why person of the worth who is of more than 3,000 crore? Why he will suffer? Lordship, they are asking any illegal demand. My lordship, just one thing.
ಒಂದ್ ನಿಮಿಷ. ಈಗ ನಿಮಗೆ 10 grams ಬೇಕಾ?
Connection with this case, 10 grams.
10 grams.
In connection with this case, but there are accused number 1 and 2.
But that then you will project it as admission
Yes.
of guilt. No.
Lordship, there's one small submission. Lordship. My learned friend saying they had given voluntary statement, this statement, that statement. CCTV is there.
I've been
If
told
they
my lordship-
produce the CCTV footage of the statement of accused number 3 and 4,
I
even
will
1 and
produce.
2,
I will
I will
produce.
concede.
I will produce today.
CCTV footage of the recording of the voluntary statement.
We have
Produce it.
recorded the video recording of this statement.
He takes the name of the
Yes,
petitioner.
Yes,
3 and 4.
yes, accused number 3's voluntary statement, videograph, we will produce it today.
Produce it. Produce it.
Yes, madam.
And give the reasons for arrest memo. When did you serve?
Arrest ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Huh?
Arrest ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
That is not correct.
ಅಲ್ಲ, but
ನೀವು ಒಂದ್ ಕೈಯಲ್ಲಿ ಮೆಮೊ, ಒಂದ್ ಕೈಯಲ್ಲಿ ಇದನ್ನ ಇಟ್ಕೊಂಡು ಹೋಗಕ್ಕಾಗಲ್ಲ, ಅರೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ.
ಅಲ್ಲ, there are 3,80,000 rupees which my learned friends talking about.
No, no, you
It is
see,
it is the,
what does the Supreme Court say in Prabir? ನೀವು ನೋಡಿಲ್ವಾ?
will the entire
ಅಲ್ಲಿ ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ನೋಡ್ತಾ ಇದ್ದಾರೆ, ಅದು ಕೇಳಿ.
Police stop.
ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ? 2024 SSC online SC 934. Just check and see.
Lordship,
Yes.
we have also a video that where police personnel coming and receiving 91 gram from our store.
Give it. You also produce it.
We'll produce it.
Both of
Lordship,
you produce it.
these things may be enough. They will put in trouble.
TV versus TV.
I have been told that entire Telangana police are waiting there now.
Let it be, let them,
Now
let it come.
you produce it. See, straight away I'll tell you, both of you are not paragons of virtue here.
No, we are not.
Definitely not. So
I should
both
have-
of you are in glass houses. Don't throw stones at each other. So whatever you want, you do. Arrest memo is not served in advance. On that ground, he will have to be released now. Whatever videograph is there, you produce it. I'll hear it. I'll take it at 4:30 or 5 o'clock. You could ನೋಡಿ judgment ನೋಡಿ, arrest memo ಯಾವಾಗ ಕೊಡ್ಬೇಕು? Arrest ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೊಡ್ಬೇಕಾ, ಯಾವಾಗ ಕೊಡ್ಬೇಕು?
And that in UAPA case.
That is an NIA. That is the UAPA case.
And this.
Remand memo, remand application, there is some secrecy to it. Because in Jigar, the Supreme Court says, in all cases, it need not be given. But it should be given. If it is given, no doubt, no problem about it. But reasons for arrest, that is inescapable. And ನಿಮಗೆ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ, ನಿಮಗೂ ಗೊತ್ತದು. That's not correct. On that ground, it will go. Whatever you want to say, tell at 4:30. Yes.
Then further protection also required because
What protection? Further protection?
immediately they will arrest other people.
ಅದೇನ್ ಮಾಡಕ್? Is that the subject matter here? Tell me.
Or should it become
Immediately, if they arrest you, immediately ಹೆಂಗೂ ಬರ್ತೀರಾ ನೀವು?
Let's see, again, this.
What to do, sir? I cannot give a blanket order saying that don't
At
arrest
least
him in
two
any
districts,
case.
Lord, these two districts, we had difficulty in these two districts because of the reason. For that reason, all the 2023 matters, they start investigating in June.
All that we cannot say anything in this case because you have not challenged anything else except the remand order. Now in the remand application, I see there are names, whatever it is, but the arrest memo is not served upon you in advance as held by the Supreme Court in Prabir. That will go. 4:30, I'll take it. You want to get some instruction, get it. ಅದಕ್ಕೆ ಈಗ ನೀವು ಏನಿಲ್ಲ ಅವರು ಇಲ್ಲ. If you
like we have
ಸುಮ್ಮನೆ fighting against each other, will take it somewhere else.
like we have issued notices under
ಸುಮ್ಮನೆ ಅವ್ರ ವಿಡಿಯೋ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಯಾಕೆ ಸುಮ್ಮನೆ?
ಅಲ್ಲಲ್ಲ, let them produce, madam. We have no problem.
Atiga Gold will undertake.
In fact, we have
On both
cooperate.
sides, lot of skeletons from the cupboard will drop out.
Allala, I'm open to it, my lord. Let them, if our officers have made a mistake, I'm not going to spare, my lord. Your lordship can take it.
That is what. See,
That I'm not.
whenever you want to initiate something, please do it in accordance with law. What is the problem?
There is.
Police should not behave as if every citizen's right is their personal fiefdom. It's not the kingdom of theirs to do something.
That's the whole issue, my lord. He takes a political malafide in this case. What is to do with Andhra police? What is to do with Tamil Nadu police?
No, that's all right. I am not on all
It is
that.
not against individual.
I
It
am
is against
not
company.
on all that.
In fact, my lord.
Whatever you want, you initiate, but let it be in
In
accordance.
fact, my lord, in one of the
In accordance with what Supreme Court has said in Prabir.
That I
That's
agree,
all.
my lord. In fact, in one of the case, my lord, investigated in Bangalore.
And
he has-
Supreme Court says if reasons for arrest is not served in advance, it vitiates the arrest itself. In a UAPA case.
Even the remand was cancelled after filing of charge sheet.
Yes.
First remand was cancelled
Yes.
and he was set into
In fact,
liberty.
in one of the case investigated in
Justice
Bangalore
Sandeep
City.
Mehta, I think. Yes.
In one of the case investigated in Bangalore City, it speaks about the selling of gold to other people. All are fake.
ಅಲ್ಲ ಆಯ್ತು ನೀವು ಏನಾದ್ರು ಮಾಡಿ you investigate, he will cooperate. He has not said he will not cooperate with the investigation. Every time, in fact, 2 orders I had initially granted was he will cooperate with the investigation, but no coercive steps will be taken ಅಷ್ಟೇ. But then later on, I was given these orders passed by the coordinate bench everywhere.
But
It is cost 30 orders on a single day is cost.
Single day 30.
I must say, my lord, we have not placed material. We have not placed material.
If you have not placed any material and led to these orders, what is this?
It is our mistake, my lord, we have not placed.
And you are saying so much.
It is-
Not one sentence is there in these that you have filed.
We have not placed it. In fact, I think
934 tappa. 934 is wrong.
No, it's perfect.
Ah,
ma'am.
yes.
That is Prabir Purkashya.
Yes.
ನೋಡಿದ್ವಿ. ನಾನು ಹೇಳ್ದೆ ಅವ್ರಿಗೆ.
ಅಲ್ಲ ಅವರು ಹುಡುಕಿದ್ರು ನಾನು ಹಂಗೆ ಹೇಳ್ದೆ.
Judgment is there in the compilation itself.
Yes. ಆಯ್ತು 4:30 I'll take. Whatever you want to submit. Because of the arrest and 2 things. I have passed an order. I have released the order. He said court ಅವ್ರು ಯಾರು ನಿಮ್ಮ ಕೊಲಿಗೆ ಯಾರು ಬಂದಿದ್ರು.
Some correction.
ಕೋರ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರು ಅದು 6 ಗಂಟೆಗೆ ಮಾಡಿದೆ because I was sitting up to 5:30. Before that only I got it uploaded in the afternoon itself. And I have directed immediate release. You hold on till the night and release in the morning. Adu seek instructions and come.
I've been told that it is remanded to judicial custody by the
Sir,
court.
if you or your counterparts have not brought anything to the notice of the court and led to passage of 50-60 orders,
Will
and you
have-
want me to undo everything by an order of,
But one wrong order, my lord, will not lead to the.
no, that is true. I'm not on that. Wrong orders, it is led.
No, it is, I must say, I'm sorry, my lord, it's not a wrong order. It is, we led to pass this wrong order.
Yes, it's not a wrong order.
Yes,
You
ma'am.
have said this is what.
Yes,
He has resigned, he has nothing to do in first order. That
Yes,
has percolated into every order.
yes. But that is, I must say, my lord, it is factually, we made a
No,
mistake.
you
in not placing-
investigate. If there is a crime, you investigate, no problem. As he said, 10 ಗ್ರಾಮ್ಗೆ 90 ಗ್ರಾಮ್ ಯಾಕೆ ತಗೊಂಡಿದ್ದೀರಾ ಅದು ಹೇಳಿ.
Voluntary statement 1 and 2 ತಾವು ನೋಡಿದ್ರೆ ಅದರಲ್ಲೇ ಇದೆ ಇಲ್ಲ.
ಏನು 90 ಗ್ರಾಮ್ ತಗೊಂಡ್ರು?
ಹೌದು. 5 ಕೇಸಲ್ಲಿ.
ಈ ಕೇಸ್ ಕೇಳಿ
ಈ ಕೇಸಲ್ಲಿ ನಾವು
ನೀವೆಲ್ಲ ಕೇಸ್ಗೂ ಕಲೆಕ್ಷನ್ ಒಂದರಲ್ಲೇ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ,
ಅಂದ್ರೆ
ಅಲ್ಲ.
ಇದು ರಿಕವರಿ, ಸಾರಿ.
Recovery, what happens, my lord, based on voluntary statement. We do recover and then transfer the material to other cases. That is what the recovery happens in most of the time.
I will see 4:30.
Yes.
Yes. But the reason will be non-serving of the arrest. You get over Prabir judgment, we'll see.
Yes.
Where could he judgment?
It is there in the compilation itself. Rosh.
Where?
Annexure.
Placed it.
Annexure H, Lordship, page number 62 onwards.
ಇದು SCC ಕೊಡಿ.
SCC.
934, get it. You get in the library. 24 SCC online SC 934. And on the remand memo also,
Yes.
there is, get that judgment also. That jigger.
Sir, criminal rules are, in fact, I argued another matter, criminal rules are
When
practice
that
prevent.
jigger,
Jimmy Jigger judgment, Lordship, states.
2023,
2023.
684, get that. Both ಎರಡು ತಗೊಂಬನ್ನಿ.
Yeah, I'll get it.
I'll take it at 4:30.
Yes.
After 42. 42.
Lord, under
ಇದಕ್ಕೆ ಯಾಕೆ
section-
ಪಾಸ್ ಓವರ್ ಬೇಕಾಗಿತ್ತು?
No, I was not here. Under section 17, my lord,
ಹಾ.
a search operation takes place.
Hmm.
Section 17 of the PMLA, my lord, presupposes that the person whose premises is being searched is, my lord, an accused of PMLA. Now, my lords, may kindly see, my lord, rule 3 of, my lord, PMLA search rules. Rule 3 of PMLA search rules, my lord. It was, this portion of law was there even under section 7.
ನೀವೇ ಪಾವನ ದಿಬ್ಬರು ಆರ್ಗ್ಯುಮೆಂಟ್.
ಹೌದು. Rule 3, my lord, it retains. What Rule 3 proviso says, provided no search under subsection 1 of section 17 of the Act shall be conducted unless a report has been forwarded to a magistrate under 157 of Code of Criminal Procedure or a complaint has been filed. So there has to be, my lord, an FIR. 157, my lord, is FIR or a complaint to the magistrate. Now, my lord, section 62 of the PMLA, my lord, always should be read in conjuncture with section 17, my lord, for the reason, if my lord
Now-
could kindly have.
For initiation of a search or whatever under the PMLA,
Yes.
one need not be an accused in PMLA.
No, my lords, kindly, my lord, see, section
In the
17.
predicate offense, if you are an accused or a connection is there with the accused in the predicate offense, that is enough.
I understand that, my lord, but they have to tell what is the reason, my lord, for.
Telling reason, we will tell.
Yes.
Yes.
For a reason, for a moment, my lord, section 17, my lords, may kindly see, my lord. So I need to, my lord, only read two provisions in conjuncture. Section 17.
PMLA.
PMLA. Section 17. Kindly, my lord, have section 17 of the PMLA.
I am there.
My lord, PMLA section 17 is used, unlike, my lord, section 50, search and seizure, where the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section on the basis of the information in his possession has reason to believe that the reason for such belief to be recorded in writing that any person has committed any act which constitute money laundering, is in possession of proceeds of crime involved in money laundering, is in possession of any records relating to money laundering, is in possession of any property related to the crime, enter so and so, so and so. My lord, presupposes that person whose premises is being searched is an offender under the Money Laundering Act. Now, my lords, may kindly see section 62. Section 62 of, my lord, PMLA. Section 62, my lord, in my humble opinion, my lord, it has to be read in conjuncture because section 62, my lord, reads punishment for which any authority or officer exercising powers under this act or any rules made under who without reasons recorded in writing. So the search has to have reasons recorded in writing.
Yes.
Those reasons should be clearly that what is the underlying reason behind the search. Now, my lords, may kindly see this Panchanama, my lord.
Reasons, yes.
Reasons. Kindly see, my lord, the Panchanama, which is, my lord, annexure. My lord, B does not say anything. My lord, the typed copy, my lords, would kindly find on page number 42.
Who are you?
My lord, I don't know. I'm a stranger. I went.
Who are you andre? I don't know andre henge.
My lord, I am an industrialist.
I am an
industrialist.
I don't know.
I run huge hospitals in Bangalore. I run huge hospitals in Bangalore. My lord, I have a very great, my lord, history and a personality. My lord, I have produced the petitioners, my lord,
You have a
biodata
great
also.
history and you're a great personality.
Exactly, my lord. My lord, we run hospitals for the government. And kindly see, my lord, this Panchanama does not
You run
use-
hospitals for the government.
We run, my lord, also hospitals for the government.
How hospital?
Lord, Vaidehi is partly run for the government. Vaidehi, the main
Vaidehi.
hospital, the Whitefield.
Oh, okay.
The Vaidehi Malya Road, my lord, is a commercial undertaking.
Huh.
But my lord, we run hospitals at various places. Kindly, my lord, see page number 42. Even remotely, my lord, it does not say why they are searching my premises. The requirement of the law, my lord, under rule 3 of my lord, the search rules is that it has to disclose. Read in conjunction with 17 and 62.
Where is the search Panchanama?
So it is, my lord, on page number 42, typed copy. My lord, it only says that we, the above named Panchas, having been called upon by so and so, have presented ourselves at so and so, then, my lord, after the above.
Now, your contention is the search and seizure agidya?
Haudu.
Search
Kindly
and-
see, my lord, there is one more legal question, my lord, which I have raised. My lord, the annexure to the, if your lordship would kindly have page number 45, my lord.
Yes.
Page number 45, my lord. What they do is, they take our mobile phones. My lord, this is something, my lord, which I would very humbly request for your lordship's, my lord, interference, because this part of, my lord, law has to be laid down. Kindly see, my lord, page number 45. What they would do is, they take our mobile phones, make a mirror image. Make a mirror image of the entire mobile phone. My lord, making a mirror image of the entire mobile phone is, my lord, clear violation of privacy, my lord. The Canadian Supreme Court holds, if you want to make a mirror image, there has to be a judicial warrant, judicial writ. Otherwise, every investigation officer, my lord, comes to my home. I may have so much of personal information, my bank accounts, my personal data, etc., etc. You want what? You are making a mirror image to know only if there is any threats or leads to the crime. My lord, along with that, what is being exposed is also, my lord, the vital information. Today, my lord, a mobile phone is a person's complete life. My lord, this mirror imaging, without the permission of the magistrate, it can never be done. My lord, the investigation officer would come there. At the time when they come, my lord, there is nobody. He would come there, call, my lord, at 12:30 as per the very Panchanama, an expert, my lord, who is well versed in taking the mirror image. Kindly see, my lord, page number 45. They take a mirror image of my phone. Keep it with them. My lord, tomorrow if there is some misuse, I don't blame, my lord, but it is my personal data in somebody else's hands. My lord, my entire data is exposed. That is the reason, my lord, the Canadian Supreme Court said, to extract mirror image, there has to be a judicial warrant, and the moment it is done, it has to be done under the judicial supervision. My lord, leaving this kind of privacy exposure to hands of, my lord, investigators, my lord, will have serious consequences. My lord, I have that Canadian Supreme Court judgment, my lord, which I'll produce. The Canadian Supreme Court said, my lord, I was also searching for, my lord, our judgments, my lord. When I had dearth of that, my lord, I had to go to Canada. The Canadian Supreme Court, my lord, says, it is a very, in 2010, my lord, the Canadian Supreme Court said, it's a very, very sensitive area. Extracting a mirror image is nothing but you are duplicating the entire system. Therefore, tomorrow you may need only a part of that for your investigation, but entire information becomes vulnerable. My lord, in my phone, I would have stored the bank accounts of my children, my husband, Aadhaar cards, everything. My lord, who has to monitor all that? Therefore, my lord, it's a serious error. And first of all, they were not authorized to do that. They do it. And all through, my lord, the Panchanama, my lord, they don't disclose what is the reason. One more very important ground, my lords. My lords, may kindly see these rules, my lord. Rule 3. Who has to be the search witnesses? My lord, rule 3 of, my lord, this search and seizure rules. Rule 3F, my lord, where clearly says,
separate again.
Adralle ide. Act nalle ide. Search and, my lord, it's called as the prevention of money laundering forms, search and seizure or freezing and manner of forwarding reasons and material to the adjudicating authority, impounding and custody of records and the period of retention rules 2005. Under which, my lord, the rule 3 says that they have to, my lord, secure the presence of persons of that locality as witnesses.
Those are held to be directories.
Yes. Now
you see paragraph 253 of Vijay Madan Lal Chaudhary.
Yes.
Now this is held to be directory.
I understand that, my lord. But even if it is directory, my lord, they have to follow it. My lord, merely it is because directory, they can't, my lord, now when the matter.
Merely it is directly and follow ಮಾಡದ್ ಬೇಕಾಗಿಲ್ಲ. Rigor of it is diluted.
How? But, my lord, now if
No,
they are.
what you say, the mirror image is.
Yes, mirror images, my lord, it is a serious, my lord,
That is,
intrusion into the privacy.
that is what is.
And my lord, they
wanting
have
an
to
answer.
disclose, even when they come under section 17, my lord, they are placing me on a pedestal of, my lord, an accused. Therefore, my lord, 62, my lord, implicates.
Now your house is searched in connection with what?
No, I don't know. I repeatedly go on asking. That's what is my prayer. Why you are searching?
ED straight away cannot enter like.
They have done it, my lords. May kindly see the Panchanama, my lord. Straight away, my lord, they come saying that we have an authorization from the regional director. Therefore, we are coming. Kindly see, my lord, page number 42.
Phone ಮಾಡಿ ಹೇಳಿದ್ರ we are coming ಅಂತ.
ಇಲ್ಲ. Page number 42, the Panchanama only says this much. So and so joint director, Piyush Kumar Yadav, joint director, so and so, under section 17, authorizing so and so to conduct search and seizure or freeze any record or property at the residential premises of so and so, and requested to witness the search. This is all, my lord. Is why you are coming, what is the underlying case. All these, my lord, have to be disclosed under section 62. 62, my lord, because it has to record the reasons why they are searching. Otherwise, my lord, everything, my lord, anybody's house can be entered into, anybody's house can be checked.
We'll see. Now, what have you sought?
My lord, I have sought for that this Panchanama, and they have collected, my lord. There is one more, my lord, small legal point. Under, my lord, section 17, the officers are authorized to record the statement on oath. Now, my lord, that statement on oath, can it amount to a voluntary statement? My lord, somebody.
That also Supreme Court.
Yes. Now, my lord, that will be.
Get Vijay Manlal
Yes, my
Chaudhary to
lord,
argue all this.
Now, my lord, here they have recorded the statement on oath, but they would call it as my voluntary statement. My lord, then I'll be seriously implicated if, my lord, because under section 50.
Exactly what Supreme Court considers, sir. Whether
lord,
that voluntary statement would be pitting the voluntary statement against the own, against the accused, would lead to become a voluntary statement. Evidence against themselves. That is Supreme Court answers no.
It does not become, my lord, but.
Nodi Vijay Manlal Chaudhary.
In fact, that matter went till up till, my lord, self-incrimination, all those things were also discussed.
Sir, Vijay Manlal Chaudhary, you see,
I have.
where is the judgment?
Vijay Manlal Chaudhary judgment thing. I have, in fact, my lord, brought out the pleadings also, my lord. Vijay Manlal Chaudhary has been quoted. All that I want, my lord, is now the prayer, my lord. I have the interim prayer. Till, my lord, the honorable courts decide. There should not be coercive action, my lord, against me. And, my lord, this should not be used, the mirror image.
Yes.
My lord, the interim.
The learned senior counsel M.S. Shyam Sundar appearing for the petitioner. ED Gary, Prasanna Kumar idaralla. Counsel Shri Prasanna Kumar is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. The learned senior counsel, the petitioner calls in question the act of search and seizure of the house of the search of the house of the petitioner and consequent seizure of several items. The learned senior counsel submits that in terms of Rule 17, is it?
My lord, section 17 of.
The learned senior counsel would submit that there is complete statutory violation in the action of the enforcement directorate in searching and seizing in conducting a search and seizing certain material from the house of the petitioner. It is a submission that unless the petitioner is an accused in any crime, the enforcement directorate would not get jurisdiction to either conduct search or seize any material. He would further submit that the mobile phone of the petitioner is seized. After seizure, a complete mirror image of the mobile phone is moved on to another mobile phone. This is complete violation of right to privacy. He would submit that unless there is an order of the court, such copying of the mobile phone details would be violative of the right to privacy. The questions need to be answered. The learned counsel for the respondent shall seek instructions and answer the same on the next date of hearing. Till such time, no coercive action shall be taken against this petitioner by the enforcement directorate.
And my lord, that mobile phone mirror image may kindly be kept, my lord, in my lord, under some judicial
Original ಯಾರ ಹತ್ರ
supervision.
ಇದೆ?
ಎರಡೂನು ಫೋನು ಮಿರರ್ ಇಮೇಜ್ ಎರಡೂನು ಅವರೇ ಇಟ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು ಇಟ್ಕೊಂತ.
So great.
Why are you so much worried about it?
My lord, huge shares, my lord, tenders, medical equipments, my lord.
In the mobile phone.
Huge, my lord. There each medical equipment, my lord, costs 30 crores, 40 crores, my lord. We have tendered. We are, my lord, we have prepared tender. Everything, my lord, mails, everything is there under the mobile phone.
Now you have given the
Not
information.
certainly, my lord, some information, my lord, which
Like
is
information ಕೊಟ್ಟಿದ್ದೀರಾ ಬಿಡಿ. Yes.
46.
Petition.
For settlement. Offense in
406, 420, 480.
respondent.
I am for Artus.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, I was not in India. They have served copy to the this.
Have got you back for the settlement.
We have already entered into compromise petition in the state commission as well as trial court.
ಎಲ್ಲಿದೆ ಅದು?
They have produced it.
So we'll close it.
From our side, already, but in the trial, one submission in the trial court, trial court PO told that there are some other complaints. That is why she will not first. She will fight. She has asked.
No complaints, only witnesses. Already acquitted the.
So far as our.
Allah, you have signed here first party, second party.
Yeah, so far as our case is concerned, we have entered into compromise.
So your case is concerned, we'll close it.
Please.
Others case is concerned, later on we'll see.
Yes. Okay.
Agreement. Order sheet, my lord.
Huh?
Page 43, order sheet.
Order sheet.
In CC 23028, the order.
Oh, 320 is allowed.
Applications are hereby allowed. Accused is hereby acquitted for the offences punishable under section.
Refer to Lok Adalat for disposal.
Disposal. A disposal ಇದು ಮಾಡಿದ್ಮೇಲೆ parties need not be present ಅಂತ ಹೇಳಿದ್ರು. Then again referred back to the trial.
The petitioners are before this court so and so. The parties to the list before the concerned court had submitted an application under section 322 of the CRPC seeking compounding of the offences. Since the court was not empowered to close the proceedings on compounding of the offences, the petitioners are before this court. The petition appends to it an agreement of such settlement. The settlement reads as follows. Reads as follows. In the light of the settlement so arrived at between the parties and the offenses punishable are the ones under section 406, 427, so not against the state. Ad ಮಾಡ್ತಿರಲ್ಲ madam. Yes. Closed. Yes, next.
Pen drive.
Let's continue. 52.
Death certificate R2.
This is with respect to the dictation was going on.
Dictation was going on. Yes, sir.
My lord, I'll only invite my lord's attention to two aspects, my lord. One is exhibit P3 and exhibit P4. P3 is the endorsement given by the Tahsildar saying that that mutation is not there.
My submission is if the entry has stopped at 3/86.
Let him tell that.
How
only.
can
Let him tell that only.
as good as summoning a document which is a non-existent.
Non-existent document ಅಂತ ಹೇಳಿಲ್ಲ. What they have.
I am allowing it. ಒಂದ್ ದಿನ will fix it. Petition ಕೊಟ್ಟಿದ್ದೀನಿ individually. Continue ಮಾಡ್ತೀನಿ. Dispose ಅಂತ.
Yes. Let there be, because there is in this matter, there is already a direction. So one divsa date fix ಮಾಡಿ, let them.
Only one day.
Please.
So direction will always be in accordance with law with all opportunity.
Please, but only thing is.
ಒಂದೇ ದಿನ will fix it.
Because the stage is already 313 stage.
ಆಯ್ತಾಯ್ತು ತೊಂದ್ರೆ ಇಲ್ಲ. ಒಂದೇ ದಿನ.
Very.
No adjournment taking on that ground.
Indeed.
Yes.
With that observation, because they will, because.
Definitely, sir. No adjournment on that ground. Madam, ಮಧ್ಯಾಹ್ನ ಯಾರಿದ್ರು? Invigilator ಹೇಳ್ತೇನೆ. ಯಾರಿದ್ರು?
53 adjourned, 54.
Awaiting report, please.
In this case,
Post immediately after service of notice upon
notice serve ಆಗಿದೆ ಸ್ವಾಮಿ. I spoke to
Post-
respondent police.
Huh? 54.
ಇದು
Furnishing of PF.
ಸರ್ವಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
Service ಆಗಿದೆ ಅಂತ ಹೆಂಗ್
ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಶೋ ದಿ ಸಂತೋಷ್ ಕುಮಾರ್ MB ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್ ನೋಡಿ. So and so.
ಸಂತೋಷ್ ಕುಮಾರ್
Registry to print the name of so and
ಕೈಂಡ್ಲಿ
so.
ಪೋಸ್ಟ್ ಫಾರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Since he has entered appearance, list the matter on 12th. Interim order subsisting shall continue till the next date of hearing.
55. Your Honor, the matter is listed for complying with office objections, but it's a matter of reporting settlement.
ಬೆಳಗ್ಗೆಯಿಂದ ಮೆನ್ಷನ್ ಮಾಡ್ತಾನೆ ಇದ್ದಾರೆ. ಏನ್ ಮ್ಯಾಟರ್ ಇದು?
It's a matter under section 408 of the IPC. The petitioner and the respondent are available on video conferencing right now.
ಏನ್ ಹೇಳಿದ್ರು ಮೇಡಮ್? Where is the petitioner?
He's online now.
That's all right. Where is the counsel for the petitioner?
I am the counsel for the petitioner.
Petitioner, please come this side. 54 either. Where is the respondent?
He's also online now.
Who identifies him?
Uh,
Settlements can't take place like this. Get an advocate for him and then move for the settlement. Yes. List on, when do you want? 12th? List on 12th at 2:30 PM.
Yes, sir.
55, madam. Yes.
56.
Office objections, mood. Éನಿದೆ madam? 10 days time to comply with the office objections. Yes.
57.
The petitioner in this matter.
Second respondent,
Waiting for, we already taken steps for the respondent number 2 minutes.
post immediately after service of notice upon the second respondent, interim order, yeah?
Yes, interim order to be continued.
Interim order subsisting shall continue to the next date of hearing.
58.
For 58, Your Lordship. Lordship, the office objections is that one clarification with regard to the name. In the complaint, he stated Ananda, but in the FIR, probably because of the typing mistake, it's become Bananda. So that is one. of the-
Ananda.
The FIR is at
Ananda.
50.
So what? 1 minute, non-compliance. We'll overrule it. Post it tomorrow. Office objections overruled, list the matter tomorrow in the fresh matters list.
For 59.
For the petitioner, my lord, the review petition was filed under a wrong provision. Father-in-law, exclusion of father-in-law from the.
ಓ ಅದಾ ಇದು 362 ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು.
ಹೌದು,
ನೀವೇನ್ ಮಾಡಿದ್ದೀರಾ?
ಈಗ 362 ಹಾಕಿದ್ದೀನಿ ಈಗ.
ಹಾಕಿದ್ದೀರಾ ಈಗ?
ಈಗ ಹಾಕಿದ್ದೀನಿ 362 ರೆಡ್.
Will issue notice.
Yes. And
ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರ ಅವಾಗ?
ಚೇತನ್ ಜಾಧವ್.
ಇದು ಸುಮಾರು ದಿನ ಕೇಳಿದ್ನಲ್ಲ ಅದು.
ಹೌದು, ಅದೇ.
You still have an axe to grind against the father-in-law.
He is the main person.
He is the main person.
Yes.
Yes, madam, this matter. Yaar, Tejesh. Who was appearing ಅವಾಗ?
Government.
Government ಗೊತ್ತಿಲ್ಲ ಬಿಡಿ. You serve on Jadhav.
ಸರ್ವ್ ಮಾಡ್ತೀನಿ.
Our office ಗೆ serve ಮಾಡಿ.
Yes.
Learned counsel of the petitioner to serve on the counsel who represented the respondents in the original proceeding. List this matter on 12th.
In the review petition ಅಂತ ಬರ್ಲಿ, ಯಾಕಂದ್ರೆ
In the review, in the review petition.
Much obliged.
Respondents in the review petition.
Much obliged.
Appearing for petitioner, my lords, kindly short accommodation.
60. 60. Vacating stay, madam. ನೀವು ಹಾಕಿರೋದು ಅಷ್ಟು vacating stay.
Please, my lord. Yeah, fine.
What's the matter, sir? ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ?
My lord, by virtue of the interim order, my lord, the entire investigation is stalled.
What is the matter, sir? For this sexual harassment. ಅದೇನಾ ಇದು?
Short accommodation, my lords.
Short accommodation. Madam, vacating stay ಇದೆ. List the matter on Friday. In the event the petitioner would not make his submissions, interim order would be vacated. Yes.
Kindly extend.
With this, subject to the said condition, interim order stands extended.
This matter was,
Grateful, my
say, my
lords.
lord, this matter was that for some time.
I know, that's why let it be.
61.
It was second respondent.
Vacating stay ಇದೆ, yes.
In this,
Wait, please, my lord. 354.
Yes, sir.
Please, my lord. My lord. Certain dates, my lords.
354A D.
ಹೌದು. Beg to pray the honorable court to
And 506 and
the
ಪ್ರತಿ ಹೇಳಲೇಬೇಡಿ, ಇದ್ದೇ ಇರುತ್ತೆ ಎಲ್ಲದ್ರಲ್ಲಿ.
ಹೌದು.
504, 506 ಇಲ್ಲದೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಲ್ಲ. ಎಲ್ಲ ಹೋದ್ರು ಅದು ಮಾತ್ರ ಉಳಿಲಿ. Yes.
My lord, the dates I pray the honorable court to permit me to read the 11
sir.
dates which in the synopsis.
Yes.
8/1/23, my lords, appointment of the respondent number 2 as office assistant. And 2016, one memo was issued to respondent number 2 regarding the her conduct. One more memo, 2016, my lords, issued to her. Then, my lord, 2017, 2/3/2017, she was shifted as the person secretary to the bishop. Then, 2018, she was appointed as a receptionist. Then, my lord, 2019 as personal secretary. Then, my lord, 17/5/2022, petition number 2 is appointed, order of appointment of petition number 2, accused number 2 as the bishop. Then, my lord, 12/7/22, kindly see this, this date in page number 2, first date, 12/7/2022. Complaint was filed by respondent number 2 before the assistant labor commissioner, raising some labor dispute, my lords, regarding her removal and posting to some other place, etc. Then notice was issued, my lord, before the labor commissioner. We appeared before the labor commissioner. Written statement was filed, my lords. And
ಹೇಳಿ ನೀವು.
on 4/7, notice was issued to respondent number 2 regarding not to collect any post and courier. We issued the notice to her, annexure M. Then, my lord, that was returned. One more notice was issued. Again, 21/7/2022, one more notice was issued to her. Series of notice 1/8/2022. Then, my lord, transfer order was passed on 16/8/2022 as per annexure Q. After the transfer order was passed, she did not obey. Then a show cause notice was also issued on 23/1/2023. Then, my lord, election happened to this body. That was on 5/2/2023. At this stage, my lord, on 7/3/2023, she registered as a criminal case. This is the factual background how she registers a criminal case, and no such allegations were made before the labor commissioner where the proceedings was going on, my lord, where both the parties were represented by their concerned persons, my lords. Now this criminal case is registered, and petition number 1 is the working as the treasurer to the concerned diocese, and petition number 2 is working as the person secretary to the bishop, and 3, 4 are other persons, my lord, who are manager and driver, etc. Number 5 is a woman, sister, and she is the vice president of the diocese. And now the criminal case allegations made herein, my lord, all these persons have sexually abused, is the allegations. And the period in which this alleged offences have taken place, my lord, that refers to 19/8/2022, 28/2022. My lord, had there been any such allegation should have been there. My lord, she lost the matters there. She could not get any relief before the concerned labor authorities. At that moment, she files this case. And the notice we have issued, my lord, kindly see page 36, my lords. The notice issued by the diocese to her. This is on 17/5/22, annexure G. That you have not completed post-graduation, not qualified for the post of secretary. Therefore, she is appointed as a receptionist. Then, my lord, she submits her complaint before the labor commissioner, page 39, annexure J, where there is no such allegation. She prayer made therein is, my lord, to action against us for illegally causing financial loss and interfering with their official duty. That is a prayer made. And against the very same persons who are before the honorable court. And the proceedings before the labor commissioner, my lords, annexure K, page 42, shows on 27/22 there was a proceeding where called upon to appear.
and we have filed our statement before the Labor Commissioner, Annexure L, regarding her grievances. And other show cause notices issued to her, Annexure N, my lords, and the transfer order issued to her at Annexure R. After the transfer order is issued, my lord, transferring her from Mangalore to Udupi, she comes out with this complaint. My lord, as far as the allegations made in the complaint are there, all these allegations pertain to the dates.
Wait. Yes.
In this case,
ಯಾರು ಇಬ್ರು ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಅವರು respondent one, I am respondent.
ಅವ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಒನ್ ಆಲ್ವೇಸ್. ನೀವ್ ಹೇಳಿ ಕಂಪ್ಲೇಂಟ್.
In this case, she was working as employee. She was employed in the 2012 and she was working there. Thereafter, she was being confirmed. And when she has become the permanent employee, the law very clear that once the employee is confirmed and he is permanented, she should not be transferred and the law neither. As per the law, she was been working. During that period, the sexual harassment was given by the respondent number.
During which period?
From the beginning. From the beginning itself, still.
Beginning itself.
Starting and.
Beginning ಅಂದ್ರೆ 2012 ಇಂದ.
ಇಲ್ಲ.
After that. When she appointed as a reception secretary.
Secretary appoint ಆಗಿದ ಮೇಲೆ this.
Why did you not complain immediately? 2018 is the first incident you say. 2021 is the second incident you say. Complaint is registered on
7/3/2023.
7/3/2023.
2023.
What were you doing for 5 years?
Meanwhile,
Will it not dilute the effect of the complaint?
she had complained to earlier Bishop, Your Honor.
Earlier Bishop and.
Where is
higher
the bishop?
authority.
Bishop complaint ಅಲ್ಲಿ?
ಇಲ್ಲ, higher authority, he is higher authority.
No, in
he
the
is head of
diocese,
the-
yes, he is the higher authority.
So
but,
for him, she has been lodging the complaint and often.
ಎಲ್ಲಿದೆ ಒಂದಾದ್ರೂ ಕೊಡಿ.
Page number.
Where have you been lodging the complaints on this incident right from 2017 to the higher ups in the diocese?
For that, there is no document, Your Honor.
If there is no document,
There is no document.
I'll
Orally
render
they
the
had-
judgment.
Orally, she had complained to.
Orally,
That they had given a warning to them, those accused number two and two. So meanwhile, when the 17/5/2022, when she had.
ಈಗೇನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಬೇಕಾ?
No, not
ಏನ್ ಬೇಕು
settlement,
ನಿಮ್ಗೆ?
Not settlement.
What do you want?
She has a.
Is it-
problem. Yes,
Because it's
You
what
should
they
be
want.
reinstated.
Reinstate, Your Honor.
ವಾಪಸ್ ಹೋಗ್ಬೇಕಾ
ಹೌದು,
ಕೆಲ್ಸಕ್ಕೆ?
ಬಿಷಪ್ ಸೆಕ್ರೆಟರಿ ಆಗಿ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದೋಣ ಇಮಿಡಿಯೇಟ್ ಆಗಿ
ಹಾ.
ದೇರ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಿ ಅವ್ರನ್ನ
ರಿಸೆಪ್ಷನಿಸ್ಟ್ ಮಾಡ್ಬಿಟ್ರು.
ರಿಸೆಪ್ಷನಿಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಯಾಕೆಂದ್ರೆ ಒಂದೇ ಒಂದು ಕ್ರೈಟೀರಿಯಾ ಇಸ್ ಶಿ ಡಸಂಟ್ ಹ್ಯಾವ್ ಎ ಪೋಸ್ಟ್ ಗ್ರಾಜುಯೇಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ. ಸೊ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಅವರ್ ಪ್ಲೇಸ್ ಶಿ ಅಪಾಯಿಂಟೆಡ್ accused number 2 ಈಸ್ ಆಲ್ಸೋ ನಾಟ್ possessed a degree post graduate. So why this is comparative ನೋಡಿದ್ರೆ ಅದರಲ್ಲೇ ಗೊತ್ತಾಗುತ್ತೆ ಸ್ವಾಮಿ what the intention they had given torture and sexual harassment in that. When she has not cooperated for that or for illegal.
So she became a receptionist.
Yeah.
So ಇದೆಲ್ಲ ಯಾಕೆ ಬಿಡ್ಬೇಕು ಅಂತ 5 ವರ್ಷ ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಅಲ್ಲ, ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಹರಾಸ್ಮೆಂಟ್ ಇತ್ತು ಸ್ವಾಮಿ. ಲೇಟರ್ ಆನ್ she has completed on 7/3.
Your lordship may kindly see my
We are
lord.
not ಅಲ್ಲ, why?
He's a treasurer, Swami, first known, second known, personal secretary, with appointed
ಆಯ್ತು,
personal
you
secretary,
treasurer
others are drivers, etc. Now she should have lodged a-
ಅದನ್ನೆಲ್ಲ ಮಾಡೋಣ.
she should have
ಡ್ರೈವರ್ಸ್
lodged-
ಎಲ್ಲ ಕರ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ?
she should have lodged a complaint of sexual harassment against the bishop to get anything from him. That's not
ಅವ್ರ
anything.
allegation.
You are working under the bishop.
ಅಲ್ಲ, ಅವ್ರ ಅಲಿಗೇಷನ್ ಬಿಷಪ್ ಜೊತೆ ಇಲ್ಲಿಗಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಇಟ್ಕೊಂಡಿದ್ಲು, ಅದಕ್ಕೋಸ್ಕರ she has to move from ನಮ್ ಜೊತೆ ಮೂವ್ ಆಗ್ಲಿ ಅನ್ನೋದು ಅವ್ರ concept.
ಎಲ್ಲಿದೆ? ಇದ್ರೊಳಗೆ ಎಲ್ಲೂ ಇಲ್ಲ complaint. This is-
ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ, ಅವ್ರ ಅಲಿಗೇಷನ್ ಪ್ಯಾರಾ ನಂಬರ್.
The Labor Commission also, it is not there, my lord.
ಪ್ಯಾರಾ
He
ನಂಬರ್
was
ಏನೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ?
represented by advocate before the Labor Commission.
ಅಲ್ಲ,
Proceedings went on.
ಆವಾಗ ಅದು
Now do something and who are the officers here?
ನಮ್ಮ
Petitioners ಯಾರು?
No, you is a treasurer. First one is a treasurer.
ನೀವು ಅವ್ರನ್ನ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ,
ಮತ್ತೊಬ್ಬ ಡ್ರೈವರ್, ಮತ್ತೆ ಅಲ್ಲಿದ್ದ ಲೇಡೀಸ್ ಎಲ್ಲರೂ ಹಾಕಿದ್ದಾರೆ.
ಮುಂದೆ
ಡ್ರೈವರ್, ಲೇಡೀಸ್, ಪ್ರಾಪರ್ಟಿ ಮ್ಯಾನೇಜರ್ ಆಫೀಸ್ ನವ್ರಿಗೆ ಹಾಕ್ಬಿಟ್ಟು ದೇ ಸೇ ವಿ ಆರ್ ಇನ್ಸ್ಟ್ರುಮೆಂಟಲ್. ನಂಬರ್ 2 is placed in her place. He is appointed as the secretary now, personal secretary. So she is transferred to Udupi. She doesn't go to Udupi. Series of show cause notices issued to her, my lord.
ಆಯ್ತು, she will go to Udupi.
Now, my lord, I am informed that for number 2, 1 ಅವನು ಟರ್ಮ್ ಹೋಗಿದ್ದ ಟ್ರೆಜರರ್ ಹೋಗಿದ್ದಾನೆ ಪೋಸ್ಟ್ ಇಂದ. ನಂಬರ್ 3 ಅವನು ಇಲ್ಲ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಈಗ.
354 A, B, C, D ನಾಲ್ಕು ಇದೆ.
Please, my lords.
ಅವ್ರು ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ಇರ್ಬೋದು.
My lord, her understanding is that if she creates pressure on these persons, she will get the
That is why.
transfer cancelled.
Moreover, accused number
All
2.
right, if she has been driven to the wall, if you can take her back, just see.
No, we have no objection. Only problem is the bishop has to decide. Bishop secretary. She is bishop's personal secretary. Bishop has to decide. We are all.
All right, you're also officers of the bishop.
Number 2 is the person secretary appointed in the place of this lady. And now therefore she says driver. Everybody is, we are going to see, not only driver.
That we will take care, but she's wanting to get employment back, see.
Sir, in fact,
Since
my lord,
2
she has
years, she didn't
approached
get any
the-
payment.
she has approached the labor commission for this, my lords, and series of proceedings happened there. She did not get any relief. And next
ಇದೆಲ್ಲ
week-
ಮಾಡಿದ್ರೆ ವಾಪಸ್ ಸಿಗುತ್ತಾ employment?
ಅಲ್ಲಲ್ಲ, since 2 year ಇಂದ ಏನು ಪೇಮೆಂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಮತ್ತೆ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್, ಏನು ಪೇಮೆಂಟ್ ಇಲ್ಲ, ಇದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಪೇಮೆಂಟ್ ಸಿಗುತ್ತೆ.
ಅಲ್ಲ, ನಾವು ಮಾಡಿದಿಲ್ಲ, ಅವ್ರು ಮಾಡಿರೋದು ಇವ್ರು.
ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಎಲ್ಲ 5 ವರ್ಷ ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಕೊಂಡು legally you have no case. Straight away to tell you legally you have no case. It is straight away a counter blast. ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 2017 ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು. When you were removed, made a receptionist, removed from that also, as a counter blast you have done this. On the face of it, it is like that. That is why I am trying to say something, if you can be accommodated. Well, anyway, it's not jurisdiction of this court,
Yes, please, my lords.
but just see if you can. Otherwise, kashta case. This is not the way to settle this course. Is another misuse of 354 A and B. 354 A, B agide andre, you should have complained in 2017, 18, 19, 20, 21.
ಕಂಟಿನ್ಯೂಷನ್
Huh?
ಲೈಫ್ ಥ್ರೆಟ್ ಬೇರೆ ಇತ್ತು.
Life
Labor
threat
commission-
ಯಾವಾಗಿತ್ತು?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಒನ್ ಶಿ ಇಸ್ ವೆರಿ ಫೈನಾನ್ಷಿಯಲ್ ಕೆಪಾಸಿಟಿ, ವೆರಿ ಪೊಲಿಟಿಕಲ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್.
Oh, because of the elections. See, something imprimatur ಇದೆಯಲ್ಲ.
ಹೌದು.
See, something can be done. Yes, there is no warrant to vacate the interim order. Heard the learned senior counsel appearing for the petitioner and the counsel for the respondents. There is no warrant to vacate the interim order. He placed the matter for admission on 26th. Interim order subsisting shall continue till the disposal of the petition. Yes,
Grateful.
yes. Extension of parole. An offense?
302, Your Lordship. Your Lordship, all
Tell me.
other accused have been released, Your Lordship, prematurely.
I know, yes. Get that. Ask Rahul Karyappa to come.
I'll inform.
ನೀವೇ ನೋಡ್ತೀರಾ? No, extension of parole. GM ದು ಇಲ್ಲಿ extension of parole. Ask Rahul Karyappa to come. ಹೇಳ್ತೀರಾ?
I'll inform.
ಬಸವರ್. ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡ್ ಬರಕ್ ಹೇಳಿ. Yes, next.
Admission 63.
Additional documents.
Offense punishable under section
Respond number 2 minutes. Respond number 2 minutes.
offense punishable under section.
What is additional documents?
Additional documents, my lord, the
No interim order, ah?
no interim.
ಏನ್ matter ಹೇಳಿ?
Lord, offense punishable under section 323 and 504 and 506. Lord, the
Yes, sir.
earlier, Lord, the petitioner filed the complaint against respondent number 2 on 14/9/2020. Thereafter, my lord, counter complaint, the second respondent. filed
Which is your complaint?
My complaint, my lord.
Crime number 79?
No, my lord. 232 of 2020.
Page. Which is 719?
719, the respondent.
Sorry, 79.
79, my lord, the second respondent.
ನಿಮ್ದು ಯಾವ ಕಂಪ್ಲೇಂಟ್ ಹೇಳಿ sir?
Namdu 232 of 2020, already B report is filed, my lord.
B report is filed.
B report is filed.
What happened to the B report?
B report, my lord, the page number 55, my lord, last para. Last para, my lord. ಈ ಪ್ರಕರಣದ ಫಿರ್ಯಾದಿ
Close ಆಗಿದೆಯಾ? Pending ಇದೆಯಾ?
ಕ್ಲೋಸ್ ಆಗಿದೆ.
My lords,
Close
there was
ಆಯ್ತು.
a protest petition that was filed, my lords. The matter has come subsequently, my lords, but then the protest petitioner, he didn't appear.
It is accepted and closed.
Please, please.
That has become final?
Please, my lords.
ಸೊ ನೀವು ನಿಮ್ಮ ಕ್ರೈಮ್ ಅಲ್ಲ ಇವ್ರ ಮೇಲೆ ಕ್ರೈಮ್ ಹಾಕಿದ್ ಫೈನಲ್ ಆಯ್ತು.
ಹಾಗೆ.
ಇದೇನು ಪ್ರಾಬ್ಲಮ್?
ಇದರಲ್ಲೇ ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಪೇಜ್ 55 ಈ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಪೇಜ್
55.
ಹಾ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರಾದ ಸಂಜೀತ್ ಶೆಟ್ಟಿ ದೂರಿನಲ್ಲಿ ತಿಳಿಸಿದಂತೆ ದೂರು ದಾಖಲಾದ ಬಳಿಕ ನನ್ನ ವ್ಯವಹಾರವನ್ನು ವಿಚಾರ ಮಾಡಿ ಹಾಗೂ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿತರಾದ ಪ್ರಕಾಶ್ ಶೆಟ್ಟಿ ಮತ್ತು ದಿವಾಕರ್ ಶೆಟ್ಟಿರವರ ಕೂಡ ವ್ಯವಹಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಕಾವೂರು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕ್ರಮಶಃ 79/2020 ಕಾಲಂ 326, 392, 506 IPC ರೀತ್ಯ ಈ ಪ್ರಕರಣದ ಫಿರ್ಯಾದಿಯನ್ನು ಆರೋಪಿಯನ್ನಾಗಿಸಿ ದೂರು ದಾಖಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ದೂರಿಗೂ ಈ ಪ್ರಕರಣದಲ್ಲಿನ ದೂರಿಗೂ ಒಂದೇ ವ್ಯವಹಾರದ ವಿಷಯವಾಗಿದ್ದು ಸದರಿ ಪ್ರಕರಣದ ಆರೋಪಿ ಈ ಪ್ರಕರಣದ ಫಿರ್ಯಾದಿಯವರು ತನ್ನ ವ್ಯವಹಾರವನ್ನು ಬಗೆಹರಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. Subject matter is one and the same, my lord.
Yes, sir.
My lords. My lords, on the complaint that has been filed against me, my lords, there is already a B report, my lords. And also kindly look into the wound certificate, my lords. Page 30, my lords. My lords, I was kidnapped, my lords, I was assaulted. And my lords, I had 50,000 amount, my lord, that was also taken from me. 29 is the wound certificate, my lords. 30 is the, it's a legible copy, my lords.
Yes, sir. 323, 504, 506.
Please, please.
Anything else?
Same subject matter, one and the same.
Maybe. ಅದರಲ್ಲೂ ಅಸಾಲ್ಟ್ ಇತ್ತ? ಅದರಲ್ಲೂ ಅಸಾಲ್ಟ್ ಇತ್ತ? ಇಲ್ಲಿದೆ ಅಸಾಲ್ಟ್ ಅಲ್ಲ, ಅದು 406, 420.
420.
ಮತ್ತೆ ಬರೀ 406, 420 ಇದ್ರೆ ಈಗಲೇ ಕಾಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೆ.
420.
This is assault. Yes, anything else? Entry mode ಹೆಂಗೂ ಇಲ್ಲಲ್ಲ, ಏನಾಗಿದೆ ಮೇಡಮ್? ಸ್ಟೇಜ್ 2021 CC.
Verify.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
Hearing before charge.
Hearing before charge. First trial you will get acquitted. ಏನಿಲ್ಲ ಅಂದ್ರೆ. Yes. The petitioner is before this court calling in question proceedings in CC 2663 of 2021 registered for offences punishable under section 323, 504, 506 of the IPC. The petitioners accused number 2 and 3 are brothers of accused number 1. The petitioners register a crime against the present second respondent in crime number 230. The second respondent registers a crime against these accused in crime number 232 of 2020 before 2020 for offences punishable under section 420, 504, 506 and 34 of the IPC. The said proceeding, the police after investigation file a B report. The B report is accepted and the crime is closed on account of the absence of the present complainant. It is the allegation of the petitioner that as a counter blast, the second respondent has registered the subject crime against these petitioners in crime number 79 of 2020 for offences punishable under section 324. Adena? 79 ಅಲ್ಲ?
323.
So and so 324, 392, 506 and 34 of the IPC. The police conduct investigation and have filed a charge sheet against the petitioner. Filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner would vehemently contend that the case which has been closed by acceptance of the B report arises out of the same cause of action, and therefore these proceedings also should be closed on account of the closure of the B report, a closure of the case by acceptance of the B report. He would submit that none of the incidents that that are alleged have happened on the said date. The learned counsel would therefore seek quashment of the entire proceedings pending against these petitioners. The learned counsel for the second respondent, complainant, would contend that the subject matter would have been the same if the complainant was not assaulted and was not assaulted apart from snatching away 50,000 rupees that was in the possession of the complainant. He would take this court through the wound certificate to demonstrate that there were in fact wounds inflicted upon the complainant by the petitioners. I have given my swords. I have given my common phrase. The aforenarrated facts are not in dispute. They are all a matter of record. The complainant did register a crime against complainant Allah. B report nimdalva. The complainant registered a crime against these petitioners in crime number 232 of 2020 for offences punishable under section 420, 504 and 506 of the IPC. The crime was registered on 14/9/2020. The police, after investigation, filed a B report in the said proceeding. The filing of the B report is not contested by the complainant and the proceedings are accepted. The B report is accepted and the learned magistrate closes the proceedings in crime number 232 of 2020. Barely a month after the registration of the crime in crime number 232 of 2020, the complainant registers a complaint against these petitioners on 2/10/2020, now for offences punishable under section 324, 392, 506 and 34 of the IPC. This becomes a crime in crime number 79 of 2020. The police conduct investigation and file a charge sheet against the present petitioners for offences punishable under section 323, 504 and 506. The submission of the learned counsel for the petitioner would have merited complete acceptance, but for the reason that there is an indication of assault by the petitioners upon the complainant. The indication of assault does not spring from thin air, but on investigation and the wound certificate that the complainant has produced before the investigating officer. It is therefore the investigation leads to filing of the charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 22. The wound certificate appended to the petition reads as for the wound certificate appended to the petition in which wounds inflicted are described are as follows. It is no doubt true that the wounds that are inflicted are all simple in nature, but nonetheless, they are wounds. Therefore, the act of the petitioners in indulging in assault on the complainant cannot be brushed aside and the petitioners left off the hook. The petitioner shall face trial and come out clean in a full-blown trial in the light of the assault being prima facie proved by way of the wound certificate or the summary of the charge sheet as the case would be. Petition lacking in merit stands rejected. Like, yes. Rahul, adu extension of parole.
Seek instructions.
Seek instructions. Friday, Thursday tagolala?
Your Lordship?
Thursday tagolala. Thursday 4 p.m.
4 p.m.
Yes,
Much
Thursday 4 p.m. Yes.
C4.
Number 2, my lord, kindly pass over. Senior Bhatta.
ಏನಿದೆ?
Petitioner in this. 498A,
498 ಏನ?
please.
ಹಾ.
Mother-in-law, father-in-law and brother-in-law.
Senior Bhatta.
ಯಾರು ಶ್ರೀನಿವಾಸ? ಪಾಸು ರೀಚ್ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ, 4 ಗಂಟೆ ಆಗೋಗಿದೆ. Next week.
Pre-moderate.
List that will continue.
Please.
List next week. List on 19th. 19th ಬೇಡ, 18th.
18,
22
maybe on
na madam
19th.
ಇದು? 22, then 17, sorry, 16th.
Please.
List on 16th. ಅವತ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ I will answer the petition. Yes. Interim subsisting will continue. Interim order ಎಲ್ಲ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ ಇದ್ರೆ.
For the petitioners in this case, my lords. 447 and 427, my lords. Trespass. Admittedly, there was a civil disputes are pending, my lords.
My lords could kindly
Last occasion,
Pass over at 4 o'clock, what sir?
last occasion I addressed my arguments, my lords, regarding there was an injunction in my favor.
I know, yes.
My lords, a
The
date
trial
could be
court.
given, my lord. A short date.
At the request of the learned counsel appearing for the respondent, again 16th as a last chance.
16th, better, sir. ನಾನು ಇರಲ್ಲ. After that.
23rd.
Much obliged.
23rd as a last chance. Interim order subsisting shall continue to the next date of hearing. Yes.
67 adjourned, 68.
Karumbaya.
The report has not been filed.
What report?
Final report.
You've sought prayer to file a final report, is it?
Yes. Investigation report.
1 minute. Yes, sir. 2/6/2021 is the crime. 3 years agide. We'll quash it on that ground. Carelessness on the part of the IO. Huh?
Take instructions.
Yes. List day after tomorrow in the fresh matters list.
Let's.
Yes.
59.
My lords, I appear for the petitioner. My lords, accused number 1, 2, and 6 have got the stay order, my lords.
Why are you passing chits?
No, my lords, to show the case numbers.
Where are the interim order copies?
Interim copies. I didn't bring them.
You should get, sir.
Next time. Now, interim order is. Bring for the.
You have an interim order in this case.
Yes, my lords.
You have.
We have filed in, no, we don't have. My lords. The connected matters arising out of same PCR, other 3 accused have got the interim order, my lords.
Where is your file?
It's here.
This file.
Yes.
Where is the FIR?
There's no FIR, my lords. We have filed PCR.
All right. What is crime number 8 of 2022?
Yes, my lords. The magistrate has ordered investigation under 56.
So FIR is there.
Yes, my lords.
ಚೀಟಿ ತರದಲ್ಲ ಓದ್ಕೊಂಡ್ಬರ್ಬೇಕು. ಚೀಟಿ ಬೇರೆ ಕಡೆ.
Apologies.
Yes.
All, it may be tagged.
ಕೊಡಿ. Don't repeat that.
Apologies.
Yes. Tag this petition along with so and so. Learned counsel submits qua the other accused. There's an interim order of stay granted by this court. In that light, there shall be an interim order of stay in the case at hand as well. List them all on the 2nd of August.
Grateful.
Yes.
70.
Petitioner is Miller. Section 506, 34, 498A, 504, 114 Miller. ಇದರಲ್ಲಿ
ಎಲ್ಲ ಹೇಳಾಯ್ತು ಆಮೇಲೆ ಹೇಳಿ.
interim application is not at
Interim order not granted.
granted. Far relatives, my lord. They are not distance relative.
Far distance ಎರಡು ಒಂದೇ.
ಅವ್ರಿಗೆ unnecessarily they made him as a part.
Unnecessarily, yes sir.
No, they are not unnecessarily made party.
Necessarily you made. ಆಯ್ತು ಹೇಳಿ. Yes. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
Charge sheet ಆಗಿದೆ. ಆಗಿದೆ.
ಆಗಿದೆ.
ಎಸ್ ತೇಜೇಶ್.
Petitioner ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬೆಂಗಳೂರು ಇದ್ರುನು they are from Tamil Nadu Miller. Almost.
Where is the charge sheet, sir?
Charge sheet
ಹಾಕಿದ್ದೀರಾ?
copy.
20.
It's here. Yes.
And they were resident of, I furnished all Aadhaar card of the two.
Aadhaar card.
ಅವರೆಲ್ಲ resident of Tamil Nadu.
No problem. Yes. Husband is before the court?
Please. Petitioner number 1 is husband. 2 is mother-in-law.
Other, sir, other in-laws. Yes. You take care of the husband. Enough.
Yes.
Yes, sir. The petitioners. are before this court, calling in question the proceedings in CC 7644 of 2021, registered for offences punishable under section 498A, 504, 506, 114, read with 34 of the IPC. Heard so and so. Before embarking upon the consideration of the case on its merit, I deem it appropriate to notice the relationship between the parties. The second respondent is the complainant, the wife of the first petitioner hyphen accused number 1. The yaru mother-in-law.
Third one, third petitioner is Atte Tamma. Petitioner is
Brother of
Tammana
mother-in-law.
Auntie.
Bad, complicate ಮಾಡ್ಬೇಡಿ. Yes. So and so. The second petitioner is the mother-in-law of the second respondent. The third petitioners 3 to 6 are the family members or distant relatives of the accused number 1 husband. The accused number 1 gets married to the complainant on 16/10/2013. It transpires that the relationship between the husband and the wife, i.e. the accused number 1 and the wife, the complainant, turns sour, and on floundering of the relationship, various proceedings emerge. One of the proceedings that emerge is the registration of the impugned complaint against the petitioners for offences punishable as aforequoted. The complaint then becomes a crime in crime number 41 of 2021. The police conduct investigation and file a charge sheet against all the petitioners. Filing of the charge sheet is what has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner submits that the mother-in-law or all other petitioners have nothing to do with the life between the husband and the wife. They were not residing with the couple at any point in time. They had only visited the house on a couple of occasions. And also the allegation again, and the allegation against them is only instigating the accused number 1 to behave in a particular manner. He would submit that the entire proceedings is a farce and it should be quashed. Per contra, the learned counsel appearing for the complainant would vehemently refute the submissions to contend that the police, after investigation, have filed a charge sheet. Therefore, it's for the petitioners to come out clean in a full-blown trial. According to the learned counsel, all the allegations that are made in the complaint are carried over in the charge sheet, and therefore it is a matter of trial. The learned HCGP would also toe the lines of the learned counsel appearing for the complainant in seeking dismissal of the petition. I have given my anxious sons. The aforenarrated facts are not in dispute. The relationship between the parties are as aforequoted. The marriage between the petitioner and the second respondent complainant is a matter of record. The floundering of the relationship is what is averred in the petition or in the complaint, as the case would be. The entire issue is triggered from the registration of the complaint. Therefore, I deem it appropriate to notice the complaint registered by the wife against all the petitioners, the husband and members of the family. The gist of the complaint, as found in clause 10 of the FIR, reads as follows, page 24, marked portion. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows. If the complaint as quoted here and above is read in tandem with the charge sheet, what would unmistakably emerge is hurling of various abuses against, hurling of various allegations against these petitioners which are on the face of it vague. There is no foundation laid in the complaint or in the summary of the charge sheet against the petitioners except the husband. All the grievances are found only against the husband. What is found against these petitioners, against the petitioners except the husband, is instigation to instigation to abuse or torture the wife. This, in the considered view of this court, would not become an ingredient that would be necessary to permit the petitioners to be tried for offense punishable under section 498A, 504 or 506 of the IPC. While finding all the allegations against the husband, if further proceedings are permitted to continue, it would run foul of the judgment of the apex court in the case of Kashkan Kaushar versus so and so state of Bihar. 2022 SSC online SC page 162. Chamber 162. In the light of the facts obtaining in the case at hand and the judgment of the apex court, I deem it appropriate to obliterate the crime against these the proceedings against the petitioners except the husband, failing which it would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, the following order. The criminal petition insofar as the accused number 1, the husband, stands dismissed. Criminal petition insofar as the other accused, so and so far 2 to 5, they are allowed and the proceedings are quashed.
71.
But this matter was heard, my lord, on the last
SPP.
occasion.
I appeal for the rest.
That's the matter. 3-1, an application came to be rejected.
You are for the state, is it?
No. She is for, my lord, the complainant, my lord, the petition. Not 3-1
connected with ಏನು ಇದು?
ಅಲ್ಲ, ಅವ್ರು state ಅವರು ಹಾಕಿದ್ದಾರೆ.
State ಅವ್ರು ಹಾಕಿದಾರ? Why?
Lordships, 319 application was rejected, your lordships.
Oh, 319
The
application.
accused, the son of the accused.
ಏನ್
is
madam ಅದು?
accused number 2.
Some statement ಕೊಡ್ತೀನಿ.
Objections.
ಇಲ್ಲ. Statement was what is
Lordship
recorded
wanted
by
to
the-
know on the last occasion, PW3, whether he is not the independent eyewitness or not the relative eyewitness, my lord.
Oh, 307 is the allegation.
Exactly.
Ah.
That is the case. Lordship wanted to know from the, my lord, the complaints about the.
You are
petition.
accused number?
Lord, I am for the complainant, my lord.
Oh, you have the complaint. Accused number in, kudi madam.
Accused number 2, your lordship, state had filed an application.
That is rejected.
That is,
I'm for proposed.
ನೀವು ಯಾರಿಗೆ madam?
ನಾನು proposed.
Proposed ಇಲ್ಲ, already you were in, ಆಮೇಲೆ okay, you came out.
No. Please.
That's what.
Accused number. Accused.
You are accused number in 2 in the crime. You are dropped in the charge sheet.
ಹೌದು.
Please.
ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದು? Independent eyewitness ಇದರ?
Please, Lord, PW, that is what my lordship wanted to know.
three witnesses, your lordships, PW 1, 2 and 3.
She claims that, my lord, he is the relative of the, my lord, the complainant. So therefore, my lord, she wanted to clarify that whether it's independent eyewitness or not.
PW2 is the brother of the complainant. ಅವರೇ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊಡ್ತಿದ್ದಾರೆ.
PW2.
ಹೌದು ಸ್ವಾಮಿ.
Now on whose evidence are you wanting to be bought inside?
ಯಾರು ಸ್ವಾಮಿ?
ನೀವು ಈಗ 319 application on whose evidence is it?
Evidence of PW 1, 2, 3.
ಅವ್ರು ಹಾಕೊಂಡಿರೋದು.
PW 1, 2, 3 ಹಾಕಿರೋದು. ಅದಕ್ಕೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಐ ವಿಟ್ನೆಸ್ ಯಾರಿದ್ದಾರೆ?
PW3 is the independent eyewitness.
Who is PW3?
PW3 is the person who he was a coolie person.
So 1 and 2 are brothers.
No, my lord, complainant and her brother. One is a complainant, 2 is her brother.
All right.
3 is not.
Everything hinges upon the eyewitness.
Please.
Who is that PW3?
PW3 is not produced at page number, not Krishna. He's a coolie.
Krishna.
How? Page number 31 along with the memo produced.
ಶಿವಲಿಂಗೇಗೌಡ. ಇದೇನ್ ಮೇಡಮ್ ಕೊಟ್ಟಿದ್ ನೀವೀಗ?
ಸ್ವಾಮಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್?
ಸ್ವಾಮಿ
That is PW 1,
1, 2, 3 and 4 ಅವರು
Where is
ಪೊಲೀಸ್ ಮುಂದೆ ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
3 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಪೇಜ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ. ಕಂಪ್ಲೇನೆಂಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ.
This is
Because
complainant.
ಹೌದು ಸ್ವಾಮಿ ಒಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ
ತಲೆಗೆ ತುಂಬಾ ಪೆಟ್ಟು ಬಿದ್ದಿದ್ದು ಗಾಬರಿಯಿಂದ ಕೃಷ್ಣೇಗೌಡರ ಮಗ ಹರೀಶನು ಸಹ ಒಂದು ದೊಣ್ಣೆಯಿಂದ ಹೊಡೆದನು ಎಂದು ಹೇಳಿಕೆ ನೀಡಿದ್ದು ಪೊಲೀಸರು ಆಸ್ಪತ್ರೆಗೆ ಬಂದಾಗ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತೇನೆ ಮತ್ತು ನನ್ನ ಕೃತ್ಯ ಸಮಯದಲ್ಲಿ ಧರಿಸಿದ್ದ ಸೀರೆ ರವಕೆ
ಸ್ವಾಮಿ ಈ ದಿನ ಸುಧಾರಿಸಿ ಪೊಲೀಸರ ಆಸ್ಪತ್ರೆಗೆ ಬಂದಾಗ ಹೇಳಿಕೆ ನೀಡಿದ್ದೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ ಎಲ್ಲೂ ಐ ಆಮ್ ನಾಟ್ ಬೀನ್ ದೇರ್ ಸ್ವಾಮಿ.
ಹರೀಶ್
ಹೌದು ಸ್ವಾಮಿ, ನಾನು ಹರೀಶ್. ಹರೀಶು ಎಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ. DT ಕೃಷ್ಣೇಗೌಡ ಮಾತ್ರ ಇರೋದು, ಅಕ್ಯೂಸ್ಡ್ 1 ಮಾತ್ರ ಇರೋದು.
ಅಂದ್ರೆ ಯುವರ್ ಫಾದರ್
ಮಾತ್ರ ಇರೋದು. ಸ್ಟೇಟ್ಮೆಂಟ್ ನಂಬರ್ 2 ಅಲ್ಲೂ ನೋಡಿ ಸ್ವಾಮಿ, ದೊಣ್ಣೆಯಲ್ಲಿ ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಹೊರತು ಕೃಷ್ಣೇಗೌಡ್ರೆ ದೊಣ್ಣೆ ಮತ್ತೆ ಮಚ್ನಲ್ಲಿ ಹೊಡೆದಿದ್ದಾರೆ, ಬಟ್ ಎಲ್ಲೂ ಹರೀಶನ್ ಹೆಸರು ಇಲ್ಲ ಸ್ವಾಮಿ. 2, 3 and 4 ಯಾರಿದ್ದಾರೆ ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೂ ದೇರ್ ಇಸ್ ನೋ ಐ ಆಮ್ ನಾಟ್ ದೇರ್ ಅಟ್ ಆಲ್ ಸ್ವಾಮಿ. ಐ ಆಮ್ ನಾಟ್ ದೇರ್ ಅಟ್ ದ ಸೀನ್ ಇಟ್ ಸೆಲ್ಫ್. ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ ಹೊರತು ಅವರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ದೊಣ್ಣೆಯಲ್ಲಿ ಅವರೇ ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಡಿ ಟಿ ಕೃಷ್ಣೇಗೌಡನೇ ಹೊಡೆದಿದ್ದಾರೆ ತಲೆ ಪೆಟ್ಟಾಗಿ ಅಂತ ಹೇಳಿ. ದೊಣ್ಣೆ ಮತ್ತೆ ಇವ್ರ ಕ್ಲೇಮ್ ಬಂದ್ಬಿಟ್ಟು ಸ್ವಾಮಿ ನಾನ್ ದೊಣ್ಣೆಲ್ ಹೊಡೆದಿದ್ದೀನಿ ಅಂತ. ಬಟ್ ಎಂಟೈರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ 1, 2, 3 and 4 4 ಜನದಲ್ಲಿ ನಾನು ಇದೀನಿ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಅಟ್ ಆಲ್ ಇನ್ ದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಟು ಶೋ ಹರೀಶ್ ವಾಸ್ ಪ್ರೆಸೆಂಟ್ ಅಂತ. ಬಟ್ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅವರೇ ರೆಕ್ಟಿಫೈ ಮಾಡಿ ಹೇಳ್ತಾರೆ, 2ನೇ ತಾರೀಕು ನನಗೆ ಬಲವಾಗಿ ಪೆಟ್ಟು ಬಿದ್ದಿದ್ರಿಂದ ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಕ್ ಆಗಿರ್ಲಿಲ್ಲ, ಸೊ ಕರೆಕ್ಟ್ ಆಗಿ ಇವತ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡ್ತಿದ್ದೀನಿ, ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
That is complainant himself.
ಹೌದು, ಕಂಪ್ಲೇನೆಂಟ್ ಹಿಮ್ಸೆಲ್ಫ್ ಸ್ವಾಮಿ.
ಮರು ಹೇಳಿಕೆ ನೀಡಿರುತ್ತೇನೆ ಅಂತ.
ಹೌದು ಸ್ವಾಮಿ, 4/7 ಆಮೇಲೆ ಸ್ವಾಮಿ ಒಂದು ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ,
ಹೌದು.
ವಿಚ್ ಇಸ್ ಬೀನ್ ದೇರ್ ಸ್ವಾಮಿ. ದಟ್ ಇಸ್ ಆಕ್ಚುಲಿ ಸಿಂಪಲ್ ಇಂಜುರಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಲೈನ್
ಅಲ್ಲ, this is the wound certificate in the charge sheet also.
ಹಾಸ್ಪಿಟಲ್. ಹೌದು ಸ್ವಾಮಿ, ರತ್ನಮ್ಮ ಯಾರು ಹೋಗಿದ್ದಾರೆ ಕಂಪ್ಲೇನೆಂಟ್ ಅವ್ರದೇ ಸ್ವಾಮಿ ಅದು. ಇಟ್ ಇಸ್ ಬೀನ್ ದೇರ್. ರತ್ನಮ್ಮ ವೈಫ್ ಆಫ್ ಕರ್ಣ ಅಂತಿದೆ, ಅವ್ರದೇ ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ವಿಚ್ ಇಸ್ ಬೀನ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಸ್ವಾಮಿ, which is on page number 5 swami.
Yes sir.
Lord, hear the case, Lord, kindly see Lord, PW3, the evidence, Lord. Lord, 319, Lord, evidence, Lord, is clear. Lord, 161, the father's statement is made. Lord, that is a statement recorded by the police. Lord, that is, she is not the
ಆಯ್ತು,
signatory.
ಈಗ now for 319, what is the evidence before the court?
Lord, kindly see PW3, my Lord, page number 31, along with a memo.
PW3.
He is the independent eyewitness. There is no dispute on that.
What is his statement?
Now, kindly see 31,
Page 31.
please.
Order sheet.
Allah, along with a memo I produced, my Lord. Memo dated 24/1/22.
Thirty-one.
ಹೌದು.
Yes sir.
PW3, my Lord. Krishna,
Krishna.
please, my Lord. My Lord, he is the eyewitness also. ದಿನಾಂಕ 2/7/14 ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆ ನಂತರ ನಾವು ಪ್ರಾಸ 1ರ ಜಮೀನಿಗೆ ಬಿತ್ತನೆ ಮಾಡಲು ಹೋಗಿದ್ದೆವು. ಆಗ ಸದರಿ ತೋಟದಲ್ಲಿ ಜೋಳ ಬಿತ್ತನೆ ಮಾಡುವಾಗ ಆರೋಪಿ
ಅಲ್ಲಿಯೇ ಇದ್ದ ಹರೀಶ
ಹೌದು
ದೊಣ್ಣೆಯಿಂದ ಸೋಣಿಸು
ಹೊಡೆದ. ನಾನು ಮತ್ತು ಶಿವಲಿಂಗೇಗೌಡ ಪ್ರವೀಣ ಅವರನ್ನು ಬಿಡಿಸಿದೆವು. ಆರೋಪಿ ರತ್ನಮ್ಮಳನ್ನು ಸಾಯಿಸಿಬಿಡುವುದಾಗಿ ಅವೇಚ ಶಬ್ದಗಳಿಂದ ಬೈದು ಕಲ್ಲಿನಿಂದ ಬೆದರಿಕೆ ಹಾಕಿದ. ನಂತರ ಆಸ್ಪತ್ರೆಗೆ ಸಾಗಿಸಲು ಆಂಬ್ಯುಲೆನ್ಸ್ ಕರೆಸಿದೆವು. ಚನ್ನರಾಯಪಟ್ಟಣ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ರತ್ನಮ್ಮಗಳನ್ನು ನಾವು ಕರೆದುಕೊಂಡು ಬಂದೆವು. ದೊಣ್ಣೆ ಮಚ್ಚು ಕಲ್ಲು ನೋಡದೆ ಗುರುತಿಸುವೆ. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ನೋಡುತ್ತಿದ್ದು ಅವುಗಳು ಈಗಲೇ ಮಾಮು ಒಂದರಿಂದ.
ಮತ್ತೆ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಿಂಪಲ್ ಇನ್ ನೇಚರ್ ಅಂತ.
ಅಲ್ಲ, ಸಿಂಪಲ್ ಅಲ್ಲ, ಕೈಗೆ ಹೊಡೆದಿದ್ದಾನೆ ಅಂತ ದೊಣ್ಣೆ ಅಂತ. ದಿನಾಂಕ 4/7/14 ನಾನು ಮತ್ತು ರತ್ನಾಕ ಅವರು ತಮ್ಮ ಹರೀಶ್ ಚನ್ನರಾಯಪಟ್ಟಣ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಬಂದೆವು. ಪೊಲೀಸರಲ್ಲಿ ರತ್ನಮ್ಮ ತೆಗೆದುಕೊಂಡು ನೀಲಿ ಬಣ್ಣದ ರಕ್ತ ಹತ್ತಿದ ಸೀರೆ ಮತ್ತು ರವಿಕೆ ಮಾಜರ್ ಮೂಲಕ ಅಮಾನತು ಪಡಿಸಿಕೊಂಡರು. ಮಾಜರ್ ನೋಡುತ್ತಿದ್ದು ನೀಪಿ 2 ಎಂದು ಈಗಲೇ ಗುರುತಿಸಿದೆ. ಸಾಕ್ಷಿ ಸಹಿ ನೀಪಿ 2B ಎಂದು ಗುರುತಿಸಿದೆ. ಸದರಿ ಬಟ್ಟೆಗಳನ್ನು ನೋಡಿದರೆ ಗುರುತಿಸಿವೆ. ಅವುಗಳು ಈಗಲೇ ಮಾಮು 4 ಎಂದು ಗುರುತಿಸಿದೆ. ಈ ಬಗ್ಗೆ ಪೊಲೀಸರ ಮುಂದೆ ನಾನು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ.
hinging upon the evidence of PW3.
Please, last occasion, my lordship, my lord, heard it in detail and wanted to, my lord, clarify whether PW3 is independent eyewitness or not in view of the law declared by the, my lord, apex court in Shankar's case.
Yes, now this page 31 ಅಲ್ಲಿ who is this Krishna according to you?
ಸ್ವಾಮಿ ಅವ್ರ ಐ ವಿಟ್ನೆಸ್.
Eyewitness.
ಬಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವರು ನಾನು ಎಲ್ಲೂ ಇದೀನಿ ಅಂತಿಲ್ಲ. ಐ ಆಮ್ ಬೈ ಪ್ರೊಫೆಷನ್ ಐ ಆಮ್
You're-
ಅಡ್ವೊಕೇಟ್ ಸ್ವಾಮಿ. ಅಲ್ಲಿ
You what are you by profession?
ಐ ಆಮ್ ಅನ್ ಅಡ್ವೊಕೇಟ್ ಸ್ವಾಮಿ. ಐ
You're
ಹ್ಯಾವ್
an
ಸಬ್ಮಿಟೆಡ್.
advocate.
ಹೌದು ಸ್ವಾಮಿ.
ಓ ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿರಿ ಆಫೀಸಲ್ಲಿ.
ಹಾಕಿದೀನಿ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೂಡ ಹಾಕಿದೀನಿ. ಆ ದಿನ ನಾನು ಇರ್ಲೇ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಆ ದಿನ. ಬಟ್ ಅದರಲ್ಲಿ ಎಂಟ್ರಿ ಕೂಡ ಆಗಿದೆ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಇದೆ.
Lordship said, my lord, if his name is found in the, my lord, order sheet, then they could have.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡೋದಿಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲಲ್ಲ, somebody could have been, my lord, my
No,
lord,
this is not fair ಸ್ವಾಮಿ. ಐ ಆಮ್ ನಾಟ್ ಬೀಯಿಂಗ್
It's all
ಅಲ್ಲ.
not about fairness.
ಅಲ್ಲ,
Yes.
ಅವರು ಹೆಸರನ್ನ ಎಲ್ಲೂ ಬರೆಯಲ್ಲ ಸ್ವಾಮಿ. ಯಾವ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರೀತಾರೆ ಸ್ವಾಮಿ, ತೋರಿಸ್ಲಿ ಅವರು.
Lord, if
Let-
she
let it
wants
show
to not
it.
take the plea of alibi, my lord, she has to take, my lord, the lead the evidence before the trial court.
It is not yet in, sir.
Allah, my lord, if,
319
my lord, now, my
application
lord,
is-
she argues that not. in
319
view of-
application is rejected.
Please, my lord, in view of, my lord, she takes, my lord, he was at the different spot, my lord, he was at the court when the incident was taken place. If that is the case, if such a plea is taken before
What
the
is
court.
this man's statement earlier
ಯಾವ್ದು
while investigation this Krishna?
ಸ್ಟೇಟ್ಮೆಂಟ್ ನಾನು
ಈಗ
ಓದ್ತೀನಿ ನೋಡಿ
ಕೊಟ್ರಲ್ಲ
ಸ್ವಾಮಿ.
ತಾನೆ,
ನಾನು
ನೀವೀಗ ಕೊಟ್ರಲ್ಲ,
ಹಾ ಸ್ವಾಮಿ,
ಅದ್ರಲ್ಲಿ
ಅದ್ರಲ್ಲಿ
ಕೃಷ್ಣ
ಇದೆ
ಇಲ್ವಾ?
ನಾನು ಓದ್ತೀನಿ. ನಾನು ಮೇಲ್ಕಂಡ
ಅಲ್ಲ
ವಿಳಾಸದಲ್ಲಿ
ಕೃಷ್ಣ ಇಲ್ವಾ ಅದ್ರಲ್ಲಿ?
ಇದಾರೆ ಸ್ವಾಮಿ, ಇದಾರೆ.
ಪೇಜ್
ಪೇಜ್ 3 ಅಲ್ಲಿ ಇದಾರೆ ನೋಡಿ. ಪೇಜ್ ನಂಬರ್ 4 3 ಅಲ್ಲಿ ಇದಾರೆ. ನಾನು ಕೃಷ್ಣ
yes 3.
ಸ್ವಾಮಿ, ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು 2/7 ಮಧ್ಯಾಹ್ನ 1:01 ಗಂಟೆಯಲ್ಲಿ ದೇವಗಿರಿ ಗ್ರಾಮದಲ್ಲಿ ರತ್ನಮ್ಮರವರ ಮನೆ ಹತ್ತಿರ ಇರುವ ತೆಂಗಿನ ತೋಟದಲ್ಲಿ ನಾನು, ರತ್ನಮ್ಮ ಮತ್ತು ನಮ್ಮ ಗ್ರಾಮದ ಲೇಟ್
ಅಲ್ಲ ಅದ್ ನೋಡಿದೆ.
ಹಾ.
There he doesn't make a mention.
ಹಾ ಸ್ವಾಮಿ,
ನೀವು
ಇವರು
you are
ಜಮೀನನ್ನ
appearing to the
ಮೇಕೆ-
complainant ಅಲ್ವಾ?
Please, my lord.
Look at the complainant statement.
Lord.
161 true, but look at his statement there.
My lord, the further statement, my lord, my lord, there on the base of the further statement, my lord, he has been dropped. No doubt, my lord. In the evidence, my lord, she gives, my lord, categorical statement. That is why, my lord, 319 is there. My lord, my lord, if at all, my lord,
319 get to bring in an accused back
Please.
into the web of proceedings, there should be something more
something more,
than
my
what
lord, more
was
than
found in
prima
the
facie.
investigation.
Lord,
More
I
than
under-
prima facie.
Please, my lord, I
More than
understand.
prima facie, which got him dropped into the proceeding.
Please.
It is verbatim similar. There is no other
Hear the
prima
case,
facie
my lord.
evidence here.
Hear the case, my lord. If this person is not at all there in the FIR or in the complaint.
FIR lila.
Fine, my lord, FIR it is there. She makes the categorical.
FIR he is there, sir. That is
Please,
why
Lord.
319 has come in.
Well, please, my lord. My lord, in the further statement, my lord, that is recorded by the police, my lord. She is not the signature 161. My lord, 161, they can make use of my further statement in the cross examination.
We'll see. Yes.
Lordship,
No, this is, I am not considering a trial here, only whether he should be brought back on
My
319
lord,
or not.
so therefore, my lord, if they say, my lord, some, my lord, kind of, my lord, there is, my lord, some dispute between the, my lord, two families. My lord, as far as PW3 is concerned, he is a, my lord, totally independent eyewitness, my lord. He clearly makes a statement, categorical evidence before the trial court, that he is the person who was there, he hits the, my lord, complainant therein.
Lordship,
When, my lord, such evidence is there, my lord, that cannot be brushed away, my lord, easily.
ಆ ರಾಡಿನಲ್ಲಿ ಹೊಡೆದ್ರು,
ಅಲ್ಲ, ರಾಡ್ ಅಲ್ಲ, ದೊಣ್ಣೆ ಹೊಡೆದ್ರು ಅಂತ.
ಮಚ್ಚಿನಲ್ಲಿ ಹೊಡೆದ್ರು.
ಮಚ್ಚು by, my lord, A1.
ಹಾ ಆಯ್ತು, A1 ಮಚ್ಚಿನಲ್ಲಿ ಹೊಡೆದ್ರು. wound is simple.
But in fact, my lord, seizure is there. There's a bloodstain cloth, my lord, cloth is seized.
there is recovery, your lordship.
There is recovery that I have
Yes,
seen.
recovery of.
Whether he should be brought into the web back or not will answer. Yes. ನಿಮ್ದೇನಾದ್ರು ಇದೆಯಾ madam? Nothing.
Please, your lordship.
Anything else you have to say?
No.
Yes, heard the learned counsel so and so and learned additional SPP, Srimati Rashmi Jadhav. Heard reserved. Interim order subsisting shall continue till the disposal of the petition.
Yes.
Yes.
ಮತ್ತು
ತಗೊಳ್ಳಿ.
Orders number 1, make order.
Office objection only.
ಆಫೀಸ್
Not-
ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲಿ 230 ಮೂವ್ ಮಾಡಿದ್ದಾರೆ, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಹೇಳಿ.
ಇಲ್ಲ ಇದರಲ್ಲಿ the 138 proceedings, my lord, kindly see the ink page number 98, my lord. Ink page number 98.
230 ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
Tomorrow is there, my lord. This case is tomorrow is there, warrant is there, that is the reason.
Warrant is there. Why you have not appeared before the court?
My lord, the summons were not served on the.
Not served.
Not served.
ನಾಳೆ ಅಪಿಯರ್ ಆಗಿ.
ಇಲ್ಲಿ ಒಂದು 98 page number 98, my lord. My lord, kindly see, my lord, this is a check issued by Bluebell Global Shuttles, my lord. This is a partnership firm, my lord. My lord, in the complaint, the
Partnership proprietor.
a partnership firm.
ಹಾ.
Partnership firm,
Global Shelters.
shelters, my lord.
Firm is
The
not a
firm
party.
is not made as a party, no notice issued to the firm.
Hmm.
The magistrate wrongly taken cognizance against the accused, my lord. Accused is only one of the partner in the firm, my lord.
Why you have not appeared before the court?
My lord, no summons were served on.
You
Even
appear
assigned-
tomorrow, I will consider your stay later. Yes, the petitioner has moved this matter on the score that a warrant is issued against him for his continuous absence in the court. According to the learned counsel for the petitioner, no summons was served on him. Since he is aware of the date of the proceeding before the court, i.e. tomorrow, he shall appear before the court, lest this matter day after tomorrow in the fresh matter.
I filed this petition on 1/4/2024. my lord.
ಪರವಾಗಿಲ್ಲ ಸರ್, ತೊಂದರೆ ಇಲ್ಲ. ಈಗ ಬಂದಿರೋದು ಇವತ್ತಲ್ಲ, ಏನ್ ಮಾಡೋದು? ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಪಿಯರ್ ಆಗಿ, ಏನಂತ
ಸರಿ sir.
ಅಪಿಯರ್ ಆಗಿ ಬನ್ನಿ, ನಾಡಿದ್ದು ನಿಮ್ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಸ್ಟೇ ಕೊಡು.
ಸರಿ sir.
ಎಸ್,
Much please.
ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಹಾ ಶಂಕರ್.
138 proceedings, my lord, I have filed a 311 application, my lord. which
Sir,
is kept
learned
in-
counsel with the petitioner to serve on the council represent, ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಅಲ್ಲ 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಂತು, ಇವತ್ತಿಗೆ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect.
Please.
List on next Tuesday in the fresh matters list. Till such time, further proceedings before the concerned court shall remain stayed.
Please.
ವಾರಂಟ್ ಯಾಕೆ ನೀವು ಹೋಗಿಲ್ಲ ಕೋರ್ಟ್?
ಅಲ್ಲ 3 month ಹೋಗಿಲ್ಲ ಕೋರ್ಟಿಗೆ, ಇಪಿ ಹಾಕಿದ್ವಿ.
ನೀವು ಯಾವತ್ತಿದೆ ನೆಕ್ಸ್ಟ್?
ಇವತ್ತಿತ್ತು ಸ್ವಾಮಿ, ಯಾವಾಗ ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಇವತ್ತೇ ಇತ್ತು.
ಕೇಳ್ಕೊಳ್ಳಿ.
ತಿಳ್ಕೊಂಡು.
ಹಾ, ಆಮೇಲೆ ಸ್ಟೇ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ ಬೇಡ.
ನೋ ನೋ,
ಅಲ್ಲಲ್ಲ.
ಯಾಕೆ
Please.
ಅವ್ರಿಗೂ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಹಂಗಾರೆ?
ಅಲ್ಲಲ್ಲ.
ಎಸ್, ಅಲ್ಲಲ್ಲ, ನೀವು ಕೋರ್ಟ್ ಹೋಗಿಲ್ಲ, ಅದಕ್ಕೆ ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಪಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಎಕ್ಸಾಮ್ಷನ್ ಫೈಲ್ ಮಾಡಿ, ಅವ್ರು ಕೋರ್ಟಿಗೆ ಹೋಗಿಲ್ಲ, ನಾನು ಎಕ್ಸಾಮ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಅವ್ರದ್ದು ಹೆಂಗ್ ನಿಮಗೆ ಗೊತ್ತು ಅವ್ರು ಕೋರ್ಟ್ಗೆ ಹೋಗಿಲ್ಲ ಅಂತ ಇದ್ರಿ?
ಅವರು ಸಮನ್ಸೆ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು ಇಪಿ ಫೈಲ್ ಮಾಡಿ.
ಆಯ್ತು, ಎಸ್
ಪ್ಲೀಸ್.
ಟ್ಯೂಸ್ಡೇ ಸೇಮ್ ಆರ್ಡರ್ ಹಂಗೆ ಇರಲಿ. ಅದ್ಯಾಕೆ ನಾಳೆ ಇದೆ ಅಂತ ಅದೊಂದು ನೋಡಿ ಮಾಡಿ. ವಿಜಯ್, ಹಾ,
Petitioner, that the de facto complainant had filed, my lord, a civil suit for recovery against the lawyers, saying that I have paid 9,37,000 rupees towards the fee.
BK Sanjay is a lawyer.
Yes, and kindly, my lord, see page number, my lord, 51. The civil suit was filed saying that I have paid about 9,37,000 rupees money to the lawyers, recover it for me.
Why did you charge so much fee?
My lord, it was on account of, my lord, several lawyers he had paid. In fact, my lord, that is given, my lord, on page number 51.
What happened to the OS?
OS is dismissed, contested and dismissed.
ಈಗ 230 ಯಾಕೆ?
Alla, now, my lord, this thing, the FIR is registered on the same thing. My lord, now the police are calling me. Kindly see, my lord, now.
Police are calling you?
Yes. Please see, my lord, the FIR, the complaint on the same cause of action. After this thing happens in 2015. My lord, he prosecutes the civil court. Civil court case is dismissed. Files, my lord, a complaint with the Bar Council of India. Bar Council of India complaint is stayed by this honorable court. After this, my lord, in 2023, he would go to, my lord, police station and file a complaint.
Oh, you lost the case, is it?
We have not lost. His case is, my lord, he was a surfacey act, my lord, recovery was against them. Comes to me saying that file a suit for partition. We said a suit for partition cannot be filed because the law is settled. All those things will not help you.
Correct ಹೇಳಿದ್ರಾ?
We filed, my lord, suit for injunction. My lord, now that case of surfacey, my lord, he would lose. After that, my lord, the canons are turned at me saying that we had asked you to file a suit for partition. My lawyers have not filed. Therefore, he had filed only injunction suit. Therefore, recovery cannot happen. My lord, he would not have any relief in that surfacey case. Finally, my lord, he would come to us and say that now you held the madilla, agag nam fees vapas kodi. Suit was filed, suit is dismissed on merits. Thereafter, my lord, a complaint against, my lord, the police would straight away register, and after registering, my lord, they would go to the magistrate and say, we want to recover the mobile phones, etc. of the lawyers, please permit. Magistrate also, my lord, straight away permits.
Mobile phones are taken.
Illa, inna adu madilla. We have then, my lord, come before your lordships.
Yes, sir. We'll have it in fresh matters list day after tomorrow.
So great.
Pass a detailed order.
So grateful. So grateful.
Heard the learned senior counsel MS Shyam Sundar appearing for the petitioner. List day after tomorrow in the fresh matters list. ಅಲ್ಲಿವರೆಗೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ ಅಲ್ಲ?
I don't think so, my lord.
Number 4.
If they call, answer the call. ನೀವ್ ಯಾಕೆ ಸರ್ 230?
Tomorrow is for appearance.
Appear.
There is a lawyer, my lord, the issue is this.
ಯಾಕೆ ಲಾಯರ್ ಕೋರ್ಟ್ ತಾನೇ ಹೋಗ್ಬೇಕಾಗಿರೋದು?
He has taken bail, my lord, no issues in the
Then?
appearing. He's, my lord, initially, my lord, he is a lawyer to one Geetanjali estate. His own Geetanjali coffee estate, my lord,
ಗೀತಾಂಜಲಿ ಕಾಫಿ ಎಸ್ಟೇಟ್.
in Chikmagalur, Moodgere.
ಸರಿ.
Where, my lord, this coffee estate consisting of, my lord, 500 acres. Wherein, my lord, adjacent, my lord, one Vasantappa is having 1 acre, 2 guntas of land. He, my lord, started to troubling this Geetanjali estate. Out of that, my lord, some litigations were arose. In those litigations, my lord, the petitioner was the lawyer. He filed one civil suit in
ಈಗ
respect.
2:30 ಯಾಕೆ ಸರ್ ಅರ್ಜೆಂಟ್?
Tomorrow is appearance, my lord,
ವೇರ್ ಸರ್?
in Moodgere.
ನೀವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋ ಜಾಗದಲ್ಲೇ?
No, I'm practicing in Bangalore. He is
Bangalore.
representing some cases in there. Kindly, my lord, the issue is this. On 22/3/2024, my lord, some workers were kind of carrying out some.
354 is the allegations.
Yes, kindly, my lord, I'll complain for a moment. My lord. Kindly, my lord.
ಅಲ್ಲಿ ಎಕ್ಸಾಮಿಷನ್ ಹಾಕೊಳ್ಳಿ.
One second. Page 22, typed copy of the FIR complaint.
Yes.
Wherein, my
Trial
lord,
stage. CC ಆಗಿದೆಯಾ?
CC ಆಗಿದೆ. ಅದರಿಂದ ಅಲ್ಲಿ CC ತೋರಿಸ್ತಾರೆ. ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ ನ ಬಿಟ್ಟಿದ್ದಾರೆ. ಲಾಯರ್ ಒಬ್ಬರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಾರೆ. In all against my lord, they are dropped. The owners and workers, those who are on that day. Kindly my lord, the complaint. Girish, Suresh, Manoj, Prasanna, estate advisor. Against the 4 persons, my lord, in which accused number 4 is petitioner. Later, my lord, charge sheet was filed, my lord, against petitioner alone.
ಅದು, you know the problem. When advocates are there, what they'll do?
Here, nearly, my lord, out of 40 litigations, he is the lawyer against that Vasantappa. He taken revenge, my lord, he knocked.
Who is Shashikala then?
The brother's wife, the respond number 2. The one
Yes, sir.
Vasantappa, who is the landlord, against his copy is served.
ಇಲ್ಲ ಮೂಡ್ ಮ್ಯಾಟ್ರಿಲ್ ಕೊಡ್ಬೇಕು ಅಂತಿಲ್ವಾ?
I'm apologizing.
ನಾಳೆ ಅಪಿಯರ್ ಆಗಿ. Yes,
Will-
you should have given a copy to him.
I'm apologizing, my lord, now it's.
Apology is rejected. Appear before the court tomorrow. We'll take it day after tomorrow. 2:30 ಮೂವ್ ಮಾಡಿದ್ರೆ ಕಾಪಿ ಕೊಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಾನೆ ನಿಮ್ಗೆ?
Instructed, my lord, I'm sorry, my lord.
ಹೊಸ್ದಾಗಿ ಬರ್ತಾ ಇರೋ ಕೋರ್ಟ್ ಮುಂದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು.
I instructed to serve it, my lord.
Yes, copy ತಗೊಳ್ಳಿ. For an advocate to go and appear there is a matter, it's definitely a problem. All right, yes. Learned HCGP is directed to accept notice for the respondent. Emergent notice to the complainant, returnable by the 19th of July. Till such time, further proceedings against the petitioner, sole accused,
Yes,
in CC so and so shall remain stayed.
apologizing, my lord, serve it.
ಇವಾಗ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇದೆಯಾ? ಎಷ್ಟಿದೆ? ಡೆಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಹೌದು ಮೇಡಮ್.
Statement 113. Appear for the
Four
second
28,
respondent.
406. As per memorandum of settlement, the matter is settled between the parties.
I'm for the second respondent, my lord. The
You're now
complaint-
filing ವಕಾಲತ್ or you entered appearance already?
I've already entered.
Sorts. Settlement ಅಂತ ಕೇಳ್ಕೊಳ್ಳಿ, ಕೊಡ್ತಾರೆ. Offense is not relatable to the state, format ಇದೆ. ಜಾಸ್ತಿ ಇದ್ರೆ ಪೆನ್ ಡ್ರೈವ್ ಇಸ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. ಮೇಡಮ್ ಜಾಸ್ತಿ ಇದೆ, ask them to give it in a pen drive. ಅವ್ರು ಪೆನ್ ಡ್ರೈವ್ ಕೊಡ್ತಾರೆ, ಅದರಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಏನಿದೆ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಇದಕ್ಕೆ ಹಾಕ್ಬಿಡಿ. ಹಾಕ್ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಏನಿದೆ ಚೇಂಬರ್ಲಿ ಕೇಳಿ ಹೇಳ್ತಾರೆ. Close ಮಾಡಿ ಅಷ್ಟೇ. Yes, no, this is too much I've written, give a pen drive. ಇದು ಮಾತ್ರ. Yes.
The memorandum of settlement.
ಹಾ, ಸರಿ. Yes.
114, 14 segment.
ಸುದರ್ಶನ್ ಇಲ್ವಾ? ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ. ಲಿಸ್ಟ್ ಆನ್ 12th. ಎರಡೇನಾ? ಅದನ್ನು ಕಂಟಿನ್ಯೂ ಮಾಡಿ
115.
ಮೇಡಮ್. ನಿಮಿಷ. ಎಸ್, ಗವರ್ಮೆಂಟ್ ನಿಮ್ಗೆ ಯಾರು ಗೊತ್ತಿಲ್ಲ ಅನ್ಸುತ್ತೆ, ಇದು ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇತ್ತು. ಅದು ರಿಸರ್ವ್ ಅಂತ ತೋರಿಸ್ಬಿಡಿ ಮೇಡಮ್. ವಿಲ್ ರಿಸರ್ವ್ ಇಟ್. ಎಸ್.
116. 116.
It may not be over today. Yes, madam. We'll take it tomorrow or day after. It won't be over. You will finish in 10 minutes?
In case, now they have to respond, so.
And you will finish in 10 minutes.
My lords, we require some
Very
time.
small issue, my lord. The jurisdiction may be decided thereafter, my lord.
What jurisdiction?
My lord, the issue is with respect to the jurisdiction.
that whether this honorable court has jurisdiction to entertain such an application, which
Oh.
is,
Jurisdiction.
yes, my lord. So then they are supposed to respond to it.
ಆಯ್ತು. ಇವತ್ತಾಗ್ಲಿಕ್ಕಿಲ್ಲ ಸರ್.
Please, any day.
Day after tomorrow I'll take.
Very well.
Yes.
My lord, may kindly fix a time. because
Time ಇಲ್ವಾ ಈಗ?
Today it wasn't fixed, my lord.
Earlier it was fixed, right?
Earlier.
4 PM.
Earlier.
Yes.
Interim order to be extended.
Interim order in the form that it is present shall stand, form that it is subsisting shall continue till the next date of hearing. Day after tomorrow at 4 PM.
Earlier.
ಅದು if you have judgments ಅದು ಕೊಟ್ಬಿಟ್ರೆ ನಾಳೆ ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟು ಫೈಲ್ ಅಲ್ಲಿ ಇದ್ರೆ I'll go through the judgments. You also have some judgments, please give it off.
My lords, I have already supplied the copies.
Some.
All right,
To the court also?
To the court also. my lord. On that date was supplied.
Fine. Day after
Applied,
tomorrow.
170.
Huh.
I appear for the petition. Offense under section 500 IPC.
ಅಲ್ಲ ಯಾಕೆ further hearing ಯಾಕೆ ಬಂತಿದೆ?
Words uttered are in page 24, para 10.
Lord, this is the case, my lord, wherein the allegations, my lord, of the respondent complainant is that one, my lord, reporter called Muhammad Rafiq Mullah has.
You are the reporter?
No,
Ah.
I am the.
You are for the reporter.
No, my lord.
Not
ಅದು
the
ಅಲ್ವಾ?
reporter, I am
ಮತ್ತೆ
not.
yes, ah, yes.
These
Lord,
words
the
were uttered
allegation is
in the presence of Rafiq
presence
Mullah.
of the reporter, Lord, certain utterance has been made.
By
on-
him. By whom?
That is also not clear. By whom also is questionable. It is not forthcoming in the private complaint and the notice. Whether it is a petitioner or someone else. My lord, that utterances, my lord, has been stiltly recorded in mobile phone.
ಓ ಇದು ಲಾಸ್ಟ್ ಇಯರ್
Oh,
ಕೇಳದ್ನಲ್ಲ
yes.
ಅದು?
These were the words uttered in the presence of these following persons.
The accused person making reference to the complainant uttered certain unacceptable words so and so. Told complainant takes money and other than speaking to anyone. Now this has become defamatory.
Yes.
My lord, the alleged utterances, my lord, has been stiltly recorded in mobile phone by the reporter. That, my lord, he has sent to the complainant, respondent. My lord, the alleged incident, my lord, as per the case of the
Oh,
respondent
it is
itself,
it is a fact that you have spoken.
it is not me.
ಅದು whoever has spoken.
How do?
It is recorded.
Mobile phone, electronic evidence.
ಆಯ್ತು.
Mobile phone. My lord, after 45 days
Hmm.
of the alleged incident, Lord, the alleged incident, my lord, happened on 27/8/2019. My lord, the legal notice came to be issued on 10/10/2019.
Hmm.
That is after 1.5 months.
Hmm.
Saying that, my lord, you apologize in writing. Page number 62, annexure C, my lord.
Hmm. Yes.
ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ para 5, my lord.
Hmm.
My client stated that Sri so-and-so visited so-and-so on 27/8/2019 in the premise of the mosque. The said Muhammad Rafiq Mullah met, greeted the two of you. The two of you broached the subject of the TV interview with Sri Mullah in public, making reference to my client. You utter certain unacceptable and defamatory words about my client such as so-and-so, so-and-so.
What was their reply?
Lord, I deny, my lord. I have given the reply also.
You have given the reply.
Please, my lord.
Yes. ಆಮೇಲೆ private complaint.
After 45 days, a notice has been issued asking me apology. And my lord, kindly see, my lord, the own statement of Sri Muhammad Mullah, my lord.
Page.
Before whom, my lord, I am producing this. Take this.
But if what you have spoken is correct, definitely you have lowered the image of.
No, my lord, I have not spoken. According to, my lord,
That's a matter
According
matter
to
of
sworn statement of Muhammad Mullah also, that my lord I have,
But you have so badly spoken.
Allah, that
Becomes a
is,
matter of trial.
Allah, ಅದು ಒಂದು abuse ತರ, ಅದು ಸೈತಾನ್ and
ಅದು ಸೈತಾನ್ಗೆ ನಿಂತಿದ್ರೆ ಸರಿ ಇರೋದು, ಮುಂದೆ ಏನಿದೆ ನೋಡಿ. The most derogatory word according to them.
ಅದೇ ಕಮೀನಾ, ಸೈತಾನ್.
ಅದೇ ಪರವಾಗಿಲ್ಲ.
Those are all.
ಅಲ್ಲ, ಅದ್ ಮಧ್ಯದಲ್ಲಿ ಒಂದಿದೆ, ಅದ್ ಬಿಟ್ಬಿಟ್ರಿ ನೀವು.
So those, my lord, kindly see the sworn statement, my lord, of the
Allah.
person before.
ಎಲ್ಲ ಓಕೆ. ಚಾರ್ ಬಾಪ್ ಕಾ ಔಲಾದ್ ಅಂದ್ರೆ ಏನದು?
ನಾನು ಹೇಳಿದ್ದೀನಿ ಅಂತ, it is not even their case. That the petitioner before my lord has said. It is not, kindly see, my lord, the.
See, yes. What defense do you have? ಕೊಡಿ.
ಅಲ್ಲ, ಇದು sworn statement ಕೊಟ್ಟಿದ್ದೀನಿ. ರಫಿ, ಯಾರ ಮುಂದೆ ನಾನು ಅಟರೆನ್ಸ್ ಮಾಡಿದ್ದೀನೋ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ my lord.
ಏನು?
I never say that I have uttered the utterances.
According to him, who has uttered it?
Well, there is another accused also.
All that is a matter of trial.
Lord, kindly see, my lord.
Another accused is there?
ಹೌದು.
ಇವ್ರು accused number 1, ಇನ್ಯಾರಿದ್ದಾರೆ?
Accused number 2 ಇದ್ದಾರೆ.
There are two accused persons.
All right.
My case is both of them uttered these words.
But one judgment, my
Day
lord.
after, ಕೊಡಿ. Day after tomorrow at 4 PM will dictate.
Please.
Prima facie.
ಅಲ್ಲ, ಇದು ಎರಡು judgment I am producing.
ಕೊಡಿ. We'll consider all
ಇದು.
that. Yes. What's the problem?
Previous matter, judgment ಬೇಕು ಅಂದ್ರಲ್ಲ, ನಾನು ಕಾಪಿ
Already ಇದೆಯಾ?
given to
My lord, interim order has to be extended.
That will be extended. List day after tomorrow at 4 PM. Interim order subsisting shall continue till the next date of hearing. Yes.
Grateful.
Madam, ಇದು ಫೈಲ್ ಇಡಿ. ಫೈಲ್ ಕಳಿಸ್ಬಿಡಿ.
118.
petition.
My lord, I am not feeling well.
You want time?
Yes. Kindly give 4 weeks time.
One week's time?
4 weeks.
4 weeks time, yes. The learned, the respondent in person seeks 4 weeks time. List the matter, interim order, yeah? List the matter after 4 weeks. Interim order subsisting shall continue till the next date of.
190. Here for the petitioner. Your Lordships had directed me to file a synopsis. We are seeking further investigation in this matter.
Yes,
List of discrepancies that.
all the lacunae in the investigation.
Yes, yes.
Yes. ಇದೇನು UDR ಅಂತ ಕೊಟ್ಟಿದ್ದಾರಾ?
No, your lordship. 302 ಗೆ register ಆಗತ್ತೆ. Deceased and accused are adjacent coffee planters. So our plantation ವಿಷಯದಲ್ಲಿ they always had some or the other problem. On 10A
So
2009,
302 register ಆಗಿ, then what is it done?
trial is on.
Trial
Witnesses
is
have-
on.
Yes, your lordship.
Hmm.
But as per the investigation, now there is a clear collusion between the accused and the investigating officer.
Hmm.
Accused number 1 and 2 are husband and wife.
Hmm.
Accused number 1 shot the deceased with a double barrel gun, which was, the shot was heard by the brother of the complainant and the father-in-law of the complainant. And then they were also seen removing the body from the place where he was actually dead and bringing it in front of their house. They left the body there and absconded from there. So after which a recovery was effected. Recovery agiddu double barrel gun, which was the house of the accused number 1 was broke open. Other in that double barrel gun and 5 cartridges were recovered. 5 cartridges, nearly 4 were live, is what the Panchanama says. 1 was allegedly used for firing anta heltare, your lordship. Now, when the first charge sheet was filed, the FSL report was still pending. And then when the subsequently the additional charge sheet was filed, FSL report arrived and the FSL report, I filed the charge sheet, your lordship, additional charge. Sir,
No, why are you seeking further
further
investigation?
investigation, the reason being, your lordship, A2 was very much present with the husband.
A2 is now given up?
She's not given up,
Huh.
but during the trial, the defense that they are taking is that she was not at the spot. Alibi ತಗೊಳ್ತಾ ಇದ್ದಾರೆ. Power dump was secured at the time of investigation, but that till date has not been produced before the court. And in the charge sheet is shown that it is pending. And the ballistic report clearly says that the cartridges that were sent for FSL were all live cartridges. None of them were used. So the projectile remove agittu anta heli clear agide FSL report nalli. Prosecution has filed the charge sheet, Your Lordship.
Let me see this. You have a copy of this now?
I mean, my lords, your lordship, this court had directed me to please the report.
Kodi. Adu kodi.
I went through the entire report. It looks like the police is also not inclined to give a crystal clear opinion as to what the allegations are. Reason is, they simply,
You are for the complainant.
no, I am for the state prosecutor.
Oh,
Special
state,
prosecutor.
sorry.
Yeah, I am the special prosecutor. The points that has been raised in
Then we
reference
should
to,
permit further investigation if need arises.
it has to be done, my lord.
We'll see.
My lords, may I just make a submission? As early as 2023, this issue of this cartridge was brought to the knowledge of the investigating officer. As a special public prosecutor, I marked a letter to the Superintendent of Police.
Hmm.
They
You
never bothered to look into it. And number two,
Sure. Huh.
number two,
Yes.
coming to certain data that has been retrieved data,
Hmm.
they are in possession of it. And the complainant has made a petition to the Superintendent of Police. They have lost the petition itself. And the report which was directed, placed, with great respect, I propose to point out, except the investigation is done, they have not even superficially touched upon either admitting, denying, or disputing this particular.
Who is the
contention.
IVO?
4, 5 IOs are there, I mean, over a period of time.
ಎಲ್ಲ ಚಿಕ್ಕಮಂಗ್ಳೂರ್ದ?
ಹೌದು ಸರ್. ಅಲ್ಲ, ಈಗ ನಾನು ಒಂದು ಸಬ್ಮಿಷನ್ ಸರ್. This is a total recklessness of the police. That's what I just proposed to employ. An affidavit to be filed by this respondent 1 and 2, because the report asked by this court, they never make mention about anything about it. I'm given to understand, and I've been notified with a memo mentioning all the lapses and the illegalities committed. Rather, that would be the right word. Let the superintendent of police and the respondent to the inspector, let them file an affidavit before them. A 10 days time may be granted for them with a direction in meeting the contents of this particular writ petition and also the memo.
No, if I find there is illegality, in what they have, I will also go through it.
Please.
While ordering further investigation, we will order departmental inquiry against them.
They have to be notified.
If I may point
They
out
will,
page
after
number.
notifying them.
ಅಲ್ಲಲ್ಲ
Your
ಅಲ್ಲ
Lordship,
notify ಅಂದ್ರೆ ನಾನು immediately after I being notified, I even contacted them. They said, yes, you appear. Then when I asked them to instruct me,
ಅಲ್ಲ, will answer.
Lordship, page number 47 in the petition, the additional charge sheet, ನಿವೇದನೆ.
ಹ್ಮ್.
He clearly says, 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಗಳ ಮೊಬೈಲ್ ಬಾಬ್ತು IPDR ಸೆಲ್ ID ವಿಳಾಸ ಮತ್ತು ಅದರ ಬಾಬ್ತು ಏರ್ಟೆಲ್ ಕಂಪನಿ ಬೆಂಗಳೂರವರಿಂದ ವರದಿ ಬರಲು ಬಾಕಿ ಇರುತ್ತದೆ.
ಅದೇನ್ ಬಂದಿದ್ಯಾ ಆಮೇಲೆ?
ಇನ್ನ ಬಂದು.
FSL is not yet come?
No.
FSL,
But no, tower dump location.
ಇಲ್ಲ ಟವರ್ ಲೊಕೇಶನ್ ಬಂದಿದೆ. I'm sorry.
ಬಂದಿದ್ಯಾ?
CDR has come, sir. CDR has.
No, I'm sorry. I'll make a small.
ದಾಖಲೆಗಳು ಮತ್ತು
Tower dump location ಬಂದಿದೆ.
ಹಾ.
Unfortunately, to connect the accused 1 and 2, they were strongly obligated to seize the mobile phones of accused 1 and 2. ಅದನ್ನೇ ಸೀಸ್ ಮಾಡ್ದಾನೆ. ತಾಳಿಲೆಯಿಂದಾನೆ ಮದುವೆ ಹೇಗೆ ಮಾಡುದು ಸ್ವಾಮಿ? I am totally handicapped as a special prosecutor. N number of letters and
ಬೇರೆ
petitions.
illustration ಕೊಡ್ಬೇಕಾಗಿದೆ. ಇರ್ಲಿ. ಯಾಕಂದ್ರೆ ಅದಾಗತ್ತೆ.
ನಾನು ಬಹಳ ಹೆಲ್ಪ್ಲೆಸ್ ಆಗಿದ್ದೀನಿ ಸ್ವಾಮಿ. I like to fairly concede this. If your lordship would kindly direct this respondent 1 and 2, because the report what was been directed by
Let's
this
see,
court.
let me go through the illegalities that she has placed on record. It's exhaustive.
The IO may be directed to give an explanation. but it's an
List on Thursday, same at 4 PM. We will direct what is to be done on that day.
Fourth.
Fourth.
Oblige.
Yes. Let's continue. ಅಂದ್ರೆ ಕರೆದು ಬಿಡಿ. ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್, ಯಾವ್ದು ಯಾವತ್ತು ಕಮ್ಮಿ ಇದೆ, ಯಾವತ್ತೂ ಇಲ್ಲ. ಸ್ಟೇ ಇರೋದೆಲ್ಲ. ಎಸ್, ಪೇಜ್ ವೈಸ್ ಕರೆಕ್ಟ್. ಎಲ್ಲಿಗೆ ಬಂದಿದ್ದೀವಿ? ಹಸು 2 ಇದೆ.
Password matter?
ಪಾಸ್ವರ್ಡ್ ಯಾಕಾಗಿದ್ದು? ತಾಹಿರ್. ಹಾ.
Things, my lord.
Huh?
Two things, my lord.
Yes, sir.
The court remanded back to the judicial custody because he was obtained from the custody. Therefore, court has remanded back. And he was placed to the prison at 10:40 in the night. Therefore, they didn't release him because to release him, they need to have a superintendent. We were not present. It only up to 7 PM or 7:30 PM according to rule. Therefore, they have not done it. First thing in the morning, they have done it. In fact, my lord, that if you wanted to arrest, on 28 also you could have arrested because accused number 3 given a statement on 28th itself. So there's nothing that we prevented, we facilitated for him to take into custody. That's one, my lord. Second, with respect to grounds of arrest, I've looked into, my lord, your lordship may see section 50 of CRPC.
Judgment, sir.
Judgment, my lord, deals with the two legislation, PMLA and UAPA.
Whatever.
In PMLA and UAPA, there is the statute mandates that the grounds of arrest has to be
Supreme
given.
Court says whether statute mandates or not, it should be given.
No, the requirement, my lord, that
Then 50 has the same language, lordship, my lord.
no, 60 is not the same language.
50, kindly have section, kindly see
And
section
what is
50.
required to be given, my lord, we have given him. It's not that we have not
Yes.
given him.
Same language, it has been extracted also there. The relevant portions is the provisions are in judgment, lordship. Kindly see section 50. Person arrested to be informed of ground of arrest and right to bail. Every police officer, other persons arresting any person without warrant shall forthwith communicate to him the full particulars of the offence for which he is arrested or other
Where is
or
the arrest memo given to him, sir?
I'll place it.
ground for such arrest.
And also intimation to his relatives, madam. And I've been also told, my lord, he is not cooperated, is admitted to hospital.
Hospital is not well.
He is in police custody. He is taken to the government hospital. Even lordship in the order sheet, same day when he was taken to the court, that day he made a submission. Court has also passed the order. He is supposed to take it to Jaydev hospital if need arises. Then he was subjected to the government hospital. Government hospital sent him to Jaydev hospital.
The previous page, my lord, is the intimation about the arrest. Previous page.
No, that is 29th on the same day.
Yes, my lord. No, previous, see, what is.
Previous in 29/6/2024, 8:30.
That's correct.
8:30 is
Yes,
given.
yes. The issue, my lord, section 50, my lord, your lordship may see section 50 at once. Every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other ground of such arrest.
When such communication should be given?
It is when we are arresting. That's the only time, my lord, we can give. When
That
we are
is true. It's not that ಮುಂಚೆ ಕೊಟ್ಟು notice ಅಲ್ಲ ಇದು.
Oh, it is not a 41-year notice.
I know, that's what.
And this judgment which you are relying on, my lord, is deals with the section 19 of PMLA.
Yes.
Which mandates the inform him on grounds of such arrest.
ಇಲ್ಲೂ ಅಷ್ಟೇ ಅದೇ ಇರೋದು.
ಇಲ್ಲ, ಅದಿಲ್ಲ. Section 19 of PMLA, my lord, in fact, the judgment extract in para 16, my lord. Same judgment, my lord, para 16, it extracts the section 19.
16.
Para 16, my lord, lordship got
43B.
Yes,
probably
that
page
is
number 13, para 16, my lord. If SEC page.
43A. Power to arrest. No, PMLA and UAPA both
Yes,
are
my lord,
extracted.
same page, it's same page. Your lordship may see 19, power of arrest. If a director, your lordship got it?
Yes.
Your director, a deputy director, assistant director, or other officer authorized on behalf of the central government by general or special order, as on the basis of material in his possession, reason to believe. Now, two things, my lord, reason to believe. The reason for such belief to be recorded in writing that any person has been guilty of an offence punishment of this act, he may arrest such person and shall as soon as he may inform him the grounds of such arrest. So it is under statute makes it mandate. Section 50 doesn't make that the grounds of arrest to be mandated. It only says reason for the offences in which he is being arrested.
Full particulars of the offence for
yes.
which he is arrested.
Yes, that is what we had given in the notice to him and to the his relatives.
Yes, sir.
Kindly. Section 50, every police officer or other police officer arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds for such arrest. This is the language here in section 50. Then section 50A, Lordship. Obligation of persons making arrest to inform about the arrest to the nominated person. Every police officer or other person making any arrest under code shall forthwith give the information giving such arrest and a place of where the arrest person is being held, any of the friends or relatives of such person as may be disclosed and nominated. Now, Lordship, kindly see the definition given in 43A. Power. Any officer, 43A, this is UAP, Lordship. Any officer of
UAP, it's there
designated
in the
authority,
judgment.
in
Yes.
judgment, Lordship. Designated authority empowered in the behalf by general or special order of central government and state government as the case may be, knowing of a design to commit any offense under this act or has a reason to believe from personal knowledge or information given by any person and taken in writing that any person has committed an offense punishable under this act or from a document, article or any such other things may furnish evidence of the commission of such offense or from any illegal acquired property or any document or other articles which may furnish evidence of holding any illegal acquired property which is liable for seize or freezing or forfeiture under this act chapter is kept or concealed in any building, conveyance or the place, may authorize any officer subordinate to him to arrest such a person or such buildings, conveyance or place, whether or by day or by night, or himself arrest such a person or such building, conveyance or place. Procedure of arrest, seizure. Any officer arresting a person under 43A shall as soon as be informed him the ground of such arrest.
Yes.
This is the ground of such arrest. Lordship, here the wording is what same wording has been used
Where in CRPC?
in 50, CRPC. Where is arrested? Other grounds of such arrest. Other ground for such arrest. Now, Lordship, kindly appreciate there is a and section 40, para 40, you see, Lordship, in this judgment.
Yes.
Page number 20, Lordship. The learned ASG argues the copy of the remand application forwarded over WhatsApp to the learned counsel for the accused. Appellant gives a complete picture about the ground of arrest. We feel that any comment on the content of the remand application and whether the same actually conveyed intelligibly ground of arrest to the accused or whether the same has to be so vague it would be impossible to understand may prejudice the trial of the case. We may, however, briefly mention the ground of arrest as conveyed to the accuser more or less the narration of the facts picked up from the FIR, which itself does not indicate any particular incident or event which gave rise to the alleged offense. However, the law is well settled that FIR is not a exculpatory, it is registered just a set to process of criminal justice in motion. The investigation officer has a power to investigate the matter and collect all the relevant material which would form the basis of filing of charge sheet in the court concerned.
Now, what is the ground on which we can interfere against a remand application?
Lordship, in respect of remand application, Lordship, the copy of the remand application was not served to make
That
a
in
proper.
Supreme Court says it need not be served.
Lordship, in this case, Lordship, in this case also, in the Jimmy Jiggar case also, Lordship,
Yes.
para number 48.
There is some doubt about the remand application.
In fact, your lordship has to look in the criminal rules of practice, my lord, that remand
These
application. I
all
say, my
are
lord,
in earlier position of law when no document should be served to any of the accused person till the investigation is over. Now that all position has been settled down by the judgment of Jimmy Jiggar and this judgment, Lordship.
Yes.
This judgment also clear speaks about the remand. Remand application has to be served. Opportunity may be given to defend the remand, Lordship. In this also police remand was there.
We'll see. Yes.
Page number.
I'll take it tomorrow.
Yes.
Yes.
Lordship, and one more just document I
Kodi.
want to place before this one.
No, if the Supreme Court says remand application also has to be given.
It is there, Lordship. And these are the photos, Lordship.
he has now obtained the copy of remand. He is-
No.
At the time of
Future,
But
when
your
you,
lordship can lay down something, my lord, but unfortunately, the presently, my lord, criminal.
but
rules of
how do you
practice-
get over the 47 orders? First you tell me.
I have communicated, my lord, that we have not placed all these orders, my lord, as passed on a noting saying that he is.
Then
the-
how can I say that?
Lordship, application is
Sir,
there.
we are
Lordship.
not-
My application is there before the court. I argued everything in the remand application.
All those
In
matters.
the trial court, I pointed out.
Illalla,
everything.
idralalla. The
And earlier-
coordinate bench
earlier.
orders.
No, we are arguing in a matter, my lord, that where we are saying that we are not prosecuting him as a director, as a company holder, but we are prosecuting him as a person who is
Anyway,
responsible.
this I will lay down, remand and arrest
Yes.
both.
But these are the photos which they have seized. These all photos.
Gold.
91 gram, they have gold seized. Is police
ಜಾಸ್ತಿ
officer.
seize ಮಾಡಿ ಏನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ,
It's not that seizing. What they do, they force us to give alternative gold. It is not the actual gold. 10 gram gold, they seek 91 gram. They see all this gold they have seized. and they made us to purchase from the local shop, which is their own shop, where they had managed it.
Lordship,
This
may
is
see
the,
voluntary
this is the gold, Lordship, which
Your
they have
Lordship-
seized.
Your Lordship, see voluntary statement.
And
of
all
the
these
accused.
things, Lordship, and the CCTV, let them put the CCTV of the station.
That he will produce. They have
CCTV,
tomorrow
ಅವ್-
produce.
ಅವ್ರೇ
all
ಕೊಡ್ತಾ ಇಲ್ಲ.
transcripts.
Huh?
ಅವರೇ ಕೊಡ್ತಾ ಇಲ್ಲ.
I don't know, that is, this all recording is there with me.
Let
This
him
on
produce
pen drive is
CCTV,
there.
my lord.
This,
Pen drive.
not this video. Lordship, this aspect is recorded in a video, that photo I am producing, then in support of this, the entire incident has been recorded. My Lordship, I don't want to go into the so deep that where I will be in trouble, he will be in trouble.
That
See,
is
this is the conduct of the police. For that reason, he want to arrest. It is not that they want to recover. If they want to recover, it is sufficient to arrest accused number 3. They didn't do that. They wanted to extract more than that, whatever.
Accused
Exactly.
number 3 is in custody.
He's in custody. He's in custody.
ಮಾಡೋದೆಲ್ಲ ಅಪರಾಧ ಇವರು ಪಾಪ ಅವ್ರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಆಕ್ಚುಲಿ.
No, he is a manager. He can inform that from where he had given.
Your Lordship,
6 months.
read this remand application of, voluntary statement of this fellow. He says, in fact, I got the video also. It's sent it to me in WhatsApp, my lord. It's unfortunate
Let
that,
them
you know,
produce it. Let them produce it. I will, we have nothing.
Yeah, if both the things I see, then yes, we'll mark all the skeletons from the cupboard. Yes. ಬೇಡ ನಿಮ್ಮ ಹತ್ರನೇ ಇರ್ಲಿ.
Lordship,
Photo-
what is,
ಪೆನ್ ಡ್ರೈವ್ ನಿಮ್ಮ ಹತ್ರನೇ ಇರ್ಲಿ.
Lordship, what is, what we require, Lordship, see, what we are requesting this honorable court is,
ನೀವು ಅವ್ರ
we are,
hospital ಇದ್ದಾರೆ.
as a company, we had given several representation that we are ready to for all kind of investigation. But in the name of investigation, they should not trouble.
Even now he will cooperate.
But
Now he is
actually-
in the hospital.
We have asked for a CCTV from this thing. Let him give the CCTV, my lord.
ಕೊಡಿ.
Let him
They
give the
had
CCTV.
given it, Lordship, every case wherever they had shown a notice,
Let him-
hundreds notice we replied. Everything has been there. I will present all 47 cases where they had notice on shelf. I have not only provided the sale and purchase detail, we have provided CCTV also to them.
No. ಒಂದು, and you are not prosecuting him as a director or invest, whatever. Now you have changed your stance. But what happens to all that?
We will have to look back, my lord. We'll have to see something. We will have to do. In fact, my lord, I've asked, how did that order also last time your lordship passed an order? I've been told, my lord, that order was passed, end of the list has been moved, and the copies have not been given to us. And in
ಯಾವ್ದ್ರಲ್ಲಿ end of
ಮೊನ್ನೆ
ಯಾವ್ದ್ರಲ್ಲಿ
last-
end of the
ಇದೇ
list?
ಇದ್ರಲ್ಲಿ.
Lordship, my learned friend
Talking
make
of
again
just- one
making
minute,
some submission.
1 minute. I am talking of Justice Hemant Chandan Gowda's orders, sir. Orders of the coordinate bench I am
ಅಲ್ಲ,
talking of.
ಮೊನ್ನೆ ಇದ್ರದ್ದು ತಮ್ಮ ಆರ್ಡರ್ನ
ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಲ್ಲ ನಾವು. ಕಾಪಿ ಕೊಟ್ಟಿರ್ಲಿಲ್ವಾ ಇಲ್ಲಿ?
ಆಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕಾಪಿ ಕೊಟ್ಟು.
Lordship, we had given in the morning, even when copy was not there.
I asked him to seek instructions and come and then I passed that order. ಅದಲ್ವಾ?
ಅದಲ್ಲ.
ಸರ್ ಇರ್ಲಿ ಬಿಡಿ ನೋಡಿ. That has passed by.
They are just making such summation to just to derogate my image, Lordship.
No,
We had
no,
given
no, don't worry
it,
about all that. Your image, nothing will happen.
no copy is not, so I have taken an order behind them, their back. You mean, to say-
Don't worry about all that. Yes, even copy is not served, I have granted. So what?
ಅಲ್ಲಲ್ಲ. The only thing is to say that he could inform us and we will take a proper instruction, and then even this matter, my lord, yesterday, accidentally I came to, because I have dealt with a similar issue in another matter where habeas corpus was my learned friend filed an habeas corpus.
No, I would have, we would have quashed all these things because identical matters anta.
Correct, but ನಮಗೆ he filed an habeas corpus in one of the matter, and I believe habeas corpus he withdraw. Only that connection, when IO came to me and discussed with me and said, sir, this is what is happening, what to do. That is the only reason I came to know about this case. Otherwise, I would
No,
not have.
I will not come in the way of any investigation in accordance with law, nor he will come in.
Yes.
He will come in the way. He will cooperate with the investigation. But in that garb, ಇವೆಲ್ಲ ಯಾಕೆ ಮಾಡು? You ask him to cooperate, whatever he wants, he will give.
Even I can place the 64 notices issued to him. My lord, tomorrow I'll place that. In fact,
charge sheet is filed in that case. My learned friend again making one. Charge sheet is filed in that case.
ಆಯ್ತು, ಈಗ ನೀವು whatever crime is registered, you
I
cooperate.
will get the copy also, that one.
You cooperate with the investigation.
Which my learned friend is retired Chief Justice, charge sheet is already filed. Director has approached and he was.
All right, charge sheet is filed. That may not, don't worry about all that. In this crime, what is registered, you cooperate with the
Certainly we are
investigation.
cooperating, Lordship. Already out of 10 grams, they already taken 90 grams. What more?
What have
What
you
else
seized?
is required?
What have you seized, ಅದೆಲ್ಲ ಕೊಡಿ. The amount of seizure or whatever it is. Now anyway, he's in the hospital. Let him be there. Safe place.
Tomorrow it's getting up, the police custody get over. They may take him to and say.
No, let him be in the hospital till day after tomorrow. We'll pass orders day after tomorrow.
God bless.
ಆಗ್ಬೋದು.
ಕೆಲವರಿಗೆ jail is a safe place, ಕೆಲವರಿಗೆ hospital is a safe place. Yes.
The custody ends tomorrow, my lord, but we'll have to mention it to the court and remand them.
Because tomorrow I think I have a bench. If I'm sitting after the bench is over, we'll definitely list this and pass. All of very bench. ಮುಂದೆ
Otherwise,
ಬರ್ಬೇಕಾದ್ರೆ you can
otherwise,
take-
what
They
we
can
do, my
make,
lord,
they
we'll
can
ask-
intimate the court. It's
No, we
because
will,
of the-
we will.
No, then I'll post it tomorrow. If there is no sitting of mine, Justice Sanjay Gowda ಅವ್ರ ಮುಂದೆ ಬರುತ್ತೆ. If that is okay, then I'll.
Alla,
send
we
it.
will, no, my lord, I'll suggest, my lord, that there will be remand application will be moved before trial court, seeking him to remand to judicial custody, but anyway, he's in hospital, he'll continue to be in hospital.
ಅಷ್ಟ್ ಮಾಡ್ಲಿ. I'll pass orders day after tomorrow. We'll list it day after tomorrow at
Yeah.
4 PM.
We will, tomorrow we'll seek for judicial.
Whatever.
judicial custody.
Yes. Let him continue to be in the hospital. Yes. Then heart problem, huh?
For such persons, hearts are very weak.
Such things heart weak ಆಗುತ್ತೆ. Yes.
But actually, it's not that he is made up. At the
All
time of
right.
remand itself, they
Day
have
after
mentioned it. That is also recorded in order sheets.
See, CCTV is produced will definitely create a problem. Yes.
No, Lordship, let them produce it. We don't have any difficulty. I am sure that no statement was given.
All right. Yes.
Your lordship may pass us some order, my lord, that.
Ah,
take
yes, I
place
will pass an
because-
order,
because
yes.
Tomorrow,
The council for the matter is heard at length. List the matter day after tomorrow at 4 PM for further hearing. The learned additional SPP is directed to place on record the complete details about the seizure that is made from the alleged seizure of 91 grams that is made pursuant to the registration of the crime, which was for the purpose of recovery of 10 grams of gold. The learned counsel for the petitioner submits that the petitioner is now in judicial custody.
Police
No, it's a police
In
custody.
police custody, and due to his illness is in the hospital,
Jayadeva.
admitted at Jaydeva Hospital. Therefore, the petitioner shall continue to be in the hospital. Needful be done accordingly by the prosecution till I pass an order on so and so date.
we will not be able to produce before the magistrate tomorrow. Your lordship may consider his dispense with production tomorrow.
ನಾಳೆಗ?
Nale.
The
Magistrate may consider.
the production of the petitioner in the light of the aforesaid circumstance before the learned magistrate is dispensed with till day after tomorrow.
Yes.
Subject to further orders that would be passed by this court. Yes. Yes, see, get ಕರೀರಿ ಮೇಡಮ್, page wise. ನೀನು ಪಾಸ್ವರ್ಡ್ ಇದೆಯಾ?
Page 10, 72 to 77.
Serial number.
One.
Serial number 72.
1 minute. Wherever interim orders are there, they will be listed after 2 weeks on a particular date. So interim orders will be extended. Please don't make a mention. Disposal will do by and by. All right?
Serial number.
Interim orders ಇರೋರು ಯಾರು ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ.
Serial number 72.
ನಿಮ್ದು interim order ಇಲ್ವಾ?
Ilvas. So both 72 matter, my lord. Maybe have it in tomorrow or day after.
Prasanna Kumar.
Yes, but it is a trap case where the covered by decision of this court only, my lord.
72 Friday ಹಾಕಿ.
Serial number.
Interim order ಇನ್ ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ, ಅದ್ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ.
104.
ಎಲ್ಲರೂ ಹೇಳ್ಬೇಡಿ. One by one. Page wise I am calling, please mention page wise.
Serial number 76, my lord.
76 and 77.
77 ಇಲ್ಲ ಸ್ವಾಮಿ ಇದು.
77?
He's in custody since 16 years. ಅದು premature release ಗೆ ಒಂದಿದೆ ಅದು.
1 minute. ಅದೇ ಯಾಕೆ ಇಲ್ಲಿ ಬಂತು ಮತ್ತೆ? Premature release ಗೆ ಇಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ. He was caught in another crime, my lord. He was convicted for life imprisonment. So one more crime will be registered against him.
77.
Some date may fix and moreover some time may be fixed.
76, madam.
Again, it will be deported.
Appear for the petitioner.
ಯಾವತ್ತು ಹಾಕ್ಬೋದು? 16th. 5 ಇದೆ ಅಷ್ಟೇ. 16th.
The 16th, ಅಲ್ಲ, because next Independence Day ಇದೆ, because premature ಇದಾಗಲಿಲ್ಲ ಅಂದ್ರೆ again you have to wait for another.
Independence Day August 15th, sir. ನಾನು July 15th ಹೇಳಿದ್ದೆ.
ಬೋರ್ಡ್ ಅಷ್ಟಲ್ಲಿ ಬೋರ್ಡ್ ಆಗುತ್ತೆ.
ಬೋರ್ಡ್ ಯಾವಾಗ ಆಗುತ್ತೆ?
ಆಲ್ರೆಡಿ ಬೋರ್ಡ್ ಆಗ್ತಿದೆ.
ಬೋರ್ಡ್ ಯಾವಾಗ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗುತ್ತೆ? When is the board meeting? Just check up. Yes.
Because 16 years custody in custody. Since 16 years in custody.
We'll post it on 16th.
Sir, 16 ತುಂಬಾ ಇದಾವೆ.
16th, sir. ಇನ್ನೊಂದು ವಾರನೇ ಇಲ್ಲ, wait. Yes.
Please.
16th. Wherever interim orders are not there, they will all come on 16th.
79, my lord, serial number.
Interim order ilva?
ಇಲ್ಲ, ಸ್ವಾಮಿ.
16th.
This is covered by lordship
16th.
judgment.
All on 16th.
Fresh matter list ಮಾಡಿದ್ರೆ time 79.
All on 16th, interim orders ಯಾವ್ದಿಲ್ಲ ಅದನ್ನ ಎಲ್ಲ
29
fresh
may be
matters ಎಲ್ಲ
listed in fresh
in the
matter.
fresh matters only. Yes.
ಸೀರಿಯಲ್ ನಂಬರ್
Notice
74
ಆಗಿದೆ.
ಇಂಟೀರಿಯರ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ ವೆಕೇಟಿಂಗ್ ಈಗ ಹಾಕೊಂಡಿದ್ದೀನಿ ಅದನ್ನ next.
Vacating ಇವತ್ತು 70,
4.
74 vacating stay.
I-
List on next Tuesday in the, under the caption vacating of interim orders, the interlocutory application. Yes. Next Tuesday.
Number 100, my lords. It's there are trial.
ಒಂದು ನಿಮಿಷ, page wise.
Page,
ಹಾ.
page 12, 85 to 91.
Serial number 80, my lord, 80.
ಇದರಲ್ಲಿ interim order ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ?
80, my lord.
89 interim order ಇಲ್ವಾ? ನೋಟಿಸ್ ಆಗಿದೆಯಲ್ಲ?
87, my lord.
16th. ಹಾಗಾದ್ರೆ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ ಮಾಡಿ.
Lordship, serial number,
9th.
serial number 70,
Anand.
90, 90.
Wait, if you are on the VC, have patience.
Yes, your lordship.
87
87, my lord, 3 weeks.
interim order ಇದೆಯಾ?
Lordships out of 21.
Tuesday.
30 petitions allowed. First the proceedings.
ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ ಮಾಡಿ. ಈ ಬರೋ ಟ್ಯೂಸ್ಡೇ. Yes.
My lord, on the third, my lord, third are four. All are being.
Third is today, sir.
Yep.
9th, yes.
My lord, serial number 80,
80?
my lord.
ಒಟ್ಟಿಗೆ ಹೇಳ್ಬೇಡಿ ಅಲ್ಲ. Yes. ಈ ಪೇಜಲ್ಲಿ ಮಾತ್ರ ಹೇಳಿ. 88 ಏನು? ಆಯ್ತು. Then post it on
My
16th.
lord, serial number 80, my lord.
Wait. Page, ಆ ಪೇಜಲ್ಲಿ ಇದ್ರೆ
My
ಮಾತ್ರ.
lord, 80, my lord.
Which one, sir? I have not yet come to that. Wait. Yes.
My lord, serial number 80, my lord. which is the
81
same
ಏನು?
page.
85 mark. Serial number 85. Implement ಆಗಿದೆ ಸ್ವಾಮಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
81 ಏನು, sir? Somebody made a mention of 81, what?
My lord, could I mention
ಮಾಡಿ.
80, my lord? My lord, 80, my lord.
85 ಮಾಡ್ಲಾ?
My lord, serial number 80, my lord, heard it day before yesterday, my lord, the pay you matter, my lord.
So what?
My lord, there is no interim order insofar as 2 of the petitions are concerned.
Interim order ಯಾವ್ದಿಲ್ಲ, ಅದೆಲ್ಲ 16th ಹಾಕಿ.
Serial number 85.
Interim order ಇಲ್ವಾ?
Only one petitioner interim order for the other 2 petitions. There is no
No
interim order.
problem.
My
Let
lord,
it
could
come
it
up
be in the
to-
fresh matters, my lord, because
No,
the
no,
state
no,
had to file,
nothing,
my lord,
nothing.
the.
Interim order ಇರೋದು ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ.
85 ಮಾಡ್ಲಾ?
83, my lord.
ವಾಹ್, ಒಂದೊಂದೇ ಕರೆದು ಬಿಡಿ ಮೇಡಮ್. ಎಸ್. ವಾಟ್ chaos, sir. ಬೆಳಿಗ್ಗೆನೂ chaos, ಸಾಯಂಕಾಲನೂ chaos. 79,
79, my lord.
16th, yes.
Fresh matters ಅಲ್ಲಿ.
Wait, sir. 80? After 2 weeks. Yes, 2 weeks. Interim order 2 weeks.
83, my lord.
83 interim order
No
ಇದೆಯಾ?
interim order, my lord. And also the council on record is ASPP now. My name may be recorded instead.
ಯಾವ್ದು petition? ಜಗದೀಶ್
Jagdish
BN.
BN.
ಇಲ್ಲೇ ಇದಾರಲ್ಲ? Yes.
my lord. I see.
Registry to delete the name of Jagdish BN as appearing for the petition and print the name of,
Urmila Pullat, my lord.
yes, so and so. List on 16th. 84. 16th, yes. 85.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 80 ಗೆ ಅಕ್ವಿಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರಾ?
ಅಕ್ವಿಟ್ ಆಗಿದೆ ಸರ್. 138 ಅಲ್ಲಿ ಅಕ್ವಿಟ್ ಆಗಿದೆ.
ಸರಿ. ನೀವು petitioner ಈಗ?
ನಮ್ಮ ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
Learned counsel for the petitioner submits that the petitioners have been acquitted of the offences. Therefore, the petition is rendered infructuous, disposed as having become infructuous. 85 ತಾನೆ?
85 ಮಾಡಿ.
ಹಾ, ಸರ್.
8 to 8 ಇಂದ 9 ವರೆಗೂ ಹಾಕಿದ್ವಿ.
Split up, split up.
Split charge? Whatever, yes. Next.
ಅಲ್ಲ 138 ಅಲ್ಲ ಸ್ಮೈಲ್ 138 ಅಲ್ಲಿ ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಜಾಯಿಂಟ್ ಏನೋ ಅಲಿಗೇಷನ್ ಇದ್ರು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಅಂತ ಅವರೇ
16th ಹಾಕಿ ಮೇಡಮ್, ಏನು ಮಾಡ್ಬೇಡಿ. Yes, next.
ಅಯ್ಯೋ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್
Interim order ಇದೆಯಾ? List after 2 weeks. Yes, next.
87.
87 ಏನು?
Number 90.
Interim
I'm
order.
appearing for the petitioners. I'm appearing
Yes,
for the
list on
petitioners.
16th,
The
yes.
Your lordship, there is no interim order and
16th.
most of the petitioners are senior citizens. Your lordship, an early date may be given. This is a third hearing, the matter has not come up for hearing, at least on the 9th, your lordship.
9th.
For most of the
yes.
petitioners are senior citizen. It's senior
All right.
citizen, your lordship, and interims.
9th, madam. Yes. 91? 2 weeks, yes. You moved for vacating stay. list on 9th in under the caption interlocutory application. No problem, sir. 9th, 9th, sir. Yes,
92, my lord, there is no interim order, my lord.
no interim order. 16th, yes, 16th.
Covered by judgment, covered by judgment.
Monday in the fresh matters list. Yes, next. 93. Again, next Wednesday under the caption vacating stay. 94, 2 weeks. This is vacating stay, madam, 94. 10th vacating stay, yes.
For the petitioner, my lord.
List after 2 weeks, yes.
May I request on 9th or 10th?
Interim, stay application ilvalla alli.
Is stay application illa, but
Six.
passport visa bitte.
Pass, 9th, yes.
96.
16th, yes. 16th, sir. ಕೆಲವು 9th ಕೆಲವು 16th ಹಾಕ್ತೇನೆ, yes.
97.
ಇದು ಇಲ್ವಾ 16th,
98.
16th,
99.
16th.
100.
100 is, maybe on 11th, my lord. 12th is the trial court matter.
I appear for the respondent in this matter.
There is no interim order in this matter.
There is no.
9th,
9th.
yes.
Great.
101.
2 weeks. ಅತ್ತಾಳಿ ಒಂದು ನಿಮಿಷ ಅವ್ರು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದಾರಂತೆ. ನಾಟ್ ಟುಮಾರೋ ಬೆಂಚ್ ಇದೆ ಮೇಡಮ್, ನಾ ಇಲ್ಲ. ಡೇ ಆಫ್ ಟುಮಾರೋ, ಎಸ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ. ಟೈಮ್ ನೋ ಮೇಡಮ್, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇಟ್ ವಿಲ್ ಕಮ್ ಅಂಡರ್ ದ ಕ್ಯಾಪ್ಷನ್ ಇಂಟರ್ಲೋಕ್ಯುಟರಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕಿ ಮೇಡಮ್. ಇದು ತುಂಬಾ ದಿವಸ ಬರ್ತಾ ಇದೆ, ಎಸ್ ಎಸ್. ಯಾವುದು ಇಂಟರ್ ಮಾಡ್ರಿ ಇಲ್ವಾ? ಎಲ್ಲ ಅಷ್ಟು ಗವರ್ಮೆಂಟ್ ಟೀಚರ್. ಸೊ ವಾಟ್, ಏನ್ ಪೊಕ್ಸೋನಾ ಮತ್ತೆ? ಸರಿ ಆಯ್ತು. 9th, ಎಸ್.
My lord,
Two-
ಇದರಲ್ಲಿ
103 ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 3 weeks.
ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದೀವಿ ಮೈ ಲಾರ್ಡ್.
ಇದೆ, ಎಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ, ಎಸ್.
Lordship,
4 ನೋ ಇಂಟ್ರಿ ಮಾಡರ್.
no interim order. 9th, Lordship.
ಪರವಾಗಿಲ್ಲ ಮೇಡಮ್, ಎಸ್.
Lordship, on
ಮೊನ್ನೆ ಅದು ಮಾಡಿದ್ದೀನಿ ಮೇಡಮ್, ಅದರಲ್ಲೂ ಇಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೊನ್ನೆ. ನೀವು ಇರೋದೇ ಇಲ್ಲ ಕೋರ್ಟಲ್ಲಿ, ನೀವು ಇಲ್ದೇ ಇದ್ದಾಗ ಇಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
I request on 9th, Lordship. 104.
104
On 9th, Lordship.
9th 104 9th ಎಷ್ಟಾಗಿದೆ ಮೇಡಮ್? ನನ್ನ ಹತ್ರ ಇದೆಯಾ? 9th ತುಂಬಾ ಇದೆ, ಮತ್ತೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ನಿಮ್ದು ರಿಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಮಾಂತೇಶ್.
Not 5. Not 4, Lordship.
Huh?
104.
104 16th 2 weeks. ಯಾವ್ದು ನಿಮ್ದು ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ? ಮತ್ತೆ ವೇಟ್, ಎಸ್. ಫಸ್ಟ್ 2 weeks ಲೆಟ್ ಮಿ ರೆಗ್ಯುಲೇಟ್ ದಿಸ್ ನಾನ್ ಇಂಟ್ರಿ ಮಾಡರ್ಸ್.
106 ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಆಲ್ರೆಡಿ 3 times ಬಂದಿದೆ.
9th,
ಪ್ಲೀಸ್
yes.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
16th
9th
ಏನು offense?
3 times 420 ಹಸ್ಬೆಂಡ್ FD ವಿಡ್ರಾ ಮಾಡಿದಕ್ಕೆ ವೈಫ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್.
9th, yes.
They've already got anticipated bail and are not furnishing the specimen.
It's all right. You are the husband, no?
I'm the aggrieved.
Huh?
I am the husband.
Husband against the wife FD withdrawal.
After forging myself.
Forging your signature.
After 1 year they filed a complaint. ಅದು
We'll answer it.
498 ವಿಡ್ರಾ ಇದು ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ
9th, don't worry, yes.
on fresh matter please.
Fresh matters,
Great.
yes.
107 ಅಲ್ಲಿ ಒಂದು FIR ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್
2 weeks.
130 ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
ಏನಾರು ಆಗಿದೆ?
ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಜಾಬ್ ಜಡ್ಜ್ಮೆಂಟ್ 6ನೇ ತಾರೀಕಿದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಅಲ್ವಾ?
ಅದ್ರ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇಲ್ಲ.
ಹಾ,
ಅದರಿಂದ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ 6ನೇ ತಾರೀಕಿದೆ.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ಏನು?
ಅದೊಂದು ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಒಂದು ರೀಕಾಲಿಂಗ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಅವರು ಪಿಟಿಷನರ್ಸ್.
ಏನ್ ಪರವಾಗಿಲ್ಲ, ಎಸ್. ಒಂದ್ರಲ್ಲಿದ್ರೆ ಸಾಕು. ನೆಕ್ಸ್ಟ್
ಅದು ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ಡ್.
ನೋ ಸರ್, ಎಸ್, ಆಫ್ಟರ್ 2 weeks. 16th, yes. 16th. B group NMAS 2 weeks.
Lord, in that vacating stay ಹಾಕಿದ್ದಾರೆ.
Vacating stay ಇದೆಯಾ?
For the respondents only.
They have filed for
Vacating stay ಅಂದ್ರೆ 10th ಬೇಡ, 17th is a holiday. 18th ಹಾಕಿ ಮೇಡಮ್.
Published.
Yes.
the entry mode may be extended.
Okay.
I'm sorry.
111
111, I am for the petitioner, my lords.
ಎಲ್ಲ 2 weeks ಹಾಕಿ.
There is no stay, my lords.
No stay.
Stay ಇಲ್ಲ. Urgency ಇದೆ, my lords.
Date may be.
ಯಾವ್ದು 7 ಏನಾಯ್ತು?
111.
12th ಹಾಕಿರಿ ಮೇಡಮ್. ಎಸ್ 112 ಎಂಟರ್ ಮಾಡಿದ್ಯಾ? ಇದ್ರೆ 2 weeks, ಇಲ್ಲದೆ ಇದ್ರೆ 16th. ಎಸ್
Interim order may be uploaded.
Huh?
Interim order may be uploaded in end of the list.
ಯಾವುದು? ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಇತ್ತಲ್ಲ ಮೇಡಮ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ, ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಏನೋ ಕೇಳಿದ್ರು, ಅದನ್ನ ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಡಿ. ರೆಡಿ ಇದೆ ಕೊಟ್ಟು.
Lord sir, serial number 77, 2 weeks ತುಂಬಾ ದೂರ ಆಗೋಯ್ತು. Because he may seek NOC, I think.
Who will seek NOC?
Petitioner might seek NOC.
ಅದೆಲ್ಲ ಕನ್ಸಿಡರೇಷನ್ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳಿದ್ರೆ that is how you should know how to handle your client.
He's in custody.
Court should tell you how to handle your client also.
Yes.
ಅದ್ರ ಮೇಲೆ ಈಗ you go and complain and then do things. ಎಲ್ಲ NOC ತಗೊಂಡೋಗ್ಬಿಡ್ತಾರೆ ಪಾರ್ಟ್. You should know how to handle your client, sir.
Handling my lords, because
Then
he's in the custody, ಅದೇ ಮೇನ್ ಅಷ್ಟೇ.
ಕಸ್ಟಡಿ ಇದೆ.
16 years he's in custody.
ಕಸ್ಟಡಿ ಇದ್ರೆ ಕೊಡಿ ಏನು.
ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ
Upload as in Delhi.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಇದ್ಯಾವ್ದು ಮತ್ತೆ ಇದು? 4 ಆಯ್ತು ಮಾಡ್ತಾ ಇರ್ತವೆ. 4 ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
It is
ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
Upload.
ಎಸ್
77 my lords.
ಮೇಡಮ್ ಅದೇನು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಇಲ್ಲ, ಅಪ್ಲೋಡ್ ಒಂದು ಮಾಡ್ಬೇಕು ಅಷ್ಟು ಮಾಡಿ.
ಅದೊಂದು 77 my lords.
77 ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಹೇಳಿ?
ಅದೇ some date may be fixed and short date ಅಲ್ಲಿ ಒಂದು time may be fixed. 16 years is in custody my lord. Touch is in custody 16 years.
Since
16 years.
you are seeking premature release.
Not premature release my lord. He was convicted for life imprisonment for 302. So after life imprisonment he will commit another offense. Because in that offense,
whether they should run concurrently or not.
Not concurrently. Because of that case premature release ಆಗ್ತಾ ಇಲ್ಲ. In
What happened to that case?
that case life imprisonment ಆಯ್ತು 302 ನಲ್ಲಿ.
ಅಲ್ಲಪ್ಪ ಏನಾಗಿದೆ ಆ ಕೇಸ್? ಇನ್ನೊಂದು
ಅದ್ರಲ್ಲಿ ಬೇಲ್ ತಗೊಂಡ್ರು. ಇದರಲ್ಲಿ ಡಕಾಯಿತಿ ಕಮ್ ಇದರಲ್ಲಿ ಇವ್ರ ರೋಲ್ ಏನಂತ ಹೇಳಿದ್ರೆ ಇಫ್ ಯು ಗಿವ್ 2 lakhs inside, so 5,000 ಕಮಿಷನ್ಗೋಸ್ಕರ ಯು ವಿಲ್ ಡೂ ದಟ್ ಅಫೆನ್ಸ್.
ಆಯ್ತು.
So neither of the sections will attract him.
Friday 77.
Please. Serial number ET also will put a date.
But your counsel should know how to handle your clients. That doesn't mean NOC ತಗೊಂಡೋಗ್ಬಿಡ್ತಾರೆ ಸರ್ ತಗೊಳ್ಳಿ ಮೆಮೊನ ಅಂತ. That is not the issue. That's not the way.
Please.
You should handle the client.
Serial number ET, my lord, it heard the matter and the last one was listed, my lord.
Interim order ಇದೆಯಲ್ಲ ಸರ್.
My lord, there's interim order only against the first petition, my lord.
Pay you.
Pay you, my lord.
I told you, you pay.
My lord,
Yes.
could a date be given, my lord? If not 16, 23rd, my lord, if a date, 23rd, could a date be given? Madam. ಆಪಾಗಲ್ಲ ಇದು. ಎಂಟ್ರಿ ಆಗ್ಬಿಡ್ತು